All right. Good morning, everyone. Welcome to the Judicial Proceedings Committee. Today is Friday, February 16th, 2024. We have 13 bills on the docket. I see Senator Lamb's here. We're going to start off with Senator Lamb just really quickly with Senate Bill 590. Then we'll go to Senate Bill 488, the Vice Chair's bill. We'll move on to 632, 619, 624, 643, 550, 630, 644, 663, 664, 665, and 538, Senator Wallstreicher. So without further delay, Senator Lamb, welcome back. The floor is yours.
Thank you. Sounds like you have a long day.
You're welcome to hang out with us.
I'll pass. But let me call up members of my panel for this bill, Senate Bill 590. We have Jonathan Smith from the Civil Rights Division at the Office of the Attorney General. It's good to see our Attorney General here. Didn't mean to jump ahead of you. This bill should be short. We also have Camila Reynolds Dominguez from Free State, and I think there's another person signed up who's also favorable, so we can bring him up too. Ken Phelps.
Yes, Ken Phelps Jr.
May or may not be here, but we can keep going. So good afternoon, good morning, Chair Smith and Vice Chair Wallstreicher. Fell into the habit of afternoon hearings. And members of the Judicial Proceedings Committee. For the record, Senator Clarence Lamb, District 12, here to present Senate Bill 590, the Equal Opportunities for All Marylanders Act. This legislation, while it may seem complex, is actually very straightforward, and there is an important need for it. For context, last summer, the Supreme Court of Maryland reached an extremely concerning decision in Doe versus Catholic Relief Services. The court found that because sexual orientation was not specifically enumerated in Maryland's Equal Pay Act, that while sex and gender identity, those two terms were, the General Assembly did not intend to extend protections from discrimination in pay by implication. That while the terms sex and gender identity were protected under the Equal Pay Act, they believe that it did not include sexual orientation in their interpretation. So specifically, the court stated that the General Assembly's practice, to quote them, the General Assembly's practice, as we understand it, has been to specifically identify categories it intends to protect in anti-discrimination statutes, end quote. So this has broad implications. Many of our anti-discrimination statutes do not contain an exhaustive list of groups that they intend to protect. If we are to take the court at their word, which we must, then in order for Marylanders of any race, sex, sexual orientation, gender identity, disability, or religion to be protected under our laws, our statutes need to be as comprehensive as possible. SB 590 standardizes Maryland's anti-discrimination statutes by ensuring that they are inclusive of protected classes. And without this legislation, marginalized Marylanders are even more vulnerable to discrimination in a variety of areas, from lending to healthcare to housing. It's critical that we safeguard their rights by implementing a comprehensive solution, which this bill does. There's a chart attached in my written testimony that overviews each section of the law addressed by the bill. With that, I'm happy to turn over to other members of the panel and take any questions at the end. Thank you.
Good morning, Chair, members of the committee. My name is Jonathan Smith. I'm the Chief of the Civil Rights Division in the Office of the Maryland Attorney General, and I'm pleased to be here, and thank you for permitting me to testify. Maryland has had a long and robust tradition of protecting civil rights and enacting laws to protect civil rights. SB 590 will fill two gaps that were created in the law by the Doe decision. As the senator said, this is a pretty straightforward bill, and may not even take the 2 minutes that you've allotted for me to discuss it. The Doe decision unsettled what was long understood law with regard to what the term sex meant in the anti-discrimination laws of the state of Maryland. You saw throughout the last 2 decades people applying sexual orientation to sex through government action, through the kind of enforcement actions that were being taken. And when the Doe decision came down, that was a surprise and a change in the understanding of what the underlying law was, and a need for this legislation to correct that. In addition, the statute will make sure that throughout the code that there is uniformity in the definition of the protected categories. So there are places throughout the code in which race or disability, sexual orientation, religious belief are not mentioned in the protected categories. What this bill does is to make sure that for every time in which there's a anti-discrimination protection that's embedded in Maryland law, that the same protected categories, and to create uniformity in with regard to which protected categories will be covered by the law and what people's expectations can be about our anti-discrimination provisions. We believe that this is an important correction and will make the laws more effective in terms of our ability to enforce them and to ensure that people can enjoy all of the equal rights and the ability to participate in society and the economy and in the basic aspects of living. So with that, we urge a favorable report. Thank you.
Good morning. My name is Camila Reynolds Dominguez, and I'm from Free State Justice. This past August, the Maryland Supreme Court issued its ruling in John Doe v. CRS, weakening statutory protections afforded to Marylanders under every state anti-discrimination clause. The court said the General Assembly's practice, as we understand it, has been to specifically identify the categories it intends to protect in anti-discrimination statutes. So, if a protected category of individual is not specifically enumerated in a given clause, that omitted category does not get the protections of the clause, even if they are protected elsewhere. This ruling is applicable to every single protected category currently enumerated anywhere in state law and to all anti-discrimination language proposed in future sessions. We conducted a survey of anti-discrimination clauses and found that the enumerations of protected classes are extremely inconsistent, not just for sex, sexual orientation, and gender identity, but also disability, religious belief, and race, among others. Under John Doe v. CRS, these inconsistencies mean that there are now significant holes in the anti-discrimination framework within state law. We are calling on the General Assembly to take swift and comprehensive action to rectify this far-reaching decision. Marylanders are currently without legal protections for many forms of discrimination, leaving them exposed to serious harms with no state-level legal recourse. The burden of this discrimination will fall on the most marginalized, who we know have the fewest resources to respond. Absent a comprehensive response, any other current or future piecemeal attempts to remedy Doe will only perpetuate the problem of patchwork anti-discrimination language that the decision created. Without SB 590, all 6 million Marylanders' legal shield from discrimination will continue to have significant holes in it. The General Assembly must ensure that all people in every protected category are not subject to discrimination based on their protected characteristics in any contexts. This act attempts to do just that, and we urge the committee to give it a favorable report. Thank you.
All right, excellent. Thank you very much, Senator. Questions for the panel? Seeing none, thank you very much. All right. All right, that looks like that's the end. So that'll conclude the hearing for Senate Bill 590. We'll now move on to the Vice Chair with Senate Bill 488. And I see our Attorney General is here. And Mr. Vice Chair, whoever else you'd like to bring up on this sponsor panel.
Well, thank you, Mr. Chairman, members of the committee. In 2005, Congress passed a law called PLCAA. In essence, PLCAA did two things. First, PLCAA provided complete legal immunity to the gun industry in federal courts. Second, PLCAA provided complete legal immunity to the gun industry in state courts unless the states pass a law saying otherwise. SB 488, the Gun Industry Accountability Act of 2024, is Maryland saying otherwise. Let's pause there for a second to linger on how strange and unique PLCAA is. Under federal law, the firearm industry is the only industry in the nation's history to receive complete immunity from lawsuits. The tobacco industry, key to the early slave economy and manufacture of a product once used by 42% of Americans, never received immunity from lawsuits. The pharmaceutical industry never received immunity from lawsuits. The auto industry, so critical to our American manufacturing base, never received immunity from lawsuits. And so Senate Bill 488 isn't a significant change in policy. It simply places one industry in the same position as every other industry. It means that the gun industry is similarly situated to the tobacco industry or the pharmaceutical industry or the auto industry. And will this unleash a torrent of lawsuits against the gun industry? We know the answer is that it will not. How do we know? Because SB 488 simply places us in the status quo ante. Think of the year you were born. Now measure the time between that year and 2005, the year PLCAA was passed. Were there constant lawsuits against the gun industry during those years? There weren't. And that's exactly the world, that's exactly what the world will look like after we pass SB 488. The only industry players that need to worry after their immunity is lifted are bad actors. In the tobacco industry, some manufacturers publicly stated that their product was not addictive, destroyed documents that said otherwise, and purposely marketed to children. Those bad actors were subject to our tort system. In the pharmaceutical industry, Purdue, the manufacturer of OxyContin, hid the addictiveness of their product, sold their product to doctors who they knew were running pill mills, and lacked reasonable controls to prevent their pills from ending up in the illicit market. Purdue was a bad actor and subject to our tort system. In the auto industry, in the 1970s, Ford made a car called the Pinto, in which the gas tank was in the rear. When struck from behind, the Pintos were at risk of exploding, and some did. In an internal memo, Ford indicated that they knew of the risk of the explosion, but declined to install an $11 part that would prevent it. Ford was a bad actor and subject to our tort system. It might surprise you to learn that I do not believe that most gun industry players are bad actors. But if you knowingly market guns to children, you are a bad actor. If you knowingly sell your product to a dealer that is selling to straw purchasers, you are a bad actor. If you knowingly fail to exercise institutional controls such that your product ends up in the hands of criminals, you are a bad actor. If you're a good actor in the industry, you have nothing to worry about. But because there are bad actors in every industry, we need to pass SB 488. Now, let me take a moment to anticipate some of the questions you may have, as well as address some of what you're going to hear from the opponents of the bill. Number one, PLCAA does not allow this bill. That is false. In fact, PLCAA specifically anticipates that states may pass laws lifting gun immunity. In the legalese of PLCAA, this is called a predicate exception. In other words, the federal government can change the default when it comes to state immunity, but it cannot control it. PLCAA specifically allows for a state change. 8 states have already done so. Number two, this law was struck down in New Jersey. That is false. First of all, our draft is based on Delaware's law, not New Jersey's. The opponents sued to overturn the Delaware law, and that lawsuit was quickly dismissed. As for the New Jersey law, there was indeed a temporary preliminary ruling against it. That ruling was quickly and summarily overturned by the Third Circuit. The New Jersey law is currently in full effect. So are the laws of the 7 other states. Number 3, reasonableness is a vague or subjective standard. This is false. There's a lot of discussion about this last year. So let me be clear. The entire American tort system is based on the concept of reasonableness. Reasonableness is never defined subjectively. It is always defined objectively. There are hundreds of years of precedent on this issue in the United States and hundreds of years of precedent before that from Britain. Firearms existed for the entirety of that time. Objective reasonableness is at the core of civil justice. Plaintiffs' attorneys are intimately familiar with the concept of reasonableness. Defense attorneys are intimately familiar with the concept of reasonableness. Federal and state judges are intimately familiar with the concept of reasonableness. Tobacco industry lawyers, pharmaceutical industry lawyers, auto industry lawyers, and yes, firearm industry lawyers all are familiar with the concept of reasonableness. Number 4, the gun industry is already highly regulated. This is true. The gun industry is absolutely highly regulated, but the point is not a relevant one. The tobacco industry is one of the most highly regulated industries in our country. They are subject to tort action. The pharmaceutical industry is one of the most highly regulated industries in our country. They are subject to tort action. The auto industry is one of the most highly regulated industries in our country. They are subject to tort action. There are already criminal laws against selling to straw purchasers. FFLs are subject to both ATF and state police regulation and can lose their licenses for failing to account for every gun purchase. This is absolutely true. But there were already laws against marketing cigarettes to children. There were already laws against selling to pill mills. The criminal law system, the administrative regulatory system, and the tort system all work in concert to create incentives for good behavior. Let me be clear. Opponents' argument that they are already subject to 2 legs of the 3-legged stool is an argument for this bill, not an argument against it. Number 5, the analogies we have used today are off point because they aren't constitutional rights. Gun ownership is a constitutional right. Gun ownership is definitely a constitutional right, but as a whole, this statement is false. Constitutional rights are regularly subject to the same reasonableness standard we've been discussing today. The First Amendment is a perfect example. The Supreme Court has regularly held that the First Amendment activities are subject to reasonable time, place, and manner restrictions. Holding a rally at 3 a.m. in a residential neighborhood is unreasonable. Holding a rally in the Senate chamber is unreasonable. Holding a rally above a certain amplification level is unreasonable. Constitutional rights are reasonably circumscribed each and every day. Number 6, the bill would allow someone to sue a firearm manufacturer for the intervening harm caused by a third-party illegal gun owner. This is false. This bill would not allow lawsuits against a manufacturer or FFL simply because someone is harmed with a gun. The bill requires a specific nexus between the harm and the party being sued. There is a mens rea requirement. In order to be successfully held liable, the bad act must have been done knowingly. Again, this is the same standard we use in the auto industry. When folks get in crashes, they sometimes sue each other. They almost never sue the auto manufacturer. The exception here is the Pinto example, where there was a specific nexus between Ford's knowing action and the fiery death of the woman who was rear-ended. Number 7, this bill expands standing so that anybody can sue, even if they weren't harmed. This is false. There are only 2 people who can sue under the bill. First, the Office of the Attorney General on behalf of the people of Maryland. This is exactly what happened in the tobacco and opioid cases, and we'll hear from the Attorney General in a moment. Second, a victim of gun violence or their heirs. That's it. Only 2 people. It's right there in the bill in black and white. 8th and finally, what about this hypo or that hypo? And I appreciate that sometimes this committee works through issues using hypotheticals, and I usually try to answer those questions in good faith. But this is not a bill for hypos. Hypos are inherently reductivist and fail to take into consideration facts and context that occur in everyday real life. On the other hand, plaintiffs' attorneys, defense attorneys, industry attorneys, and judges are highly experienced at briefing, arguing, dismissing, and ruling upon highly contextual fact patterns. That's exactly why we need this bill, to allow our civil justice system to do what it already does each and every day for every other American industry. Let me conclude with this, Mr. Chairman and members of the committee. Immunity for any industry is abhorrent to basic notions of American justice. SB 488 places the firearm industry in the exact same position of every other industry in our country and in our state. If the industry is exclusively made up of good actors, as they will claim, they have absolutely nothing to fear from this bill. But if there are bad actors among the good, we must allow our civil justice system to hold them to account. I ask for a favorable report. Mr. Chairman, the Attorney General will be next, and I'm deeply honored by his presence. Following him will be Mary Kana of Everytown, and I urge folks to listen closely to her testimony. Mary helped author the New Jersey law, has defended these laws in other states. Her success rate is 100%, and has unique insight as to how these cases are being litigated elsewhere. With that, let me introduce the Attorney General of the state of Maryland, Anthony Brown.
Morning, Mr. Chairman and members of the Judicial Proceedings Committee. For the record, I'm Attorney General Anthony Brown, and I'm testifying in support of Senate Bill 488, the Gun Industry Accountability Act of 2024. I'd like to start by commending Vice Chair Waldstreicher, not only for your leadership in providing Marylanders, as well as the Office of the Attorney General, with the important tool for holding the gun industry accountable for its contributions to the crisis of gun violence in our communities, but also for your very thorough, comprehensive, well-thought and documented presentation of Senate Bill 488 and the context in which the committee is considering it. Mr. Chairman, I've submitted written testimony. I'll be brief, highlight some points from that testimony. All of us are familiar with the tragic cost of Maryland's and caused by Maryland's epidemic of gun violence. On average, guns kill nearly 800 people each year in our state. Much of the blame, not all of the blame, much of the blame lies with the gun industry, which has done far too little to keep guns and ammunition out of the hands of those who are not allowed to have them or would use them to do harm. Only 5% of gun dealers are responsible for 90% of recovered crime guns. In 2022 alone, federal firearms licensees reported the loss or theft of some 17,000 firearms. Many of those thefts and losses due to the irresponsible behavior and conduct of federal firearm licensees. And the gun industry has a history of marketing its products to young people and those most prone to commit acts of violence. As a general matter, when guns and ammunition are used to commit acts of violence, their manufacturers and sellers are immune from suits, regardless of how blameworthy their conduct may have been. This is because, as the sponsor described in his testimony, of the Protection of Lawful Commerce in Arms Act, known as PLACA, that creates impediments to holding the firearm industry accountable. However, if a gun manufacturer or seller violates a state or federal statute governing the sale or manufacturing of guns and ammunition, a predicate statute, again, is the sponsor defined, a suit to redress the resulting harm is not barred by PLACA. PLACA provides examples of suits that would fall within the predicate exception. They include, for example, suits arising out of a defendant's non-compliance with federal or state record-keeping requirements. It includes suits arising out of certain false statements of fact material to the legality of firearms and ammunition transactions and suits arising out of certain efforts to provide firearms or ammunition to people statutorily prohibited from possessing them. Senate Bill 488 would add a predicate statute to Maryland law, enabling firearm manufacturers, sellers, and marketers to be sued for their irresponsible conduct without running afoul of PLACA. SB 488 would prohibit firearm industry manufacturers and sellers from knowingly creating, maintaining, or contributing to public harm by engaging in conduct that is unlawful or unreasonable. And it would require them to establish and implement reasonable controls regarding the sale, manufacture, distribution, importation, marketing, possession, and use of firearm-related products. And the bill would enable private persons to enforce these obligations by suing for injury or loss resulting from the violation. The bill defines violations as a public nuisance, and it would authorize the Attorney General on behalf of the people of Maryland to sue firearms industry members for the creation of that public nuisance. Should SB 488 become law, I intend to make full use of this authority to hold the firearms industry to account for its behavior. Enacting Senate Bill 488 would place Maryland alongside other states that have passed legislation to hold the firearm industry accountable. As you heard, 8 states have done so in the past 2 years. To date, again, as you've heard in that very comprehensive testimony, none of these state statutes has been successfully challenged in court, and at least one has been expressly upheld. I urge the committee to favorably report Senate Bill 488 so that the firearms industry can be held accountable for its conduct and so that it can be incentivized to prevent the deadly misuse of its products. Thank you, Mr. Chairman.
Good morning, Chairman Smith, Vice Chair Waldstreicher, and members of the committee. My name is Mary Kana, and I am Policy Counsel for Everytown for Gun Safety. On behalf of our volunteers across Maryland, I'm here to urge a favorable report on Senate Bill 488. As you heard, in 2005, Congress passed PLACA. In the years since, this law has shielded unscrupulous actors in the gun industry from accountability for harmful practices that have cost far too many lives. No other industry in the country has been granted such broad immunity. When gun dealers and manufacturers engage in irresponsible business practices that result in preventable harm or in the criminal misuse of guns, PLACA allows them to avoid liability. PLACA's liability shield, while broad, is not absolute. The law includes exceptions, including one that allows lawsuits to proceed in cases when the gun industry member knowingly violates a state law related to the sale or marketing of firearms. These exceptions exist for a reason, to enable those whose conduct violates the law to be held accountable. When members of the gun industry face civil litigation and the risk of incurring financial loss because of their unsafe business practices, they will finally have the incentive to establish the reasonable controls called for by this bill. The Attorney General needs a statutory authority to investigate bad actors in the firearm industry and hold them accountable. We are grateful to him for prioritizing this legislation. Since 2021, 8 other states have passed laws similar to this one. All of these laws have withstood legal challenges and have enabled the filing of several active cases against bad actors in the gun industry whose misconduct has caused death, injury, or other harm. Passing SB 488 would require members of the firearm industry to establish reasonable controls around the sale of their products and enable the Attorney General and Marylanders harmed by the gun industry to hold them accountable when they engage in unlawful conduct. Thank you for your time. I request a favorable report.
All right, thank you very much. Questions from the committee? Senator West.
Thank you, Mr. Chair. Let me ask some questions, if I could, of the sponsor of the bill. So I know you're reluctant to engage in hypotheticals, but I'm going to give you one. I don't know where gun manufacturers are located. Let's assume one is located in the state of Missouri. Is it possible for a gun manufacturer in Missouri to be sued under this bill?
So again, we can come up with a lot of different hypotheticals. but none of them will mimic the context and facts that a plaintiff's attorney, a defense attorney, and a judge would consider in a case that was brought under this bill. And so these hypotheticals are not able to fully explain what the bill does because there's no facts around the hypotheticals that you are creating. And so that makes this very challenging. If the harm was done in Maryland, and the law would allow suit, just like if the harm was done to Maryland in an auto accident, and in the Pinto example, the manufacturer might be in Detroit, but the harm was done here in Maryland, that suit would be allowed. A opioid manufacturer might be in New England, but where the harm was suffered in Maryland under current law, the victim would be able to sue. And so this bill, as we've indicated, puts the firearm industry in the same position as the auto industry, pharmaceutical industry, opioid industry, every other industry. The bill does not change current law.
Okay. Thank you for your answer. So as I understand it, from reading the language of the bill, firearm industry member means a person engaged in, among other things, the manufacture of a firearm related product. And firearm related product in turn is defined as a firearm, in relevant part, as a firearm which is marketed in Maryland or intended to be distributed in Maryland or possessed in the state if it was reasonably foreseeable that possession would occur in the state. So as I read the bill, if the firearm manufacturer in Missouri anticipated that it's possible that one of the manufacturer's guns would be possessed by someone in Maryland, that firearm manufacturer in Missouri could be sued under this bill.
That is not correct.
It's not correct. Why is it not correct?
Because in your example, there is no harm. This bill.
I just said could be sued. I haven't gone into the circumstances of the suit.
Well, this is why hypotheticals are so challenging here, because we don't have the context and the facts. We are creating simplistic versions, and those don't take into consideration everything that a plaintiff's attorney, a defense attorney, a judge, and then possibly a jury would consider in the totality of the circumstances.
I'm just trying to get a simple answer. Is it conceivable, if your bill is passed, that a firearms manufacturer in Missouri could be sued by someone based in Maryland?
If there was no harm in Maryland, there is no right to sue.
Could be sued, covers everything.
Right. If you let me finish, if there is no harm in Maryland, there is no private right of action under the bill.
I'm sorry, say that again.
If there is no harm in Maryland,
Oh.
there is no private right of action under the legislation.
All right. So let's go on to the definition on the bottom page 2 of the bill, reasonable controls. What if I'm the manager of a firearms manufacturer in Missouri, what sort of reasonable control would suffice under this bill to protect my company from being sued by someone in Maryland who is harmed by a gun which happened to be used in the state of Maryland to injure that person in Maryland?
So, Senator, as we indicated during the testimony, courts are experts at determining reasonableness. They do under the tort system each and every day. The concept of what is reasonable underpins the entire American civil justice system. I work in that system, you work in that system, and we deal with concepts of reasonableness, objective reasonableness, each and every day. The concept of controls is not foreign to these courts. They deal with it when it came to the opioid issue. You had opioid manufacturers who were selling their product to pill mills that they knew were writing illegal prescriptions. They did so because they did not have institutional control in their management of their company. And they were found to be that lack of control was unreasonable. This bill simply puts the gun industry in the same position that the opioid industry is in. And just as they were found liable when they failed to exercise reasonable institutional controls, so too could the gun manufacturing industry be held liable if they fail to institute reasonable institutional controls.
So let me read to you just a small portion of the fiscal note, which goes into great length, page after page after page, about all the controls that are placed on manufacturers and retail sellers of firearms here in Maryland. And as you know, because you've been on this committee for a number of years along with me, we've passed scores of bills to regulate in various ways firearm manufacturers and retailers here in Maryland. So here's what the fiscal note says. Before a person purchases, rents, or transfers a regulated firearm in the state, the person must submit to the Department of State Police or other designated law enforcement agency a firearm application that identifies the applicant and the firearm that's the subject of the transaction. Applications are investigated by the Department of State Police and are subject to a 7-day waiting period before the transaction may take place. Now let's assume that all that has occurred, and yet down the road that firearm is used to injure someone here in Maryland. Is there any circumstance under this bill under which the manufacturer of that gun in Missouri can be sued by the person who was injured in Maryland after that gun was put into commerce by the state of Missouri, assuming that these various requirements had been complied with in the sale of that gun?
So let me answer that with two things from my testimony. First, the fact that the gun industry is highly regulated, as the fiscal note indicates, is not an argument against the bill. In fact, it's an argument for the bill. Other industries that are highly regulated, including criminal laws and administrative regulations, are also subject to civil tort liability. Those are the three systems of justice that we have in Maryland: criminal incentives, administrative remedies, and civil liability. Those three incentivize the very behavior that Ms. Kana indicated we are looking for in every industry, including the gun manufacturing industry. And so the fact that the gun industry is so highly regulated does not change the fact that they are missing one stool of the three-legged stool. Second, you asked about kind of third-party interveners. The bill, as we indicated, specifically requires a nexus between the wrongful act and the gun industry manufacturer or industry player. Without a nexus between the act and the defendant, there is no suit, and it will not move forward.
I'm not sure you answered my question. So let me try to rephrase it. So your bill requires a manufacturer in Missouri to place reasonable controls, meaning policies that are designed to prevent a gun coming into possession from a person prohibited from possessing the gun. So the fiscal note goes into great detail about all of the restrictions we place on sales of firearms in Maryland. And we have passed these restrictions over the years, I assume, presuming that these are reasonable controls on the sale of a gun. What additional reasonable controls on the sale of that gun do you feel that the manufacturer in Missouri is obligated to implement in order to protect the manufacturer from being sued under this bill?
Again, so I think it's a legitimate question, 100%. Again, that question is present in every other industry suit in the country. Whether the industry, whether the defendant complied with applicable regulation and criminal laws is admissible evidence in a civil suit in which the defendant is being sued for damages. And so this bill positions the gun industry in the same position as any other industry. Should the gun industry argue in court that they are compliant with all applicable criminal and administrative regulations, that is admissible evidence in court. Same as any other industry.
Well, let me come at it. I'm still not sure I got the answer to the question. Let me come at it another way. Your bill relies on the defined term reasonable controls. In Maryland, we already have lots of controls, which I believe for the most part are reasonable on the sale of guns here in Maryland. What additional reasonable controls do you think a manufacturer in Missouri should implement regarding the sale of guns here in Maryland, its guns here in Maryland, which would protect that manufacturer from being sued for injuries sustained by someone in Maryland?
I understand your question and I appreciate it, but it's not a question of policy. That is a question of law. Plaintiffs, defendants, judges, and possibly juries regularly make determinations of reasonableness. They do this in our tort system every day. They're doing it right now, up the street, on Road Boulevard. This is part of our legal system. These determinations of reasonableness are what courts do. They are not it's not a policy decision that we make.
Well, let me try that one last time.
Okay.
If I own a gun manufacturing firm in Missouri, what in your view are reasonable controls that I should place on the sale of my guns to Maryland dealers, which are going to suffice to protect me from being sued by someone in Maryland who down the road is injured by one of my guns?
So I think we're treading here. What is and is not reasonable in the civil tort system is not determined by legislators. That's determined by the plaintiff's attorneys, the defendants, ultimately the judges and the juries, not by us.
Well, let me try another way of getting around this same issue. If we want
one more line of inquiry on this one, I want to move because I respect this, but you can ask another question. But if we go through one more iteration and there's no joy, I think we're going to have to just move on to another question.
If we want to safeguard the citizens of Maryland from gun violence, why don't we pass specific legislation designed to do that in specific ways, as we have in the past, rather than simply enact a bill that says dealers can be sued by anybody on the grounds that they didn't exercise reasonable control of the sale of their guns? Why don't we provide specific things that they need to do rather than leave it up in the air and invite plaintiffs' lawyers to file a bevy of lawsuits against the manufacturers?
Well, on the first part, I agree with you. We can and do provide regulations and criminal laws affecting the gun industry, and both the manufacture and the sale. And we should continue doing so. Where I take issue with your question is that these ideas are mutually exclusive, that we as legislators can choose either to pass criminal laws affecting the industry or provide reasonable civil tort access to victims of gun violence. We can and must do both.
All right, let me go on to another part of the bill. This is the substantive part, which actually specifies the circumstances in which someone can be held liable. It says your section 3-2302, which says the firearm industry member may not knowingly create harm to the public through engaging in conduct that is unlawful. Well, if the conduct's unlawful, it's already prohibited, isn't it? Why do we need a bill to say a manufacturer cannot knowingly engage in unlawful conduct?
Because if it is unlawful, they may be subject to criminal liability or regulatory action. But because of PLACA, they are immune from civil liability in state court unless we provide a predicate exception. So again, there are three legs to the stool: criminal, regulatory, and civil. This provides the third leg of the stool.
All right, I think there are others who want to ask questions. Let me just focus on one final area, and that is the penalties. It says a person who brings an action under this subsection may seek and be awarded punitive damages. Punitive damages means an unlimited amount of damages. Is there any standard which will govern under what circumstances punitive damages can be awarded? Or is it in any case in which damage has been found, punitive damages can be awarded against the defendant?
Under Maryland law, punitive damages require a showing of malice.
So even though it's not mentioned here, you believe that is a part of the definition of punitive damages that you're using in this bill?
Correct. That's current Maryland law.
Okay, thank you.
Thank you, Mr. Chair. This question is for the litigator from every town, Ms. Cano. Can we come to the, that way we get your right in the camera. So you had mentioned in your testimony about in 8 other states. And in these 8 other states, you had talked about bad actors and that there was current legislation being. Can you give me some of the examples of
The civil
things?
cases?
Yes.
Yes,
Of what they are.
Sure. So New Jersey, for example, the New Jersey Attorney General's office just sued a gun dealer in the state because they had lax security. They posted online pictures of guns basically in the front window to thieves. Googled gun store. They saw that this particular gun store had easy access. They robbed it. And of the guns that have been recovered from that theft have all been recovered at crime scenes.
And any other?
Sure. New York, the Attorney General of New York is currently suing a firearm accessory manufacturer. It was a magazine lock, and on their website, they provided easy instructions to remove the lock to enable people to install large capacity magazines onto their assault rifles, even though they're illegal in New York. Another example is the state of Washington. The Attorney General sued a gun manufacturer for selling illegal large capacity magazines, and they won a $3 million verdict as a result of that case.
I'm just bringing this up, section 3-2301, it talks about firearm related products. And then it also talks, number 1, talks about sold, manufactured, distributed, or marketed in the state. Is there anything that can be sold, manufactured, or distributed that is not directly firearm related? And what I mean by that, on the particular gun, can clothing that is then marketed by said gun manufacturer because people want to buy it because of that name, can that clothing be caught up in this? And I don't think it's a hypothetical. Okay. I think it speaks to the actual reasonable controls.
Sure. I mean, I suppose if that clothing somehow contributed to the harm or death of a Marylander, that's very possible. But as Senator Waldstreicher said, it would be up to a court to decide whether that was actually the case, and is, I would say, probably extremely unlikely that that would happen.
Well, my only link is that it was distributed, because it says this in the bill, sold, manufactured, or distributed and marketed in the state. So that to me is very broad. I'm not an attorney, so I may not be looking at it properly, but for the common man or common woman, to have something that's been branded.
Sure.
Is that a loop that somebody could actually be caught up in?
I think not. If you look at firearm related products, the definition, it says a firearm, ammunition, component or part of a firearm or firearm accessory. And I think that is going to limit it to things that are attached to or being used with firearms.
Okay. All right. Thank you.
Thank you, Mr. Chair. Mr. Vice Chair, I have a couple questions for you, sir. So in your testimony, you mentioned about bad actors through, and I bring that up because through selling of firearms. So this is not just the manufacturers, this is anyone that sells firearms, correct? It would be the stores, the retailers.
That's correct.
Okay. And then, and they would be considered bad actors through selling legal firearms, kind of like the example that the advocate from Anytown?
Everytown? Yeah, Ms.
Everytown,
Kana.
I'm sorry.
Yep.
I'm sorry. So here's my concern is that the examples you gave, while they were great and they were accurate in how you gave them, they don't necessarily, they don't apply in this situation. And here's what I'm going to say for the auto manufacturers. You gave an example of a manufacturer defect in design that was known, the Pinto, and someone's death resulted in that. That wasn't, you know, for them being able to go back and sue for that, it's appropriate. It's justified. Did they go and sell the dealership? Was the dealership allowed to be sued as a result of that? Because they had nothing to do with the manufacturer and design of the vehicle, and they weren't aware of any of the defect or risk that was associated with that.
Correct. Under this under current tort law, the example you use, and under the bill, there must be a nexus between the defendant and the harm.
So
I agree with you.
would the manufacturer, or I'm sorry, would the seller of said automobile be liable like you're trying to do here for the firearm industry?
Well, I can't speak to the individual Pinto case beyond the knowledge that I have, but the specific language of the bill requires a specific knowing nexus between the harm and the defendant.
Okay, so that leads me to my next question. Thank you. Are auto manufacturers responsible through no fault of engineering design when another vehicle is operated and unfortunately would go off the road and strike people at a bus stop or you know, pedestrians? Are they responsible when there's no engineering issue, but it's the person that's operating the motor vehicle? Their fault.
Again, I can't speak to hypotheticals where we don't know the facts and the context, but in general, as I indicated in my testimony, when two people get in a crash, they sue each other.
Correct.
They don't sue the manufacturer.
Correct.
And we are agreeing.
Yes.
And the reason we're agreeing is because I don't think this bill creates the liability that some of the opponents think it creates, because it requires a clear and knowing nexus between the harm and the defendant.
But it doesn't, because, and I'll ask the Attorney General about that on his testimony, but there's a clear delineated difference of what's being asked here. You know, when you talked about, you know, tobacco and them hiding the addictive nicotine, when you talked about the opioids having the known addictive elements, there was known covering up of bad actors, right? This is something that is a highly regulated trade, that people are in that business of commerce. And we are not only looking to hold the manufacturers responsible, but now we're looking to hold the individual gun store owners who meet all the current regulations that would be in place in Maryland. So that's where the concern is coming in, is that they get inspected for security, they get their safes inspected, they get everything inspected and vetted, and they meet the standards. And by the example that was given about like the one window that was broken in, and I understand it's probably not the best thing to have windows in a gun shop, let's be honest. However, if that was meeting the standard of that law, of what was allowed or permitted, then they're in compliance. And now we're looking for another element to try to hold them accountable. So I guess, and the last question I have, is there liability on firearm manufacturers for faulty manufacturing that would cause catastrophic weapon failure that causes injury, death to the subject firing the weapon? So like in your example, the Pinto, there's a design flaw. The manufacturers have this design flaw. They issue a gun, it has a catastrophic failure, weapon explodes. Is there liability even under PLACA for that?
There is, yes.
Thank you. My next question, Mr. Attorney General, could you come say hi, sir?
How you doing, Senator?
How are you, sir?
Can I, before you ask a question,
Yes.
can I just, I think, pick up on where Senator West and you were asking about the reasonable controls. Assume an arguendo that in statute and regulations, we have reasonable controls.
Sure.
Okay, that gun sellers, manufacturers have to abide by. The question comes down to, did that gun store establish and implement what's required in statute? And when they don't, then it exposes them to liability under Senate Bill 488.
Understood.
So it's less a question of, do we need more controls, and some would say yes, some would say we have plenty. But even given the existing controls in law, did you establish and implement them at the gun shop? Did the manufacturer do it? Did the distributor do it? And did all the others who are defined in the bill as a firearm industry member?
So that's a great segue into my question. Thank you, Mr. Attorney General. So in that scenario where we have these reasonable listed out requirements, right? And there's inspections that happen. And if they don't meet that and something happens, there's already a mechanism in place to hold them liable, is there not?
Well, and again, I'll echo what the sponsor said. You've got certainly administrative controls, you've got criminal liability, and under Senate Bill 488, if there is harm associated with that, you'll be subject to tort liability.
Okay. And so, Mr. Attorney General, you made a comment about that much of the blame lies on the gun industry of the 800 Maryland deaths. That's concerning for me. So I understand, I guess, the intent of what you were saying, sir. My concern is that in that statement in and of itself lends me to worry that you're already shifted in a mindset that a lot of liability for those 800, more than, as you said, I wrote it down, much of the blame lies on the gun industry of 800 Maryland deaths. That's concerning because that tells me your mindset has already shifted, that they have liability in that. And I worry about that kind of statement because much of the blame is there's a lot of wrongdoers out there that are that are not legal gun owners that have guns and doing a lot of bad things to people. And I know you get the same report I get, Mr. AG, on the MCAC report and the rate and deaths that are occurring in the state as far as firearms. And I agree, it's alarming. Having said that, holding people and an industry as a whole liable, or that your feeling is that much of the blame lies on the gun industry, is concerning to me, because that we could sit there and say, well, much of the blame for the 42,000 deaths that happened across the country in vehicle collisions lies on the vehicle manufacturers for not making safer vehicles. It's not fair. Gun ownership is a legal right. It's an opportunity, and people are allowed to exercise that right. It is a protected element within the Constitution. So and I guess what I'm asking is, are the gun manufacturers or the industry members, are they selling these weapons and ammo to those who are unlawfully allowed to possess them in the state of Maryland?
Let me respond, if I may.
Yes, sir.
When I make statements that there are those who are blameworthy, I don't suggest whatsoever that anyone engaged or everyone engaged in the sale, manufacture, distribution of firearms is culpable of civil liability.
I appreciate
Just like I have concerns, just by way of analogy, of the number of DUIs on the road.
Sure.
Right. And I don't suggest that every alcoholic beverage manufacturer or every driver in Maryland,
yes,
or dealership is blameworthy, but I'm concerned about the high level of DUI. I'm concerned that 800 Marylanders lost their lives, as I pointed out in my testimony. I am concerned that a small handful of dealers account for the 90% of guns that are recovered in crimes. Those are the concerns that I have, but no way would I suggest that everyone involved in this industry is blameworthy or liable.
No, I appreciate that. Thank you. And then in your testimony, you also referenced unlawful versus unreasonable. You made a reference to both now, unlawful and unreasonable. Those are in two entirely different thresholds on accountability and liability in law. And I mean, would you agree?
I would agree.
Can you explain to the committee the legal definition and separation required elements of those two differing things, unlawful versus unreasonable? Because this bill only rises to the threshold of unreasonable.
I'll give you an example using the example that was brought by every town. Unlawful would be, for example, if I had a requirement to have certain record keeping for who I sold the firearm to, and I had to do a certain background check. And if I didn't do it, I violated regulation. That's unlawful.
Sure.
Okay, unreasonable could be, and I'm not reaching any conclusions.
Gotcha.
Unreasonable was certainly found in the case that was presented when someone displayed a firearm in a window
Mhm.
that was not reasonable security for that firearm. Someone, however whether they broke into the dealership or whatever, they were able to steal the weapon. Was that unlawful under the jurisdiction? Maybe not. But was it unreasonable? It was determined to be unreasonable. So there's a distinction between unlawful and unreasonable.
And I appreciate that explanation. Thank you, Mr. AG. You know, I find it, you know, we're trying to find these solutions, right? And, you know, I agree, there's unreasonable methods in place, just like I think it's unreasonable that our own body doesn't understand that the value of a firearm that's stolen, because it falls below $1,500, should be left as a misdemeanor, when it should be not held by the value, but the threat that it presents to our society, to our community. So I would like to think that, hearing your testimony, that you would be one that would be championing for that solution as well, to hold those wrong actors as a felonious act, which could help curb some of these thefts that are occurring in vehicles and in people's homes. Can you comment to that at all?
When that bill's in front of us,
It's here.
Yeah, but it's not in front of us here. I want to stay focused on Senate Bill 488 and not the debate and discussion around maybe related, but a different bill.
Okay. So my last question then, Mr. AG, is Mr. Attorney General, sorry. States that require a waiting period to assume possession that is different than Maryland. Okay. Depending on the type of firearm you purchase. Could one be liable for a firearm that's sold in another state and carried into Maryland by this bill? So if they're, and I bring up the example, like there's a lot of different rifles that are side by side, are the exact same rifle. The only difference is one has a stamp on the barrel and one does not. The one that does not have a stamp on the barrel is illegal to buy in the state of Maryland. The one that does have this, or the one that does, you can buy in Maryland, even though they're the same. So what I'm asking is, you could go to another state and buy legally and bring into Maryland that same weapon. This is what worries me about the unreasonableness or the other thresholds, because we're adding a lot of things onto this that it could be, my worry is that someone will make it that it's unreasonable because it was known that you couldn't purchase it in Maryland and you went to another state and purchased it legally and brought it into Maryland. Is there liability associated with that on those dealers, knowing that you live in Maryland in this bill?
Look, there's a lot of issues that you presented in that hypothetical. And, you know, you'd have to look at things like jurisdiction. You'd have to look at what's knowing, what's reasonable. And as you know, Senator Waldstreicher said, I'm not sure it's particularly of value to entertain that hypothetical when, look, these cases are potentially complex and they're going to have to be evaluated on the facts presented in each individual case. So it's really hard to entertain and answer hypothetical.
Okay. I appreciate your time, Mr. Attorney General. I just have one more, actually, two more questions for the bill sponsor, please. In the purpose of the bill, it talks about a public nuisance being one of the prohibiting the sale, manufacturer, and establishing that a violation of this act is a public nuisance.
Mhm.
Do we know what the threshold of, or what the definition of public nuisance is?
So like reasonableness, public nuisance is a tort concept that that goes back hundreds of years and has hundreds of years of precedent, both in Great Britain, where the nuisance concept originated, and here in the United States.
So when I pull up public nuisance and run it through, it says that any conduct that interferes with the rights of the public.
So that's a dictionary definition?
Yeah, I mean,
Sure. So the definition that will be utilized in interpreting this statute would be the judicially defined definition, not a dictionary definition. And the judicial definition of this is based on hundreds of years of precedent of defining what is and is not nuisance.
Okay. And then on page 2, my last question, Mr. Chairman, so thank you. On page 2, line 7, under paragraph C, you make reference, the bill makes reference to a firearm accessory, means an attachment or device designed to or adapted to be inserted into, affixed onto, or used in conjunction with a firearm. So, this is an attachment for a firearm. It's a dust cover for a barrel. So the manufacturer of this, by your bill, by the definition of your bill, could be found also additionally liable. The person for making sure that the chamber is clear in the rod, in the barrel, this could also be. And then the last one is really concerning, is because these are handed out for free because of previous legislation, which is a safe, a gun lock that goes up through the magazine well, out the ejection port to render the weapon safe and secure. So by the reading of the firearm accessory, all these fall into your categories.
What you have shown are firearm accessories, yes, but the liability doesn't attach just because it's a firearm accessory. All the other requirements of the bill are still operative. So the accessory needs to have caused the harm. So I don't know how a dust cover causes harm, but the accessory needs to have caused the harm. The harm needs to have occurred in Maryland, and there needs to be a nexus between the accessory and the harm.
So the reasonableness of the word of reasonableness is what I keep coming back to. Would it be reasonable to say that even though someone may have a weapon that is secure in a safe or elsewhere, and then they don't have this on top of it, or they had this and not in a safe, but then someone steals it and cuts it off, then are we going to say that it wasn't reasonable that they had it secured safely and now this company is liable because their cable wasn't strong enough?
So again, we're back to hypotheticals here. Reasonableness is a determination utilized, well-defined by courts and utilized in courts each and every day by both plaintiffs and defense attorneys.
I appreciate your time. Thank you,
I appreciate
Mr. Chair.
you. Thank you.
Thank you, Mr. Chairman. Go ahead, stay up there. Stay up there, Senator Wallstreicher. Thank you. Thank you, Mr. Chairman. I have 2 very quick questions, I promise. The first, full disclosure, complete softball. The second, more technical. But my softball is this. First of all, I want to thank you to the bill sponsor. I very much appreciate this bill. Thank you to the Attorney General for your eloquent explanation of this, and to Mary for giving us those very specific examples. That was important for me in this hearing. It's also important for me to see the people sitting here in this hearing to remind me of, what my constituents really care about. So just I want to note that this is not easy. You've had a series of hard questions. You're answering them very thoughtfully. These are tough issues, and it's not easy to do. And I'm very appreciative of the work that you all are doing on this, which brings me to my softball question, which is, what are we trying to do here, big picture, for the people of Maryland? What are we providing for the people of Maryland if we pass this legislation? And then I will follow that up with my specific question related to the language.
Sure. Well, thank you for the question. And let me also acknowledge the Moms Demand Action advocates behind me. They came in force today, very early on a Friday. As you know, we have limited testimony, and so they wanted to be here to show their support for the legislation. We really appreciate our friends at Moms Demand Action. What are we trying to do on a grand scale? We're trying to hold bad actors accountable. We know that the industry is not all bad actors, but unfortunately, we know, like any other industry, it does have some bad actors. Marylanders deserve access to civil justice. And under PLACA, they don't have that. We have the power for victims of gun violence, real human beings, our constituents, who are harmed by this product, sometimes because of the knowing unreasonableness of people in the industry. And when that happens, they deserve access to our courts, and we deserve the opportunity to give it to them.
Thank you. I really appreciate that. So my specific question, and as you know, and the committee knows, I'm new to these issues. I have read a lot of these bills, but usually while sitting on the floor, as the committees have already vetted them. But in my memory, usually when we do legislation like this, in addition to words like sale and manufacture and marketing, we usually have the word transfer in there. And I'm wondering why this legislation, I'm sure you have a reason. I just want to know what it is. Because as I read it, I'm looking like on page 3, line 14, it says, to ensure that the firearm industry member complies with all provisions of state and federal law and does not otherwise promote the unlawful sale, manufacture, alteration, importation, marketing, possession, or use, but not the word transfer. Can you explain to me why?
So I'm going to give a shot to Ms. Kana, who I think is
Okay.
better situated.
Perfect.
But I think the short answer is non-industry players can provide transfers. Under Maryland law, family members may transfer between family members, and they are not industry actors when they do that. And so if you were to purchase a weapon on behalf of your adult child and then transfer the weapon to that child, you are not an industry actor. And so because we allow family transfers in Maryland, we don't include that in the bill because family transfers are not acts of the gun industry.
Thank you.
And Ms. Kana, I don't know if you want to take a shot.
Yeah, I'm happy to add a little bit more to what Senator Waldstreicher said. If you look at page 2, line 21, firearm trafficker means a person who acquires, transfers, or attempts to acquire or transfer a firearm for the purpose of selling or disposing of the firearm in violation of state law. So there you have illicit transfers accounted for. And similarly with the straw purchaser aspect. So if someone pays somebody to buy a gun for them because they're not allowed to have it, and then they give that gun to that person, they would be a straw purchaser. So here it's going after the conduct of a dealer who knowingly is engaging in these kinds of transactions, knowingly sees the same person coming in over and over again, buying maybe the same gun over and over again. That would be potentially an instance where that gun dealer could be held liable, considering, depending on obviously all the other facts.
Great. Thank you so much. I appreciate it.
Thank you very much. And whomever on the panel may be able to answer this. I had a bill drafting question. On page 4, when we're looking at the type of remedies that are available to, or that the Attorney General can seek versus a person, I noticed that there were some differences, and I was wondering if there was a reason why one, I think under the Attorney General, they could seek restitution, but a person could not. And they also could seek any other appropriate relief, but the person could not.
Thank you, Mr. Chairman and Senator Sidnor. Restitution is when I am standing in the shoes of Marylanders, and this would be true under Senate Bill 488. It's true when I bring consumer protection actions, when I bring antitrust actions, et cetera. I'm seeking restitution, which are the sums that I'm seeking on behalf of Marylanders. When I have received compensatory or punitive damages, those will typically go to the state, the general fund or a special fund. Injunctive relief obviously is an order saying you have to discontinue doing what you're doing. So that's why I can seek restitution on behalf of the people of Maryland, where the individual who's bringing the claim on that the section below that you identified, they're bringing it on behalf of themselves or a family member.
Got you. Is there this? And I noticed that again the way it's enumerated. For the Attorney General says compensatory and punitive, whereas for the person it separates punitive and compensatory. I'm wondering, is there a meaning behind why it's drafted that way? For the Attorney General, does the compensatory damages have to go with the punitive versus the person can only, can receive compensatory or punitive?
I think that's just the bill drafter.
Okay, but it's not meant to be a distinction though.
No,
that's what I was trying to get at.
Yep.
Okay, thank you. For let me see, Miss Kina. It talked a little about disparate impact. I'm curious if you might be able to really speak to who this law is intended to help.
Sure. you know, this law is intended to help all Marylanders, give victims of gun violence access to justice when the gun has been purchased illegally, for example. However, right now, because of the PLACA immunity, many lawsuits are not able to be brought. And like I said, victims deserve access to justice. We know that in the state of Maryland, 80% of gun homicides are committed in majority Black and brown neighborhoods. So these are the victims of gun violence that currently are boxed out of having access to justice when their loved ones are hurt or killed by illegal guns or unlawfully sold weapons.
Thank you. If I might ask, just for your experience in these other states, I think my colleague earlier was talking about section 3-2302, talking about the unlawful or unreasonable. I'm curious, in your experience, when these suits have been brought, would they tend to be brought looking at actions that were unlawful or unreasonable?
Well, the Washington case that I pointed to, that was unlawful action by the gun dealer, right? The case I discussed in New Jersey, I would say would probably fall under Maryland law if it were brought here, unreasonable under the totality of the circumstances. For example, if that gun dealership had bars on the windows, security cameras, a cage out front that made it very difficult to rob the store, that might not be unreasonable under the totality of the circumstances. In this case, because it was just a plate glass window that was easily broken with guns kind of sitting right there in the front, similar to like a window at Lord and Taylor, then yeah, it could be found, and we will see what the courts decide, unreasonable under the totality of the circumstances.
And I may be misunderstanding this, but if you wouldn't mind clarifying, because of, you call PLACA, that's the acronym. Because of that law, if a firearm industry member was engaged in some act that was unlawful, current law would prohibit Marylanders from that may have been damaged because of that unlawful act from then being able to sue. And that's the state of the law today.
Exactly.
Somebody that created somebody that did an unlawful act, there's damages to Marylanders, and Marylanders can't.
Yes, exactly. So the gun dealer may be held criminally liable if they're prosecuted for the unlawful act, but the victims of the gun violence that was proximately caused by the gun dealer's unlawful act would not be able to sue to get damages or to have an injunction to make that gun dealership follow the law.
No civil remedies.
Exactly.
Okay. What is the standard of care that manufacturers must take to ensure that they would not be subject to liability?
So we've discussed a little bit about reasonable controls, right? And a lot of these laws are already mandated by Maryland law for in-state federally licensed firearms. This would impose similar duties on non-Maryland licensees who want to do business within the state. So for example, this would be requiring security, keeping security inventory, having like good records, background checking your staff, training staff on how to properly run a background check, using trace data to identify bad actors so that they're not repeatedly selling to people who are engaging in straw purchasing and gun trafficking.
It sounds like best practices, right?
Something like that, yeah.
Gotcha. The final question that I had for you are the violations under 2302 would be deemed a public nuisance. I know my colleague was asking what's a public nuisance, but my question is why nuisance theory rather than something else?
I think that this is the model that a lot of states have followed. It enables the Attorney General to stand in the shoes of Marylanders to keep them safe. And a gun dealer selling hundreds of guns to prohibited people is a nuisance to the public when those guns are being used in crimes that are harming or killing Marylanders.
Gotcha. Thank you. I had a question for Mr. Attorney General. And you can correct me if I'm wrong, but I believe the way that your powers operate is you're essentially restricted from doing anything unless statutorily you're given authority to do something, correct?
My office is a creature of statute. That's correct.
So I would assume that you need this statute so that you can pursue this type of cause of action. Am I correct?
That is correct.
All right. Thank you very much. Thank you very much, Mr. Chair.
Thank you, Mr. Chairman. I'm really seeking information. I can understand the statute. So since we were just with the Attorney General, either the Attorney General or the sponsor, does this statute work that you would first have to have an individual bring a claim, then notify the Attorney General, who could then at their discretion either also bring a public nuisance claim that, you know, works with the individual claim? Could you, or is it a little bit different than what I just described?
The statute does not require an individual to bring a claim or complaint to the Attorney General. The Office of the Attorney General would be able to act without an individual bringing a claim.
With the individual, I understand they're going to have to have experienced, you know, injury or loss. What would trigger your bringing a case?
I mean, I would, as I do in many of my enforcement actions, again, whether consumer protection, antitrust, securities, even in my criminal division, right? I look at what is the harm? Is there harm? What is the activity that may have contributed to that? I do my due diligence. So you could have a scenario in Maryland where someone is injured by a firearm or firearm accessory as defined in the bill. I would, you know, investigate that and I would look to see whether or not the elements of this public nuisance were met to determine whether there's potential liability.
I guess I'm trying to figure out whether you are going to look when begin to look at this statute and a particular potential defendant after an individual has been injured or suffered a loss, or whether I should understand this statute is I'm now creating sort of a division within the Attorney General's office who will be basically looking across the state at all times at gun manufacturers and everybody else that's mentioned here, that you'll start just doing broad investigations to see if you can develop facts to begin to sue various potential defendants, which that's what I'm asking about.
Right. So and thank you for the opportunity to clarify that. If you look at page 3 down at line 20, right, there's a requirement for harm. So we're not investigating fire industry participants, looking at their practices, looking at their protocols, whether they're in compliance with the law. We're going to investigate actions that led up to harm.
What do you think that harm would be? I mean, you said it wouldn't necessarily be tied to an individual being injured or killed. It wouldn't be that limited. So what other harm outside of an individual being injured or killed would be the harm that would trigger your beginning to look at something, being looked at a defendant, potential defendant?
Harm certainly includes death, loss of limb,
I said
injury.
Other than that, what other harm? Because I asked you whether you needed, I thought you perhaps needed an individual to have been injured or suffered a loss before you would begin to get involved under this statute. You said, no, I don't have to have an individual injury or loss. I just have to have harm. So what harm other than an individual's injury or some kind of loss, physical damage, would trigger your looking into using this bill for some purpose.
Let me clarify. When I said I didn't need an individual harm, what I meant was I don't need an individual coming to the Office of the Attorney General saying I've been harmed and asking me to initiate an action.
What do you need?
I need harm.
I'm asking you to explain that to me in layman's terms, because I am very lost and
Right.
do not
If-
understand what you're
right,
saying.
so certainly that would include the loss of, someone's life, your life, a family member's life, or loss of life of any Marylander. It certainly would include physical injury to a Marylander.
So what you're saying is even if an individual who's been harmed or killed or injured doesn't take any action under this statute, you yourself could look at it independently of that, make your own assessment and decide whether your office should get involved. Is
That's
that
correct.
okay? That's very
Yeah.
helpful. You should.
Yeah.
Then under this statute, let's see, are there any other negligence schemes, because that's what this is, right? Where we have put in statute that individuals can recover attorney's fees?
Yes, attorney's fees are found for individual plaintiffs in statute throughout Maryland. I can't catalog all of the cause of action that are in statute where that is the case, but this is not new in Maryland law.
Okay, I might.
And
want-
I can certainly come back
Would you
with the
follow up?
catalog of cause of action.
That
I
would
can do
be
that.
very helpful. Thank you. Then I just want to make sure I understood, Mr. Attorney General, in your testimony and in your written, you said that 5% of gun dealers are responsible for 90% of recovered prime guns. And I realize you are using I think this is the Brady, is that the Brady National Organization?
That's correct.
data?
It's footnoted there.
Yeah,
right.
that's what I thought. So I'm trying to understand the import of that, or is that because we just have a lot of a consolidation in the industry of gun dealers, or such that there aren't that many? And of course, that would mean that if there were illegal guns recovered, they'd probably trace back up to them. Or is this data saying we've got 5 gun dealers, 5% of them are apparently just in the unlawful gun trade? They're careless, reckless, or they're basically actively, illegal firearm dealers. I just don't understand the significance.
Some would explain it as that 5% are not properly doing background checks, checking for straw purchases. And as a result, you have a lot of purchasers there who should not be are not eligible, or if they're eligible, they're purchasing it for someone else.
Right.
And that's what I think,
Okay.
would be argued there.
And do you
But
think
it's
this-
got to be alarming that, like, you can go, imagine you got 100 gun dealers and 5 of them are selling 90% of the guns that show up in gun.
That's what I was asking. Is that data true for Maryland? Is that a statistic that holds?
I'd have
in
to defer to
Maryland?
Brady. I don't know the granular data in that.
So,
But what is true for Maryland, as we mentioned, I mean, 800, gun deaths in Maryland. I mean, that's true.
so get
That's
back to me,
accurate.
because I
want
do
the
want all this
granular data on
information, but
that?
get back to
Mhm.
me on that. What I'd like to know is why aren't there more efforts, since it's apparently is well-known data, why are we not prosecuting these gun dealers for the obvious crimes they are committing? So that you can get back to me.
Well,
on that. I
I'll
just
share
wanted
this
that.
much
Sure.
because it's not,
I want you to get back to
I'm
me
not
too.
disclosing anything that the committee hasn't read. But the city of Baltimore is very much focused on this issue and is looking at gun sale data. They're trying to acquire gun sale data from I think it's from ATF, because they're aware of this and they're trying to gather the data to demonstrate what we all know is happening.
PLACA is a statute I had never heard of until last year, and only briefly because we didn't get this far into the hearing. So, and I think I really need this information, but I don't want to make the hearing too long. I would like somebody to get back to me on why policy-wise PLACA was originally created and Congress created this law. I remember it has something to do, I saw a footnote sort to the extent that whether this is right or wrong in terms of whether you agreed with the approach. I thought the approach was there was a concern that because of the Second Amendment makes this particular product unique among any that you created and try to connect with an analogy of cars. There's no other product you mentioned that is protected by the Second Amendment. That's the distinguishing factor. And so PLACA, as I understood it, was Congress's attempt to say, we have to be mindful and careful about how much we allow for lawsuits that, you know, if an industry goes down, like the car industry, another one will pop up, or tobacco or anything else that's unsafe, but you put one person out of business, another will pop up. But when you're dealing with a product that is protected, there was some concern there. So this is their attempt. I'm not saying I'm not weighing in on whether it's good or not. That's my understanding of why it was done. So I would just, if I'm right about that, you can confirm that. If I'm wrong or I've missed some things, not here, this will take too long, but please get back to me about your thoughts about why it exists. And, you know, and how this will, you know, work with it. One other question. Okay, the last thing, and anybody can answer this. Since I think we are all very worried about gun violence and gun deaths, I'm wondering why we are not pursuing additional requirements on gun manufacturers, owners, and the like to put into law more things concretely and definitively that you must do to be measure up to the kind of safety we want. Pass a law that says you do not put your guns in a window. You know, so it's completely barred. You don't do this, you don't do that. Because while I understand litigation takes forever, it's expensive, it can go on and on and on, odd things can happen, but death is certain. So what we really want to do is bring down the level of death from guns. So to me, we should be doing a lot more in terms of putting in place laws that clearly tell everybody in this industry what we expect and what we will not tolerate. So that's a little bit of a question, a little bit of a statement, but I feel like this is a very meandering way to bring about protections, and it will take decades and decades in court cases. That's what worries me about this approach, but I'm really get the point of it. And we do have to bring down gun violence and gun deaths and guns, right?
And again, I don't think they're mutually exclusive, the approaches, right? And there may very well be the need for more regulation, but notwithstanding whatever level of regulation you have, you may very well have firearm industry participants who are not establishing and implementing whatever it is that the General Assembly or a regulatory body promulgates. And this bill gives then someone who's harmed by that failure to establish and implement what we think are good regulations, it gives them the ability to recover in court for the damages that resulted from that.
But I just want to push back a little bit. This is a very flawed way to do it, in my opinion. I'm a trial lawyer, and you know, there are a lot of motives for why lawsuits are brought. There's a lot of economic incentive to it. There's a lot of elements, but we and the Attorney General and we're not in that milieu. We don't benefit. We're not going to profit monetarily. We don't have, I hope, you know, motives other than public safety. Certain public safety, the highest standard of public safety. So to me, I would like to see if it's so known to the people that are coming up with this idea, all the various things that are lacking, that we aren't brought lists that say these are certain things that ought to be in place, and telegraph it to the industry so that industry people can say, this is what's expected of us. We're not going to find out after a 10-year lawsuit what is and is not acceptable. We're going to telegraph to them a whole lot more upfront. Saves a lot of money, a lot of heartache, might save some lives. So I know they're not mutually exclusive perhaps, but I certainly don't see the effort I'm suggesting, and I don't see it in this bill either. So thank you.
Yeah. So Senator James, you and I've had some disagreements this week over condo solar and stuff like that, but today you hit on exactly what I was about to ask. And Ms. Canuck, you come up. So it's a matter of the approach and in Plaka. So I want to give you an opportunity to address this because I know that the next panel is going to bring this up.
Sure.
And so it seems that a lot of what is in this bill is, and I'm just going to put this out there because some of the arguments that I've read, is prohibited by Plaka, like some of those suits. So the qualified civil liability action that's brought in either federal or state court. A lot of that language, like punitive damages, a civil action or proceeding, all that stuff, restitution, fines, penalties, other relief is in this bill. So the question up front is, it seems as though a lot of what you're doing seems to be preempted by federal law under Plaka. Okay, so just that's an argument that's going to be forthcoming. You heard the sponsor talk about the predicate exception and outlines that. And to Senator James' point, a lot of what is allowed under Plaka through the predicate exception is if there's a violation of state law. And so I wonder why take this approach as opposed to creating state statutes that more clearly project what is and is not permissible in the state of Maryland. Why are we taking this approach instead of that approach? And I think that's what Senator West was getting to as well.
Yeah.
And so I want to make sure that you have an opportunity to address that because I know that's a forthcoming argument.
Sure. Yeah. So one, I think the predicate exception exists for a reason, and it's to enable there to be, accountability, right? It's Plaka is the protection of lawful commerce in arms. So what we're going after here is particularly unlawful acts and then unreasonable under the totality of the circumstances. I think to Senator Waldstreicher's point, this is the third leg of the stool. The threat of civil liability is a great motivator for industries, and we have seen that to be the case. So having the ability to sue civilly will further incentivize FFLs and manufacturers to act as reasonably and safely as possible. Now, a lot of the things that would count as reasonable controls are already required by Maryland law. Record keeping, for example, background checks. So what we're doing is trying to open the door for victims of gun violence to be able to say, if you're not following this law and you're contributing to gun trafficking or contributing to straw purchasing, then you need to be held liable. And not just maybe the guy who manages your store who's engaging in this might get fired or might get, tried for a crime, but that there is a financial incentive to do the best that you can. In the same way as in other highly regulated industries, this is what happens. Did I answer your entire question, Senator?
Yes, I mean, I think yes, you did. But I think that what's going to be, I think, more clearly expressed in the forthcoming testimony is just the exceptions under Plaka allow for a lot of the exercise of what you just said through state statute and the implementation and enforcement of state statute. And so the question then becomes, why not go that route as opposed to this route?
I think, and I think that some of these laws that exist would actually qualify already as predicate exceptions under Plaka. So that's great.
Yeah.
However, there is to create this law, which kind of broadens it a bit to unreasonable conduct, allows for there to be room for courts to look at something and say, maybe it's not exactly the law that you can't store guns in a window, for example, but we can look at it and say, well, like, hey, you posted on your Instagram all of these guns that were right in the front window and everybody could see it, and you made it really easy for them to be stolen and used in crimes.
And the last question, just real quick, because it's coming. So eight states have had this law on the books. You mentioned New Jersey, which has been upheld. But how many of these statutes have actually been utilized by the Attorney General or any certified right? Because it seems like the New Jersey case was upheld, but it was a pre-enforcement decision.
Sure. Yes.
So we need to talk about that.
Yeah, look, a lot of these laws are pretty new. A good portion of them were passed last year. New York's has been effective for almost 3 years, and the New York AG is, like I mentioned, going after the magazine lock company that made it easy to unlock the magazines. Like I said, none of these challenges, pre-enforcement or as far as I know, post-enforcement have been successful. Obviously, we'll see how that New Jersey case goes and whether the FFL that's being sued tries to challenge the law as unconstitutional, though not, like I said, none of these challenges have yet been successful. But look, it is a fairly new policy. So one way or another, we haven't seen much.
Thank you, Mr. Chairman. I want to associate myself with the chairman's concerns and Senator James's concerns. I inartfully was trying to head down the same road. I've never heard Senator James be more articulate or more persuasive in her articulation of the same concerns. And it is.
Well, yes. Wow.
Wow.
And the concern is simply expressed is if there are problems with our current statute, if guns are being left in windows, for example, which is the only problem I've heard expressed this morning, but there may be others, why start a long process of lawsuits, which can take years to resolve to find out what the problems are? We can solve those problems right now by amending this bill in such a way to incorporate those problems in this bill. We can pass it next week in the Senate. They can pass it in the House. We can have it a law quickly. Why don't we do that instead of what this bill's trying to do? Could you explain that?
I'm happy to also give you other examples of unreasonable conduct.
Give me the other examples.
Sure, I will definitely do that. I think another example would be security over inventory. So in the back, you know, it's easy to break into the back door, not keeping appropriate records. I think that it would be difficult to legislate every single thing that could be unreasonable. And that's why having this reasonableness standard makes sense in this case.
Well,
and I understand
there, most of these gun shops are pretty small places. We're not talking other than what's the one out in the mall, Rundle Mall, the big one.
Bass Pro Shop. Maybe?
Bass Pro. Other than that, which is massive.
Sure.
Most of these gun shops are pretty small.
Yeah.
I don't know why we can't check on these gun shops and try to find any situation in which a problem could occur and legislate to protect that.
In my opinion, I believe it would be difficult to fully legislate all of the potential circumstances in which that would not be true. For example, whether it's unreasonable to sell a gun to somebody who shows up muttering to themselves about their coworker that they don't like and they are seeming angry. A gun store should be able to say, they should make the choice to say, we're not going to sell to you today. And that would be something that would be difficult to legislate perfectly, but would be a circumstance in which a court might say, this was unreasonable because of all of these things. And I do want to address your concern about civil litigation. I think that you're right. It may take some time to have some verdicts under the statute. We've seen though,
Plus
Washington, for example, already had a $3 million verdict and their law is only a couple years old. And also, I think that the purpose of this law is to incentivize reasonable conduct, cautious conduct, safe conduct by FFLs, right? So it's not necessarily that they are being sued and that they're going to lose money, but that the possibility exists. So they want to create the smallest potential for getting sued and having to engage in that process at all.
Okay, thanks for your answer. Mr. Attorney General, can I ask you a question? Right now, if there are problems with gun dealers in Maryland, aren't you capable of indicting the gun dealers for violating the laws?
I have authorities, some by the General Assembly, some by the governor, where I can enforce certain criminal laws. I have authority. It's a 13-page letter I had to send to the governor last year to get authority. So I can't recite all of them to you off the top of my head. So sure, I have criminal and certain civil and consumer protection types of enforcement authorities over a lot of businesses and a lot of individuals in Maryland. I do not have authorities today, though, that can provide compensatory relief, right? To seek restitution on
So,
behalf of Marylanders in this space.
so if a gun dealer is not complying with the existing law, for example, keeping his inventory inadequately so people can come in the back door and just take it, you would have the right to go in and indict the gun dealer for failing to follow existing Maryland law in that respect, but you don't have the right to bring a civil action against the dealer for damages. Is that what you're saying?
No, I'm not standing here today telling you that I have the authority to investigate, indict, and prosecute a firearms a dealer for not maintaining regulatory compliance. I'm not standing here and telling you that. I would really have to look at my authority. We have not brought that type of action as Attorney General. And I don't want to guess whether I have it or not, but I have limited criminal jurisdiction. I have a limited criminal jurisdiction. State's attorneys have broader criminal jurisdiction, and a lot of these regulatory violations are actually, and I'm not suggesting this one here, but a lot of regulations are inspected and investigated by different departments, Department of Labor, Department of Environment, et cetera, Maryland State Police. Some of them result in civil penalties and not criminal penalties. Some are in criminal penalties, misdemeanors, some felonies, very few felonies for regulatory violations. So I can't stand here today and tell you that I could go and investigate and seek an indictment.
Well, let me ask you this. Would you be unhappy? Would you be opposed to a bill that would give you the authority to investigate gun dealers, and if they're not complying with Maryland law, indict them and go after them for civil penalties?
If you're asking me if I would welcome that in lieu of Senate Bill 488.
No, that's
okay. I just want to be clear. I just want to be clear
in the
how the
abstract,
answer.
in the abstract, would you be unhappy if we were to pass a bill giving you that authority?
What I'd like to do is work with you on that bill to see whether that's because we're talking about Senate Bill 488, and I want to stay focused on this. I mean, I understand your concerns, and I'll work with you and any member on additional regulations or statutes, enforcement, et cetera. But today we're focused on, and I'm limiting my testimony to really to civil liability actions that I can bring and that Marylanders can bring on behalf of their families.
I understand it, but if this bill, for whatever reason, shouldn't pass, I would be willing to sit down with you over the course of the interim and work on a bill for next year, which gives you the authority which you have not said you would oppose in this regard.
I would not oppose that. That's correct.
Okay. Along the same lines, though, of your earlier testimony, I'm intrigued by the fact that 95% of the gun dealers are responsible for 90% of illegal recovered guns.
5% of the dealers, 90% of the guns.
That's what I think I said, that 5% of the gun dealers are responsible for 90% of the illegal recovered guns. And all the guns that are sold go through the ATF, isn't that correct? The records, and if I'm a gun dealer, I'm going to sell a gun. I need to do the background search, the 7-day wait, and then the information about that sale and who I sold it to is now maintained by the ATF. Right?
Correct.
Does your office have a relationship with the ATF enabling you, once we find that these guns have been used in a crime and we know what the serial numbers of the guns are, is your office capable of coordinating with the ATF to find out which gun dealers sold that gun or which gun dealer sold that gun? And can you do that for each case in which a gun is recovered that was used in a crime?
There are restrictions on my ability to do that.
Federal restrictions or state restrictions?
Federal.
The federal law restricts the attorney general of a state to get.
It's not my data, it's their data.
It's their data, and they won't let you take a look at it.
I'm saying I have restrictions on it. On what yeah.
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 I think the Baltimore Police Department has the information, but cannot share it with the mayor because of the ATF regulations.
Interesting. Okay, well, that's interesting information. And I guess we can't change that. I guess the Congress has to change that. The U.S. Attorney, okay, well, I'll have to call Eric and find out what's going Because it seems to me that's the way, I've wondered for years. We have all these guns that are recovered in these crimes. Why in the world aren't we finding out where the guns came from, who sold the guns? And if there's a steady stream of guns coming from a single seller, let's go after that seller.
I don't object to that.
Okay, thanks.
Senator West, I can say this, the Attorney General can. So the Attorney General, I think, and correct me if I'm wrong, one of 3 or 4 Attorneys General in Maryland that does not have common law power. So we should work on that. We should change that. I can say it. You can say it. All right. I think Senator McKay, and then was it James? Are you okay? Senator McKay.
Mr. Attorney General, may I please, sir? I don't know if you're having the same recollection that I'm having 20 years ago, you and I debating not guns, but dry cleaning.
Oh, I remember that. Yes. Oh, my goodness. Yeah.
So be prepared.
Just so you know, women were paying more for dry cleaning for similar garments. I put in a bill. I think we call it the Dry Cleaning Parity Act of 2000 and whatever it was. Yes. Yeah.
And we debated that actually at the time, Delegate Cass Taylor, before becoming Speaker Taylor, had actually put in that where Maryland prevents non-gender pricing. So a blouse, while you would think it is a female garment, blouse in the military is used and it does not determine the gender.
That's right.
And so therefore you could not charge a higher price for someone who was a female or a male. So anyhow.
Mr. Chairman, I move favorable on that.
So anyhow, circling back to that New Jersey state example of the lack of security that our friends from Everytown had brought up. It seems that in that New Jersey case, they were going after the gun dealer. My question is, can you, if this was to pass, go after the manufacturer of the gun in that case? Can you, or is there something preventing that?
So let me say that while you're referencing an actual case, for me, as I stand here today in Maryland, that is still a hypothetical.
Right.
And I really would defer to someone who's more knowledgeable with about that case, but it still presents a hypothetical. I'd have to understand the facts in that particular matter.
And may I articulate it a different way? In Maryland, if we had a gun dealer who was putting firearms up, no security, XYZ, someone broke in, stole that. If we pass the Gun Safety Industry Accountability Act of 2024, does that give you the ability to go after the gun manufacturer because the local gun shop did not put in the security of where it should have been?
I would have to look at reasonable controls that applied to the gun manufacturer. Okay, I would have to look at the elements of this, action, this new cause of action that the General Assembly establishes, and I'd have to evaluate. I'd have to look at the facts in the case, and I'd have to apply the law to make that determination. I can't do that now. I don't know as I stand here today, I don't know what the relationship is between the manufacturer and that dealer, what the controls were, what they ought to be. I can't, as I stand here today, I can't answer that.
So following along that line, don't we already regulate in Maryland gun shop security laws? Don't we already do that?
Yeah, to the extent that we have regulations, I mean, the regulations are enforced by in this case, probably the state police or
That's
another
what I'm saying.
regulatory
I
body.
mean, in this case, to take a New Jersey, it would be illegal in Maryland to not be putting in those security, either the bars or the security controls and all that kind of stuff. I think we already have that in Maryland.
Right. But I think this goes back to some of the other questions about how specific can you be in regulation when you're talking about reasonable security, storage, handling of a firearm that's for sale. And as I stand here today, I can't tell you whether in Maryland's regulations, it requires bars on windows, or whether it requires a certain distance away, or whether it requires certain types of windows. I don't know the answer to that. But certainly to the extent that those requirements are in regulation or statute, if they're not followed, then that could be exposure to liability for that dealer.
Okay. And that goes back to, I believe the comment was that you needed this in statute to determine the course of action. And so my question, the reason I asked you those questions is, it would seem to me that while hypothetically, those reasonable controls should be somewhat already defined, and they're subject to open litigation that could be, but you would not. I know you, of a man of character, wouldn't put legislation that would be political. So that's my question. I don't understand how, because we need the statute's course of action, reasonable controls, to me, isn't defined well enough that it couldn't become political.
I'll go back to the sponsor statement that, like, there's an established body of law in Maryland, in tort law, what is reasonable and what is not reasonable. And courts have sufficient experience, litigants do, plaintiffs counsel, defense counsel, on how you make or defend against case of reasonableness. And that's the body of law that litigants rely on, not just if we pass Senate Bill 488, but all the other activity that's already occurring in Maryland. I mean, for all of the questions that are raised about, well, the uncertainty of reasonable and what does it mean, that is already the case in Maryland. This doesn't create that problem. Okay, what it does is it does introduce to the firearm industry the same potential liability that every other industry has. So I get that you'll have opponents to the bill, and the concern is they're entering the world of tort litigation, tort liability that everyone else is exposed to. And many of those other else's, whether entities or individuals, are also in highly regulated industries.
So for that tort reform, and every other industry, is the government part of that? Are there caps on what we can sue the government for?
Look, I'm not following your question.
From a tort reform? Yeah.
Oh.
Yeah. Are agencies under a cap or can't be sued?
I'll give you an example only because you just experienced it or passed it last year. The elimination of statute of limitations in child sexual assault cases. You remember last year, everyone was focusing on private entities that would be at risk. And I think that was because in large part, my office was investigating the Archdiocese of Baltimore. And today, there are state entities that are now defendants in actions brought under last year's legislation that has exposed state entities to the risk of liability because of that. And last year, you also increased the caps on the Maryland Tort Claims Act in those actions. So yes, the Maryland as a state, we could be held liable under the Maryland Tort Claims Act. I'm not under Senate Bill 488 though.
So, however, and correct me if I'm wrong, a dealer actually doesn't do the background check. A handgun background check is actually done directly with the state police by the internet. And if that is true, then with passage of this, why wouldn't then Maryland State Police be charged in this hop, skip, jump of selling a firearm? And how does the Attorney General of Maryland, who is to represent the Maryland State Police and then also represent possibly a plaintiff in this bill, Senate Bill 488?
And the answer to your question probably turns on the interpretation on page 2, line 10, whether or not a court would find that the Maryland State Police was a firearm industry member.
Okay, so they could be then found, it's possible Maryland State Police could be found liable in this case because a judge may figure out that they're the ones that did the background check.
I think exceedingly unlikely.
Okay.
And as their attorney general, I will defend them vigorously.
Well, that's what I'm saying, and that's my
Yeah.
issue. Of
And I will argue
defending-
that the Maryland State Police is not captured by that definition or any other definition of this law. This law is not intended to hold government entities liable for enforcing or the non-enforcement of regulations. We have other means that we use to ensure that.
Maybe I misunderstood you, but because the dealer accesses the state police through a website to understand, to get the background check, that then the Maryland MSP would not be liable?
What I'm saying is that will turn around the definition of firearm industry member. And as I stand here today, I don't believe that the Maryland State Police are included in that definition. And there are many participants, okay, or people or entities that have a role in the background check. And to the extent that a firearm industry member does not meet their standard of conduct in the background check, that could expose them to liability under Senate Bill 488.
Okay, thank you, sir.
All right. Senator Bolden and Senator
My
West.
glasses?
No.
Mr. Attorney General, please, if you could return. So my good friend from Western Maryland brings up a point that I thought was a very interesting, as many things are under the law, an interpretation. And when we're talking about the firearm industry member engaged in the sale, manufacture, distribution, importation, the part you referenced, is MSP not a part of the sale process because the sale cannot happen without their authorization? You have to get your double negative email 7 days after your request that says you are not disapproved.
I
does that not make that
don't
part?
believe that the Maryland State Police is subject to liability under Senate Bill 488 should it become law.
Okay, thank you. And isn't it true that your report that verifies the top Maryland dealers are all in compliance with Maryland law?
My report, help me.
You have a report that came out. And I apologize. I've been all over this thing.
Just for the other answer for the MSP, I mean, I have a bill that's coming up that deals with gun buybacks in Maryland, and we dealt with this question of what, sale is or facilitation of the sale, and like running a background check is not considered to be part of the sale or facilitating the sale. Just as soon, same as like having a UPS truck.
Well, that was my concern
Ship
also.
some of these things down here. It's not considered to be,
They're not a part of it.
no. So.
Okay. I'm not seeing that right now, Mr. Attorney General, so but I want to make sure that we're clear on the regulated firearm transfers are able to be tracked to the last known legal point of sale. Is that correct?
Say that one more time.
Regulated firearm transfers are able to be tracked down by law enforcement to the last
I can't,
legal.
I don't have enough information or background to be able to answer that question. I'll have to follow up with you on that.
Okay. Okay, thank you.
Thank you, Mr. Chair, and I'm sorry to impose the third time, but because of the colloquy between my good Senator McKay, and the Attorney General, I now have another question. I wrote down what I thought your answer was to one of his questions, and as I wrote it down, it says, you said, everyone else is subject to the same tort liability that this bill imposes on the gun industry. Did I correctly write down what you said?
What I intended to say is that as the sponsor of the bill introduced in introducing the bill is there's that three-legged stool, right, of administrative or regulatory compliance with laws and regulations. There's criminal oversight for certain conduct, and there is civil oversight, if you will, or exposure liability, the tort system. And my comment was to suggest that there are many industries that are exposed to tort liability, not necessarily Senate Bill 488 or public nuisance type of tort liability, but different types of tort liability.
Okay, well then can we agree that in your normal garden variety tort case, punitive damages are not part of the judgment, correct?
That's right.
And attorney's fees are not part of the judgment, correct?
I can't answer that.
Well, I think trial lawyers will tell you that under ordinary circumstances, if they're bringing a tort case, they cannot recover attorney's fees.
Right, but I should also point out that in many of the cases that I bring as the Attorney General, I can bring penalties. I can ask for punitive damages.
Yes, but you're not bringing garden variety tort cases. And then my final point was in your normal tort cases, the standards are negligence and proximate cause, neither of which is part of this bill, is it?
In this case, in this
bill, 488.
Not every tort has the same elements of the cause of action.
So this bill, 488, creates a new class of action, which is not the same as the ordinary negligence tort action.
No, not a new type of claim. It doesn't bring your standard, perhaps negligence claim. This is a public nuisance claim, and there's a knowledge component to it. There's a causation component to it. There's a harm, and those are elements that you'll see in most, if not all, torts. But that doesn't mean that this is a negligence action.
Okay, fine. Thanks.
Thank you so much for sticking with this here and asking these questions. I forgot to ask this one question, and I don't think you can answer it completely here, but I do want a response, particularly from the Attorney General. It just struck me that this whole scheme, in addition to violating the spirit or intent or the way PLACA is supposed to work, or undermine it in a way that we could have congressional backlash, which might change PLACA in a way that will prohibit this from going forward in the way we've done it, as opposed to the way we're suggesting we redirect your efforts. The other concern I have is that I think there is an argument that this will fly in the face of Bruin. Whether you like Bruin or not, and I'm not particularly a fan of the decision, it is the law of the land. And I think that while you can try to argue to me and in this body at this moment that this is all about negligence or some cousin to negligence, in the end, you may be getting into a way in which you are regulating or making it more difficult for law-abiding citizens to engage with firearms. I just say that because not here, but I would like to have some thoughtful response from you all about how you view this will be reacted to in the context of Bruin. And I would note that in all the other states, we only have 1 year worth of these bills being in existence. And you all should respond if you know, and I'll certainly ask others. I imagine one or more of these statutes will be challenged. and go up to the Supreme Court. So I worry about us spending needless money and expense while we have at least 8 opportunities for the federal system to take a look at this sort of new statutory scheme and look at it in the context of constitutional challenges. But if you all could later on get back to me on your analysis of how this fits in with Bruin, I would appreciate it.
Can I just, in response to that,
I'm just
you're
trying
going to
not to
hear a
make it
lot of,
too
you're
long.
going to hear a lot of opposition to this. You're going to hear Bruin's second.
I'm
Amendment.
asking for myself,
Right.
sir.
But I will
So,
say this, I'll
for
give you,
me.
yeah.
Okay.
By way of like just comparison, right? So this is, last year, Anne Arundel County, or perhaps the year before, they passed an ordinance that required gun dealers to provide information at the point of sale about suicide prevention. Why? Because there's a correlation in between, firearms and suicide. Firearms is the most used method of suicide. And that was challenged, right? It was challenged on all sorts of grounds, including Second Amendment grounds. And today that is surviving at the Fourth Circuit. Like it survived the district court challenge. It survived the Fourth Circuit challenge. That is regulating, if you will, loosely speaking, not the individual's right to purchase the firearm. There's no restriction on that. It's what the dealer is required to do. So there are, and this is not, the Senate Bill 488 is not a regulatory bill. We're not imposing regulations, but it's impacting the sale, not the use or possession of a firearm, right? In that case, we argued it's not a Second Amendment issue. In fact, the arguments that were made was that it was a First Amendment issue, requiring dealers to provide information or speak to in the marketplace about suicide, and they didn't want to do that. So I would just say that Bruin was decided on Second Amendment grounds and the analysis of the Second Amendment. There are actions that we take that may impact the firearm industry, and they don't all trigger Second Amendment.
I agree with you, but there's a huge difference, huge, in putting out a pamphlet about suicide and opening up an industry to lawsuits that could bankrupt them and put it all out of business. I'm sure people want that. I don't have a particular, I'm not taking a position on that. But what I'm bringing up is very salient and not here, but I would like to hear your feedback after this hearing, because I don't think what the example you gave has any impact on the bill that we have before us. Thank you, Mr. Chairman.
Just want to follow up, Mr. Attorney General. So the report it was your report from the Maryland Firearm Crime Injuries, Fatalities, and Crime Firearms Study report that you had issued, I believe, in 2022. Or 2023. I don't know. I think the report came out in 2023, but it was during that time period from August of 2020 to July of 2021. And you noted that on page 26 of that report, the top 10 Maryland retailers have recovered firearms, and you listed them out and the number of firearms associated with them. And then the report goes in very great detail about each individual firearms seller. And at the end of each one of them, every one of them, that there was a dealer audit done, conducted in compliance of the audit, and that at the end, every one of them closes out that the auditor found the dealer correct and that the audit was satisfactory with no further action recommended. So in this situation, you have reports by your own office showing that the gun dealers were in compliance. The audit found them in compliance, but these guns fell into otherwise illegal hands. So I'm not sure that we agree on the connection of how they're getting there. But to hold them, there we have the top 10 dealers in Maryland that had the highest number of guns. And I wanted to give you an opportunity to comment on that if you have any, because it's contrary to what I believe this bill asks for.
Well, not every unlawful use of a firearm is attributable to the action of a dealer. And no one's suggesting that.
This was the recovered firearms, sir. I apologize.
Oh,
Maybe I didn't make that
Yeah.
clear.
I think probably the best thing for me to do really is to, I don't know when that report was released,
I
and
believe it was last year, but
yeah, and dated before I was Attorney General. I know that our office
Perhaps.
doesn't do the inspections themselves that are reported there, so I really have to work with you, take a look at that report and get you the answers.
okay. I
to
just
that
want to make you
question.
aware of it. It's
Yeah.
the reporting period from August 2020 to July 31st, 2021. And on page 26 is the
Yeah,
specific.
and what was the
area.
date of the report? Yeah.
It looks like it came out last year when I look at it. It says. When I'm looking at it, it looks like it came out last year, but that's the reporting period.
Sure.
So
Okay.
thank you. If you can get that, I appreciate it.
What he's really squinting at is the proximate cause and intervening causes, which is what you were talking about earlier, but. All right. Thank the Lordy. We are done with this panel. Thank you all very much. Thank you to the sponsor. Thank you, Mr. Attorney General. Thank you, Ms. Knopf. Thank you. All right, we're now going to move to the opponents of the bill, and we'll hear from Mark Schneider and Mark Pennick.
Thank you, Mr. Chairman. Mark Pedant, President of Maryland Shall Issue. I'm an attorney licensed in Maryland, and I'm an expert in gun law. And indeed, PLACA. You have before you my 18 pages of single space written testimony detailing all the problems with this bill, just the legal problems, not the policy problems. So what you heard from the sponsor and from the Attorney General today was that this bill is designed to bring gun dealers and manufacturers and distributors and sellers and marketers into the same status as you find everywhere else, all other industries. That was exactly the problem that motivated Congress. And Senator James, you'll see this in 15 U.S.C. section 7901 A8, precise finding that regulation by litigation was abusive. Was an abuse use of the courts. And that's what this is. By defining the predicate statute to include not only illegal actions, which you're all in charge of, right? You can make anything illegal you want, pretty much. But also completely undefined, unreasonable actions. No definition. And how is it defined? Well, they told you right up front. We'll define it on a case-by-case basis by litigation, precisely the abuse of the system that Congress was intended to prevent with the enactment of PLACA. Yeah, is PLACA unique? Absolutely. And why? Because it was the courts were being uniquely abused against the gun industry, against the lawful commerce that the gun industry was engaged in. So if you want to make something illegal and thereby satisfy the first prong of the PLACA, the predicate exception, make it illegal. It's that easy. And you can have a civil liability. So I see my time has expired. I'm happy to take questions.
My name is Mark Schneider. I'm the Vice President of the Maryland Licensed Firearm Dealer Association. Our organization takes issue with this bill. The presumption that licensed firearm dealers harm the public through the legal sale of highly regulated and constitutionally protected products is untrue. Our organization opposes SB 488 as it threatens our members' ability to stay in business. And data does not support the claim that Maryland licensed firearms dealers are the source of the reckless and illegal actions of criminals. We are a highly regulated industry, abiding by both federal and state statutes governing the sale of our products. Licensed dealers do not sell firearms to the criminal market. As you know, there are severe criminal and civil penalties for doing so. Somebody mentioned 5% of dealers are selling to 90% of or 90% of the guns are making their way to the criminal market. Well, if that was true and the government knew that, there would be an audit and that company would be put out of business and charged. And if they're not, then the government's not doing their job at that point. Vague terms such as reasonable controls and unreasonable under the totality of the circumstances are not defined or clearly explained and thus unacceptable terms. We heard earlier that these terms are used in other parts of law. Well, if we can't understand them, how do you expect us to follow this? You can't pass a law that only attorneys can understand and expect compliance. Due to the vague terms in this bill, it would open almost every licensed dealer to frivolous punitive litigation. It would make it impossible to obtain insurance, which we need to stay in business. Licensed dealers should not be held liable for the legal and lawful sale of firearms to law-abiding citizens. Those who commit illegal acts with firearms should, and we support stricter penalties for those who illegally use firearms. I request an unfavorable report.
Thank you. This legislation isn't about criminals that you're talking about, right? This is about gun manufacturers and industry folk. The gentleman who last spoke.
Yep.
He's the one that talked about criminals. Am I correct?
I'm sorry, what was the question?
You said that in your testimony, you were talking about lawbreakers and the like. But this, and I'm assuming when you're talking about lawbreakers, you're talking about individual criminals but this is about firearm industry members. And on page 3, line 2019 through 23 is talking about firearm industry members who have engaged in unlawful conduct. That is criminal, correct? It is unlawful is criminal.
Would be, yes.
So would you have a problem with that?
No.
Holding criminals accountable?
No, not at all.
Okay, thank you.
Thank you, Mr. Chair. Mark, can you come up to the podium, please? So we've heard a whole extensive line of questioning. I just wanted to kind of round them up a little bit because you're probably a little bit more articulate and versed on some of these items, much more so than I. So I wanted to ask, there was the sale of the firearm, the regulated firearm transfers are able to be tracked down to the last known legal point of sale. Is this by law enforcement?
Oh, yeah, absolutely. The ATF can track down to the dealer who sold it by serial number, and that's the trace. They do that all the time.
And that's any legally transferred firearm can be tracked down by that method.
Oh, absolutely.
Okay. And obviously we're all about, you guys up here today, we're all about responsible gun ownership. We want responsible gun ownership, which kind of likens to my good friend from Baltimore County, who's, about holding those accountable that are the bad actors, because I heard about bad actors earlier.
Absolutely.
But this bill talks about the bad actors being through the legal commerce of selling firearms.
What this bill permits, because it's not linked to even any proximate cause requirement, and you heard it from the sponsor, people who are victims of gun violence will be now permitted to sue under this bill. When established law and PLACA itself says, no, you can't do that because those lawsuits are abusive and have been used as abusive. So the whole point here is to prevent people who are victims, and my heart goes out to them, but whose injuries are not the proximate causation of the harm by the sale of the firearm or the manufacturing of the sale or the marketing of the sale. Proximate causation is actually written into the text of the PLACA itself. So the only place where you see reasonable even mentioned in PLACA as a standard, otherwise it has to be a knowing violation of an existing law. You can't have a knowing violation of existing law that's undefinable, which is what foreseeable is, especially in a bill that doesn't even define it. So but where reasonable comes in is a violation of two laws in particular. 18 U.S.C. section 922G, which is a list of prohibited persons, and section 922N, which is a person under indictment. So those are the only two where Congress said you have reasonable cause to believe is the purchaser is involved with those two elements. Everything else has to be a knowing violation. What knowing violation means in this context that you knew it was illegal and you did it anyhow. Now, how in the world can you know something's illegal if it's merely foreseeable or if it's merely unreasonable? You can't possibly.
And that's
the very point that the district court in the NSF New Jersey case said was violated by PLACA when this requirement that it would be unreasonable. It's exactly the same language, by the way. It's on point. Now, the Third Circuit did not touch that merits ruling. It reversed it on purely standing grounds. So that's the only adjudication to date was actually addressed that language and found it unlawful under PLACA. So you have a case on point. And all these statutes that they're talking about, all 8 of them, are uncurrent challenge. The second, the New York statute was just orally argued in the James case in the Second Circuit on the 3rd of November. And I invite the committee to listen to it. It's very informative. New York's going to lose. And
that's why I wanted to bring that up, because I had asked that specific question that you bring up about unlawful, which is a clearly defined standard.
Yes.
Versus an unreasonable, which is a very objectionable standard.
Well,
it's an objective standard.
Unreasonable in the totality of the circumstances. And I'm fine if you had a list of things which were objective, say this is unreasonable.
Sure.
Okay.
And it's defined.
Now, at least you know. But this statute doesn't do that at all. And indeed, it reaches to products that are merely foreseeably possessed in Maryland, which covers the entire country. Certainly our neighboring states. So that is Maryland reaching extraterritorially into the business of other states. And Senator James, if you look at the congressional findings under 8 and 9, you'll see one of the very purposes of this was to reject this sort of intermeddling into the business of other states because it's a violation of this interstate comity. So the very purposes are outlined in 7901. This statute violates. It's the whole purpose here is to reach extraterritoriality into the business of other states who may regulate firearms differently. But this now will allow the Attorney General and the New Jersey Attorney General and New York Attorney General have done precisely this, reach beyond state boundaries to regulate outside their boundaries. Now, there's a huge commerce problem with that, Commerce Clause problem, and it's outlined in my written testimony. So you're not only going to have to say a Second Amendment problem and a PLACA problem, you're going to have to face a Commerce Clause problem and a vagueness problem and a Due Process Clause. They're all outlined. So good luck with that.
So I wanted to, and I just wanted to comment on one last thing or have you comment on it. Do the gun dealers already have the right to refuse to sell to someone at point of sale?
Sure, as long as it's not for a prohibited reason.
Correct. And so I had a little bit of a concern when the one young lady came up and spoke about that someone was in there talking about they were angry with a coworker or whatever it was. It was such a vague standard, a vague statement, but then that implies, and it's very misleading, that now we want these people at point of sale to be basically mental health evaluators on someone's mental status at the time of sale.
Exactly. And not only in Maryland, but nationwide.
Yes.
So the Attorney General, by the way, this statute, this bill does not require that the harm even occur in Maryland. Statutorily, it's just a public harm somewhere.
Okay. Mr. Pennick, I appreciate you coming out today and thank you for answering my question.
Thank you, Mr. Chair. I think it's only fair to give you a few minutes to, in light of the fact that the proponents of this bill were up here for about 2 hours, you have a chance for a few minutes to talk about your concerns. So let me sort of direct you in that regard. Firstly, we got into this conversation about the ATF and the information it has about guns which were used in crimes, because they're all sold and registered with the ATF, and the registration on the gun, the license number is registered with the ATF.
Not quite, Senator.
Okay, go ahead.
So the way the federal system works, and this is by federal law, by the way, the federal FFL has to keep records that provides a link from who he sells to, which the ATF can then go to the FFL and say, who did you sell the serial number? So let's say they recover a gun on site X. They go to the manufacturer and say, well, manufacturer, who did you sell that gun to? Manufacturer says with his records he's required to keep, says I sold it to dealer X. And the ATF goes to dealer X and says, who do you sell it to? And he consults his records and says, I sold it to individual A. And then they can go to individual A. Of course, by that time, at that point, the trail may be cold. That individual A may have lost it, it may have been stolen from them, who knows?
But if dealer A, dealer X is selling gun after gun after gun after gun to individual A, and those guns are consistently showing up as having been used in crimes. Now, so that's my concern. Now, and that was the hypothesis projected here. Does the Attorney General of Maryland have the ability, knowing what the serial numbers are of the guns used in crimes, to go back and get that information and then investigate individual A who has acquired gun after gun after gun, which are being used in crimes?
So this goes back to my old clients at the ATF when I was at Department of Justice. The ATF regards that information as law enforcement sensitive information, which it obviously is. It is exempt under FOIA. It is, and they may or may not choose to share it with other law enforcement agencies. They won't share it for civil reasons. So that's an ATF call. Nothing you can do.
We can't change that.
Can't change that.
We can talk to our congressman and get them to change it, but we can't change it.
If they want, they can.
Okay.
But I mean, this body can.
It just
because
sounds
it's
so
a federal
strange that
agency.
in light of the violence with guns in this society, that law enforcement cannot get that information in a way which would allow individual A in our hypothetical to be prosecuted.
And Baltimore's trying to do that, and Baltimore's failed for that very reason. So what the ATF can do as a matter of enforcement discretion, they have enormous power over dealers. They can shut them down. Is they can go investigate the dealers and make sure that they're complying with every dot and title of what they're required to do. And if they're not, then the ATF can very aggressively, and they have, shut that dealer down.
Okay, let's come to this bill, this specific bill. Now, you heard Senator James earlier with her very eloquent colloquy on this issue, and my far less artful colloquy. So the Maryland laws, as are set forth in the fiscal note in this with respect to this bill, go on and on and on with all sorts of requirements for dealers to comply with when they're selling guns. If we're missing some, wouldn't it be better for us just to add some more legal requirements that the dealers have to comply with, rather than set people at work suing, involved in years-long lawsuits in order to try to establish that some requirements should be there?
Absolutely. And that would at least satisfy the predicate exception. And I'll give you an example about the guns being shown in the window. Right now, that's illegal in Maryland, because this body passed HB 1021 a couple of years ago, requiring secure storage of all firearms.
And that was the only, for instance, that I got when I asked questions about what are we complaining about here. The only, for instance, I got two. I got the gun in the window concern and the inadequate control of inventory concern.
Both of those are covered by 1021 and other regulations.
And take guns. Does Maryland law currently control inventory?
Yes, the Maryland State Police have a lot of control, because almost all these FFLs are also state licensed dealers under the state law. And they require, and this body did in 2013, impose additional record keeping requirements with the Firearm Safety Act of 2013. And the Maryland State Police was the agency charged with enforcing it, and they do, as every dealer will tell you. Of course they do. And what was more chilling about the testimony I heard is that they want to reach across state lines and say, well, you didn't train your individual to look for signs of mental disturbance, and therefore you, the dealer, are going to be liable for the misuse of a firearm in Maryland. That's very chilling. Now you have no idea what you're supposed to do with respect to training. But after the thought, and by regulation by litigation, you're now going to hold an out-of-state dealer responsible for his failure to train an individual to look for a psychosis. Wow. That's the industry-wide, nationwide regulation of the firearms dealer. And of course they object to that. No one's objected to that. No other industry.
All right, let me just conclude by focusing on some of the terms in the bill. The term reasonable controls in the bill, and the other term unreasonable under the totality of the circumstances. Now, you cited a Fourth Circuit decision. By the way, Maryland is in the Fourth Circuit, so those decisions are binding on Maryland, dating from 2006, which said a statute is impermissibly vague if it either, one, fails to provide people of ordinary intelligence a reasonable opportunity to understand what conduct it prohibits, or two, authorizes or even encourages arbitrary and discriminatory enforcement. In your view, are those terms in this bill reasonable controls and unreasonable under the totality of the circumstances? Do they pass muster under that Fourth Circuit decision?
No, and they don't pass muster under Article 24 of the Maryland Declaration of Rights, which imposes the same requirement. That's the Galloway decision cited in my written testimony and has been affirmed over and over and over again by the Maryland courts. This allows the Attorney General a carte blanche to go in and say, well, I think this is unreasonable, and I get to litigate this. Well, that's death by litigation. It's death by 1,000 cuts. That's precisely the harm that Congress wanted to avoid.
And finally, I talked to the Attorney General about whether or not this is just imposing normal tort liability on gun dealers. Normal tort liability does not include attorney's fees, and it does not include punitive damages, does it?
That's correct. Now, that's right. There is a possibility for punitive damages in certain limited circumstances. The Attorney General was right about the limited circumstances. What tort liability does require, and I refer you to the Valentine case cited in my written testimony, that the harm that's being suffered be approximately caused by the violation that you're complaining about. In that very case, there was a break-in of a dealer, broke through a window, grabbed the guns, and those guns were used in a crime, tragically. And the Court of Appeals, the Supreme Court now, held that the harm was not proximately caused by, even though it may have been foreseeable, because it was an intervening criminal act of the person who committed the crime. That's the law of Maryland. That's the proximate causation cause of Maryland. That's going to stand as a barrier to proximate causation under PLACA as well, because PLACA incorporates the law of proximation expressly in its statutory structure. So you cannot abolish proximate causation under PLACA.
Great. Thanks very much for your answers.
Thank you. I'm going to ask you a few questions that I asked the other side, so and you again can get back to all of us with the answers, but I want to just confirm, and I see this often when Maryland puts in a bill, some legislators put in a bill, they rush to tell me that some other states have done it. But I think they failed in this case terribly by not being honest about or accurate about the fact that the states were this just happened. And I want you to let me know, I assume that in every one of these cases, you know, everything moves slowly too, so it takes a while, but in any event, I assume that, and you can confirm or not, that they'll be challenged in every state.
They have been.
Okay, they've all been challenged.
Everyone.
And do you represent to us that those challenges will keep going up to appellate level until?
Well, indeed, there's one now in the James versus New York case, which was just yes, ma'am, who's just argued, but in the Second Circuit, and the citations in my written testimony.
Yeah.
And I encourage you to listen to our arguments available on the Second Circuit website.
But do you anticipate that one of these will ultimately, I assume, get up to the Supreme Court?
Oh, yeah.
The effort will be there.
Absolutely.
So,
I guarantee you that.
So just like in the Bruin case, Maryland could certainly have jumped in before and tried to defend our own statutory scheme on how we, left discretion to the state police as to whether, to issue guns. The Bruin case went ahead and told us and the 5 other states what the law of the land would be. And I think what you're saying is that with these 8 states, there'll be one that emerges to help inform us of how to proceed in the context of marrying the PLACA statute with our own intensely justified interest in lowering gun violence in this state.
I think the state certainly has an interest in addressing violent crime in the state,
Exactly,
whether
yes.
with guns or not. I don't think the state has a legitimate interest in discouraging the lawful purchase of firearms, because that's the Second Amendment right. Certainly, you can't suppress the ownership or the purchase of guns just for that reason.
No, but the proponents of this bill, and I am with them, want to bring down illegal guns, bad actors, crime and murder. We're all sick of it.
I'm all in favor of that.
The question is whether this is the approach that will be effective and also withstand the strictures of the Supreme Court, the Second Amendment and PLACA.
So I virtually guarantee you that if Maryland passes this, it will be challenged. Every one of these bills has been challenged. The Second Circuit is probably going to reach the merits of that first, because the New York statute is probably the oldest of these. This ordinance, this bill is modeled after the New York statute. You'll get a decision in James from the Second Circuit probably within the next few months. And if the plaintiffs lose, they'll take it up. If the state of New York loses, they'll take it up. So yeah, we're going to have some resolution of this at some point. But I got to tell you that nothing in PLACA that I've ever read or has ever sanctioned or allowed, no court decision, as a predicate statute, a statute that simply makes the conduct unreasonable.
And just two more questions, again, trying to ask you sort of the same line of questions I asked the others, the proponents of the bill. I'm looking, and I'm going to read every bit of your testimony as I will the other side, but on, this may not be numbered. Let me see. Oh, no. I think it's on page 8 of 18 of your testimony at the bottom. It seems to me what you're making very clear to me is that PLACA requires this predicate exception, and clearly states that there has to be included a knowing violation, and then you have to go on to talk about approximate cause of the harm for which the relief is sought.
Correct.
As I read the statute as drafted, that proposed, it really fails on the face of it. If you just read this statute, it does not comply with the requirements of the predicate exception.
I could not agree with you.
Clearly laid out in the statute. So on its face, putting aside the merits,
yes,
it's just not written properly. Is that
Oh,
correct?
this statute bill is very badly written. I mean, it doesn't even require that the harm occur in Maryland. It violates the due process clause in the reach of jurisdiction by saying that you nearly be foreseeable that a firearm put into the stream of commerce comes to be possessed. Now, just on reach under the due process clause, that's invalid. I'm giving you a citation.
So, I mean, even if we wanted to do something in this area, we have not followed the very clear and concise instructions under PLACA. And I assume that the other thing that I brought up earlier, if we would to take a statute and list very definitively and clearly what we expect and tolerate or want from gun dealers and gun manufacturers, this is how you store them. This is how you do this. And we're very clear about it, not with vague terms like, knowing or reasonable controls, neither word which I have any understanding of in this statute, what that means. But if we were to say, you do not put your guns in a window without bars, if you do not do this, this is how you train your employees. This is how you do this. If that's what we did, if that's what this statute was, we would have a colorable statute that might survive a PLACA challenge.
But what you could do, even under that, is allow liability for harm that wasn't proximately caused by the violation.
No, clearly we left that out of the statute.
Right.
And clearly that's required as well. So that again would be something we'd have to add into a statute.
We're okay with that.
Right.
We want a clear field, knowing what we can and what we can't do so we can comply.
What I want is an effective strategy for helping bring down gun violence. I don't want a statute that does not meet, obligations that we're well aware of. The last thing I want to ask is, it's a stunning thing and it does bother me. And I think it bothers everybody in this room, this statement that 5% of gun dealers have sold 90% of, give me just a moment, I gotta find this. I think the Attorney General's. I'm wondering if you're familiar with this. 5% of gun dealers are responsible for 90% of the recovered recovered crime guns.
That's
When I
very
read that,
misleading.
that immediately tells me, you know who they are. And you you're either implying that the gun dealers are the ones sort of engaged in unlawful illegal activity. And if you do, I don't know why we're not going after them and shutting them down, but that is was used, it was highlighted. What's your response to this number? What does it mean? Is it
So
accurate?
there's a lot of things about that statement that are misleading. First, the ATF doesn't do gun traces on every gun found on a crime scene, not even close. It's a tiny percentage. So that's already skewed, right? So, and the fact that the dealer came from him eventually doesn't mean that the dealer did anything wrong, because it could have been stolen, transferred multiple times since the dealer did a lawful sale.
Okay.
So there's no way for the dealer to control that. PLACA prohibits him from being held to account for that. If he's otherwise in compliance with the whole host of state and federal laws that govern that sale, he's blameless. PLACA says so.
Well,
So the idea that you could focus just on that number and think that, well, these dealers are obviously culpable is wrong statistically and factually. But if there is a problem, the ATF has all the tools it needs to bring those people down and put them out of business.
Well, have you read anything where the ATF said, yes, this data is very helpful. This shows us we've got a problem, but gosh darn it, we don't have the time, or we're not interested in
No,
going after these
no.
terrible gun dealers. Because by the way, that's their obligation. That's how you bring down gun crime and gun violence. So, because what I feel like is people are relying on this statement. And yet when I ask about, well, why aren't we doing anything? I'm not getting a satisfactory answer. So either this data is misleading, it does not stand for what it's being put out there for, even in the Attorney General's opinion, or there's a problem on our end, the government's end, in going after bad actors.
I will say you the ATF right now, and they're my old clients, they're part of the Department of Justice, is very aggressive with the dealers right now. And particularly under the current administration in the White House, they're even more aggressive than used to be. So they have all the tools they need to put dealers out of business who are violating federal or state laws.
Here's the last thing I would ask for you, and not in this hearing, but I would welcome, since you are an expert in this area, to give me a list of some possible additional language that we could put into statute to help, bring clarity to what we expect in this area that we aren't already legislating in. And at least we could take a look at that, I'd be very interested in some help in that
So
regard.
Senator, I would love to do that if I could think of anything, but this state is among in my view, at least the top 3 in terms of the gun regulations nationwide that it already imposes.
Well, for example, the lady from everywhere said, in addition to the gun, the windows, I remember the other case, Senator West, it was that they had sold a magazine, but on their website or in some social media way, they were advertising instructions on how to manipulate that magazine or remove it and put a higher volume magazine, which was directly in violation of New York law, and that is what they're being sued for. So I don't know if in New York that was already illegal, or
It is in Maryland. Absolutely. The dealer can modify a high capacity magazine, but it has to be a permanent modification which cannot be changed.
So in the examples that everywhere gave, and I know it wasn't exhaustive, it's not fair, but the 3 examples they gave, we already prohibit that.
Everything that I can think of, you already prohibit.
All right.
Now, that said, I mean, the General Assembly never ceases to amaze me in what they can come up with every year, but it's just about as complete as you can get.
All right. Thank you, Mr. Chairman.
That was a good dodge there. But I knew you weren't going to give us a list of things we should put into statute. All right, just real quick for the members and for the people watching. Yeah, I know it's well past lunchtime, so some members are going to be rotating out to get some food and handle other business. For people to understand that and bear with us. Wink, wink, nod, nod. Going all at one time. We gotta keep form, but Senator McKay, go ahead.
Chair, thank you. Mr. Jaws, Mr. Penick, so this bill 7488, does it include like common carriers who deliver or distribute and then to the dealer?
It includes marketers, to the extent that they common carrier could be construed to be a marketer, but I don't think it could be reasonably construed to say like FedEx or US Postal Service or like.
So I'm looking at page 2, lines 10 and 12. It talks about distribution. So
Distributors, and I think
Distributors.
that means people who are in the business of distributing firearms or firearms accessories and ammunition.
okay,
And by the way, ammunition is not, sales are not restricted to FFLs. Mom and pop stores sell ammunition. They're not federally regulated, nor are they regulated by the states. Mostly because the federal government found in 1986 that the existing regulation of ammunition didn't found in the Gun Control Act was pointless. You regulate the firearms and that takes care of the ammunition. So not only would this apply to FFLs, then you're talking about, can we extend this to the dealers who sell ammunition, because now they're defending people who sell ammunition as part of this regulatory structure. And that's not exact, it's not conducive to federal law or state law.
so it just seems to me that this bill is the equivalent of holding, say, Dell computers, Apple computers responsible of nasty kitty porn or something like that that's on somebody's computer. I mean, it just, the link is there. I don't know where it stops.
See, it doesn't stop, which is why Congress enacted PLACA in the first place. What led to PLACA was the use of the court system to hold manufacturers and sellers responsible for the misuse of firearms, which was those lawsuits were accumulating in such a way that it's threatened to put the industry out of business for lawfully engaging in conduct that federal and state law allowed. So that's what led to the enactment. And this bill basically seeks to recreate the same regulation by litigation regime that PLACA was designed to stop. That's why it was enacted in the first place.
Thank you, Mr. Penick.
A quick question. I'm curious on under current law, when can manufacturers be held liable for their acts?
Well, PLACA sets it out. For example, defective product, they can be held liable.
Okay.
So if they violate an existing federal or state statute, they can be held liable. So for example, in my written testimony, I have a state case just came out of the First Circuit involving PLACA, in which Mexico sued Smith & Wesson, saying that you knew that certain dealers on the Mexican border were selling guns illegally to the Mexican cartels. Well, the court said, well, that states the kind of harm that PLACA was intended to address, because it would be a knowing violation of federal law, and allowed that to go forward. That was on a motion to dismiss, so there's been no discovery or anything. But the court made clear that you have to show that the manufacturer knew that those dealers were in fact engaging in that conduct. That's what this bill doesn't do.
Okay. I appreciate it. Thank you.
Good afternoon, Mr. Penick. Thank you for coming today. Yes or no, Mr. Penick, you testified earlier that you much prefer the scheme created by HB 1021 over the structure created by SB 488. So yes or no, Mr. Penick, did you support HB 1021?
What we didn't support was the bill that originally came out that attached criminal penalties and a lot of very vague legislation. The bill that was ultimately decided by the General Assembly and enacted was very much different than the bill as originally proposed. So we certainly did oppose the 1021 when it was enacted, when it was proposed, and as it ultimately got resolved, it was much, much better.
In fact, Mr. Penick, you personally testified against HB 1021, isn't that correct?
I did indeed.
And in fact, Mr. Penick, what you're saying today now, which is that you supported the final version of HB 1021, that isn't correct. Is that so? Did you urge Governor Hogan to veto HB 1021?
I did.
You did, in fact. And in fact, Mr. Penick, you wrote, and I quote, "This bill sponsored by the Speaker imposes drastic and expensive new security measures on existing firearm dealers in Maryland. As detailed in the attached MSI testimony, these costs will likely drive out of business existing dealers who are almost uniformly small businessmen and women." Did you write that, Mr. Penick?
I most certainly did.
And that was your letter to the governor after the final version of the bill was passed. That's not in reference to the
Absolutely
original
correct.
version.
And by the way, my prediction has borne out. The number of dealers has decreased. Small businessmen have gone out of business. Are they expensive and difficult? Yes. But by the way, I lost. So that is now part of the law of Maryland. And by the way, that is part of the predicate exception that PLACA would now allow. A willful and knowing violation of that law would serve as a predicate statute law. Now,
And now, Mr. Penick, Governor Hogan did in fact veto the bill at your urging. Is that correct?
yes, he did.
And we overturned that veto.
No, you did.
And so, Mr. Penick, not a question. I hope you can see why some of us find it odd that you hang your hat today on HB 1021, which you just claimed you supported in its final version, even though you did not. You testified against it and successfully urged Governor Hogan to veto it.
Senator,
Thank
my
you, Mr.
personal
Chairman.
opinions or
Thank you,
even my
Mr. Penick.
positions on these prior bills have got nothing to do with whether PLACA applies and the predicate exception or not. I lost all my arguments in that bill, although I managed to prevail, and so did the dealers, in getting the bill substantially revised. For example, the criminal penalties were removed. So that made the bill a lot better than it was. And so to that extent, do I still think it had the adverse effects that I told the governor it did? Yeah, it does. And has it happened? Yes, it has. Because you have put out dealers who can't afford that cost. But you still have dealers. So what's this do? Now, existing dealers who can still comply with 1021 are now going to be forced to understand, try to get liability insurance to cover for something that's merely unreasonable without ever defining what the term means. So if you want to create uncertainty among dealers, that's the best way to do it. Because all it takes is a litigation, and the litigation alone will put them out of business, regardless of the merits.
Mr. Penick, I just want to clarify the record here for a little bit of a mischaracterization that just occurred. At any point, did you say that you supported HB 1021, or did you simply say that it was much better in the final product?
I said it was much better. I've never supported it.
Thank you.
All right, seeing no further questions from the committee. Oh. Nope. All right. Thank you both very much. Thank you.
Thank you.
With that, that'll conclude the hearing for Senate Bill 488. Is Senator Quarterman here? There he is. All right. Now move on to Senate Bill 632, Senator Quarterman.
Pull up your picture, you know, pull them up now.
Yeah, how are we going to do it? I was going to do it after. How do I do this here? Yeah.
So I have to, because it's through Zoom, no one has to go through Zoom. I share a screen right here. I'm dropping it. It's like a lot more. View. There you go. And then you can just
How do I go through?
just hit the down or the up button.
Okay. Thank you.
All right, Senator, whenever you're ready, we have some, just for note, just some members just rotating out. We've been here all morning, so folks are just getting something to eat, but they'll be rotating back in.
I'll defer to whenever you want me to start, or if you want me to wait. It's up to you.
Sure, yeah, let's give it a second just
Sure.
for everyone to settle down here.
I don't blame them.
All right, thank you, Chair Smith, Vice Chair Wall Striker, members of the Judicial Proceedings Committee, for the record, Senator Paul Quarterman, District 2, Washington and Frederick Counties. Thank you for the opportunity today to present Senate Bill 632, Peace Orders, Visual Surveillance. Senate Bill 632 will authorize a person to petition for a peace order and to be heard in court on the grounds that the respondent is conducting unwanted visual surveillance of an area of a residence where they have a reasonable expectation of privacy. If the petitioner meets their burden in court, the judge would then be able to issue an order to the respondent ordering them to refrain from committing the acts complained of the petition. In the spring of 2023, our office was contacted by a constituent with concerns regarding a disturbing pattern of behavior being exhibited by their neighbor who had recently moved in behind them about 4 months earlier. The neighbor had placed about 12 cameras in an aggressive manner right along the property line, some of which are pointed directly into the constituent's backyard, where their two minor-aged girls tend to their barn and into their yard and play. An area that you would reasonably think there would be an expectation of privacy in. The Washington County Sheriff's Department had been contacted. They instructed the constituent to approach the neighbor and inquire, why are there so many cameras pointed directly into their backyard, particularly the area where their minor children are playing. The constituent approached the neighbor and his simple reply was that was his right to do so. This behavior has continued on for months. Constituent attempted to file a harassment or peace order through our sheriff's department, but then they were informed due to current law, until this man actually harms somebody, there is no recourse that can be taken. Given this information, the family attempted to block their neighbor's camera view by installing metal poles, wooden boards, all around their property line. Some photos we'll go through here soon that we've included. They are uploaded in your testimony as well. They've called the sheriff's departments on multiple occasions. Our office reached out not only to the sheriff's department, but also our local state's attorney's office. Again, similar responses. There's nothing that can be done until an additional quote act has been committed. And to that, we find unacceptable. We understand property owners have a right to place cameras on their property. At the same time, a family has the right to a reasonable expectation of privacy, and this aggressive and intrusive behavior is unwarranted. We understand there may be challenges. The intent here is simply to allow the family to file a peace order so they can get in front of a judge. You can clearly see what is going on here and then adjudicate appropriately. We're obviously not attorneys here. We will defer to the judgment of this committee. We've reached out to legal counsel. We've reached out again to our state's attorneys, our sheriffs. Anyone we've spoken to agrees that this situation is wrong. But again, come back to, well, there's nothing we can do. Our hands are tied. So we come here today seeking a remedy to this situation. As you look on the screen here, this is a picture here of some of the property. So what's highlighted here to the right, the one on the lower, that's actually the property line. The one that's a little higher is one of the cameras on the tree. So it's not like this individual has cameras up on their house where traditionally people have cameras to, make sure no one's getting into their house. They are as far away from their house as possible, looking right into the neighbor's yard. This is said neighbor. He is putting a board in a tree limb with a camera that looks over top of partition boards there, again, to look into the backyard, again, where these two young girls here behind me in their yard. Again, more pictures of the board showing the aggressive manner was moved around. Here's a camera that was lower here at one point, and then as different boards partitions have gone up, they've gone up higher in different areas. So this just kind of gives you an outline of the situation we're dealing with here. Again, we appreciate the opportunity to be here today. We would respectfully ask a favorable report. We are open to amendments of whatever way we need to do to try to, if the language needs to be done a different way. We've spoken to the judiciary about this as well. I know they put a letter of information in there. I just want to make sure it's noted it was an informational purpose. They were kind of deferring back to the legislative branch when we kind of explained the situation that was happening. So that's kind of what we have here. And again, appreciate your guys' time here today and look for a favorable report. Thank you.
Thank you very much, Senator. Did Heather, Hannah want to testify as well, or did you?
Sure.
Oh, sure. You can come up to the podium. Thank you.
First of all, thank you for allowing us to come today and to speak. We are in favor of Senate Bill 632 going to law because we have been dealing with a neighbor who has been video surveillancing our property now for over a year with multiple cameras. After talking to police, we found that there was no recourse against this intrusion. Our neighbor built the house on the property that backs our small barn where our 2 children house their 4-H animals. Shortly after he moved in, he placed 3 cameras in a tree line about 5 feet off the property line, facing and pointing directly and deliberately towards our barn. He is able to view them and see our children at the barn, as well as possible hear audio. One camera we know has motion detection because we see a blue light flash when we pass within range. It was obvious these cameras were placed for the sole reason of surveillancing us. We confronted our neighbor about the cameras, but we did not get any indication that they would be coming down. My husband and I decided our best course of action was to block the view of the cameras with plywood and screen material, as you can see here in the pictures. Our neighbor responded by moving the cameras to see around our blockage, forcing us to add more screening. We felt that he was harassing us and our children, yet there was nothing that we could do. Now we no longer send our children to the barn with their animals after dark, and we watch them closely during the day. In talking with others about our issue, we have found that we are not alone in dealing with this similar situation. These people are also found that they have no legal recourse. We understand that almost everyone has security cameras these days, and sometimes they may see a piece of a neighbor's property. This is a clear difference between that and using the cameras for intentionally surveillance against a neighbor. Our story is just one example of why Senate Bill 632 needs to be put into law. Thank you for your time.
All right, thank you. Are there any, all right, Senator McKay.
I messed it up. I apologize. Only one button to push and I can't push the right one. Senator Quarterman, this is for you, please. I just want to get the record straight because our committee testimony talks about the judiciary and they took an unfavorable position, even though the piece of paper is informational white paper. So I just want to.
Yeah, we noticed that. We've reached out to them this morning because our understanding was they were just going to not take a position. It would just be informational only because the letter clearly says when it's, but how it was uploaded. Yes, we were aware of that and we were looking to rectify that in the House when the cross file goes through.
Okay, I just making sure that my members here in this committee understand it's a white paper, not necessarily unfavorable.
Correct. Yeah, and I appreciate that. Differentiation. So thank you.
See any other questions? I had a question. And again, I'm sorry that you're dealing with that, but how I'm trying to understand how this would even work. I mean, again, from everything that I've heard, when you're outside, there is no reasonable expectation of privacy. I mean, you have companies that are going and with their technology and taking pictures of all of us in our backyards. You have governments who are putting cameras up all around the place. What really would this accomplish? I mean, what is it that you're trying? I'm not going to say hide, but because it's not hiding. I understand the whole idea of privacy, but how do you accomplish this?
Well, and I appreciate the question. I think that's the challenge here. Is how do you define reasonable expectation of privacy? What does someone find reasonable? Maybe what you find reasonable may be different from what I find reasonable. But I would think that we could all agree to a certain point that when you have someone who is clearly solely interested in surveilling minor girls in the backyard of someone's property, that's a problem. And I don't know the answer and to your question of how we fix that, but we can't continue to allow that situation to happen. And so again, I'm not the attorney and I would rely on you, my friend, of how we thread that needle. But that's the challenge because to repeatedly be told by the sheriff's department, the state's attorney's office of, sorry, there's nothing we can do until this person actually does something. We don't want to be in this room again saying what happened to these girls. We don't, nobody wants that. And so I don't know that the exact answer to your question, other than I think that's what I would, give to the committee. That's the challenge here of what can we do to allow people to have obviously the right to surveil their own property, to allow people to, as things happen, but at the same time, allow a family, again, how you define
live in
expectations.
peace.
Yeah, to live in peace and not have some guy moving cameras around over top of boards, put them in trees to watch children play in a backyard. It's not.
Let me
right.
make sure I heard you correctly. So when your family put up the boards, he then took his cameras and moved them somewhere else so he could.
Sure. This one's lower. And then he moved it up higher. Here's him moving around. He's got a board in the tree to reach over top of these 2x4s. Hannah, can you explain what those screens are there, I guess?
They are roofing material that my husband put together, so that way they're on a pole and they can go up and down with the height wherever he decided to hang it in the tree.
As they move them,
he moves
them.
A
Yeah,
lot of these
none of those plywood boards were there until the cameras went up, and then we just had to start adding blockage.
Yeah, and all these cameras are all the way at the end of the property line. They're not like up against this. I mean, he may have some there too, but this is solely focused on watching
on this family.
Yeah, and it's just, I don't, like I said, that's why we're here, and that's the situation that's been presented and the challenge, and that's where we look to the committee to help provide some guidance. And again, we're open to any suggestions. We're just trying to find a path to allow this family to get in front of a judge. Any reasonable person you talk to, we're out in the hallway having conversations, waiting here. What are you guys here for? You explain the situation. Everybody's like, that's terrible. How could someone be allowed to do that? And that's what we're trying to figure out. We just wanted the opportunity for them to be able to be in front of a judge to present this. The judge can make that determination on a case by case basis. I don't know how that works into the definition of the law per se.
With your testimony, am I correct in assuming you've spoken with an attorney?
Mhm.
Yeah, I mean, we've spoken to an attorney, lawyer.
And they couldn't figure out.
So we met, just for the record, we met with the former majority leader, who directed us to the peace order, which then got us in touch with some other counsel to help propose this. So we've talked to multiple different councils. We spoke to our state's attorney's office, the sheriff. I mean, everyone's what do we do? And so that's what we bring to you, my friend. So that's because, again, we can't allow this behavior to continue in this fashion and have the only recourse be, well, until something actually happens. That just, I don't think anyone's comfortable with that. So
I'm trying to think harassment. I'm
sure.
My mind is going. I'm trying to.
Yeah, and we're open to any and all. That's, it fell in the peace order. I mean, harassment, whatever. We're open to any tool in the toolbox can be put in there. Again, that allows the ability, I guess, to, have a judge take a look at this and make that determination of like, yes, this is clearly aggressive. This is clearly beyond the scope of security. And be able to make that determination to be like, all right, you need to knock this off. So.
Thank you very much. I don't see any other questions, so thank you very much. That will end our. Oh, sure. Thank you. And I think in the system, the judiciary was uploaded as unfavorable when in fact it should have been for information.
Yes, I appreciate you pointing that out. I think Senator McKay said the same thing, and we reached out to them this morning because we've been in contact with them also. They reached out to us a couple of weeks ago when we put this in, trying to figure out what's going on, and we had conversations back and forth with them as well. So I appreciate you noting that. That's this is the challenge. This is what we're trying to figure out. But I have, I know you guys will figure it out. All right.
I appreciate.
I got full faith in you. All right.
Look, thank y'all very much.
Yes, sir.
That'll end our hearing on Senate Bill 632. All right, then I'll go next. Sure. All right. Oh, yes, Senator Cowley.
We're good.
All right, that works. Senate Bill 630. Are you on here?
No.
Oh, yeah.
Oh, Lord, I don't know if I have that authority.
Here all day, but I don't know if they don't realize we're up yet. So, oh, I see the front, you guys are coming in. Let me get them. Yeah, Ron. Sorry, I got them, don't worry. So we're going a little out of order, but I want to keep us moving. So this bill, which has a number, which I will tell you, it is 630, Senate Bill 630, is related to medical debt. I see only a couple members of the committee here, so we will be efficient. And it's a good bill to only have a couple of members of the committee for, because there's no opposition to this bill. I think that we can move it. It does have some amendments, but let me just walk you through what it is. And this will be familiar to Senator Charles because it's really a HGO kind of bill. So Senator West would also understand. This is related to, if you can remember back in 2021, we passed legislation unanimously out of the Senate related to medical debt that particularly prevented hospitals from placing a lien on someone's personal residence for medical debt, those really aggressive collections tactics. So we already made sure that hospitals could not do that. But when we did that back in 2021, we did not account for the fact that 44% of medical debt is actually from out of hospital care. It could be really expensive dental care, for example. I know Senator McKay is familiar with this issue. Oral health care, it could be medication, diagnostic tests, those types of things. So what we want to do with this legislation is really close that loophole and make sure that you can't place a lien on someone's personal residence. We're not talking about second homes, vacation homes, just their personal residence for medical debt. So that is what this legislation does. It's pretty simple. I will say that there are a couple of amendments that I just got back, so I will make sure council has them. And they're based on the favorable with amendment testimony that you'll hear about. I will describe them for you so that we can keep it in the record. I'll also let you know that 11 other states already do this. States, across the partisan divide: Arkansas, Florida, Iowa, Kansas, New York, Oklahoma, South Dakota, Texas, Washington, D.C. also already does this. I want to point out that the Hospital Association submitted a letter of information. They are, obviously, this doesn't affect them at all, but they wanted to make sure we changed, we aligned the definition with where it is elsewhere in statute. So that's one of the amendments. The other amendment just clarifies sort of how we describe the medically necessary language. We want to make sure that this applies to medical debt that was medically necessary, that was determined to be medically necessary, but we want to make sure the language we're using is consistent with where that is elsewhere in the statute, which is what that amendment is about. And then finally, there is a third amendment that I think someone from legal aid here will be able to describe that really is just very specific about the process that's currently being used in Baltimore. So the language that we requested with that amendment just says that no Maryland court shall attach a lien to a property as the result of an enrolled judgment for medical debt, either by automatic process or upon request of the creditor. That's just to clarify that this process that we think is currently happening in Baltimore shouldn't be happening. And someone will explain that who is better equipped to than I. So with that, I will make sure you know there is no opposition to this bill and pass it on to, I guess you're up. Okay, perfect. Wonderful. Thank you so much. Oh, and I urge a favorable report.
Good afternoon, everyone. It's nice to be before you and to see you all today. My name is Heather Forsyth, and I'm the Deputy Director of the Health Education and Advocacy Unit. And I'm offering comments today on behalf of the Attorney General in support of this bill to protect Maryland homes, primary residences, from lien attachment due to unavoidable, unplanned, and involuntary medical debt. The Attorney General believes that no Marylander should have to risk their home to pay for essential health care. It's estimated that nationally and statewide that 1 in 5 people have medical debt, and even people who have health insurance can experience crushing medical debt due to high deductibles and out-of-pocket costs and fees not covered by insurance. Accidents and illnesses are little d democratic because they hit everyone and they can hit at any time, anyone at any time. Yet study after study also shows that medical debt is borne most heavily by those who have low income, who are Black or Hispanic, or who have chronic illnesses. We suggested allowing liens to attach to Maryland homes to satisfy medical debts that largely people have no control over, doesn't really represent our state values. And we urge the committee to join the Attorney General in support of SB 630 and ask a favorable report. Thank you for your time.
Good afternoon, Vice Chair, members of the committee. For the record, my name is Marceline White. I'm the Executive Director of Economic Action Maryland. Economic Action Maryland works on economic rights, equity, and housing justice through research, education, and advocacy. We're here in strong support of SB 630. I want to thank the Senator for bringing the bill. This bill builds on the past work of the General Assembly to address crushing medical debt. We believe, and we know from work we did this past year, a poll shows that 14% of Marylanders today have medical debt, and that figure rises to 23% when you look at Black households. So we know medical debt is a problem in Maryland, and particularly for Black households. Again, 44% said the medical debt is from outpatient services, and that is exactly the issue that this bill addresses. This prohibits medical debt liens on outpatient services and on medical debts that are private practices. I want to talk for a second about why this is important. Home liens can negatively impact a household's credit score. They can make it difficult for people to borrow, to refinance, to get affordable mortgage payments, and can create a vicious cycle if they're trying to repay their debt to refinance. We believe that it is important for them to be able to take out a home equity loan, and it can impair that. It may inadvertently widen the racial wealth gap. This bill still allows for liens on second homes, and it includes the clarifying amendments that the Senator spoke of. We believe that it allows people to address the issue of medical debt, and 11 other states do this. For all these reasons, we support Senate Bill 630 and ask for a favorable report.
Thank you. Vice Chair Waldstreicher, members of the committee for the opportunity to address the bill. I'm Franz Schneiderman. I work with Consumer Auto Maryland, a nonprofit group that works to protect Maryland consumers and Maryland drivers. And, I want to add my voice to the other advocates about how important it is to extend what we did in 2021 in the landmark Medical Debt Prevention Act and protect all Marylanders against all kinds of medical debt leading to a lien against their house. Medical debt is shockingly common. It's concentrated among low-income Americans and people of color. But, one study I consulted said that 26% of people with incomes over $90,000 reported medical debts that they couldn't pay because, medical debt can strike anybody if you happen to get a serious illness. It's a kind of debt that nobody chooses and nobody wants. And again, it's not something that people should lose their homes over or have their credit record devastated. And of course, when home liens get attached to people's homes, it not only threatens the security of their home, but it undermines their access to the equity in the home and really can devastate their credit rating. The Consumer Financial Protection Bureau has acted to limit the reporting of medical debts to people's credit reports because they too perceive it as deeply unfair for those kind of debts that nobody chooses and nobody wants to, deeply devastate people's credit rating. And, again, it only applies to private residences and first homes, not to vacation homes or second homes. So, it wouldn't enable, wealthy people with a lucrative portfolio of properties to just not pay their bills and, be able to protect their properties against attachment. So hope you'll support the bill. Thank you.
Good afternoon, members of the committee. My name is Anthony Davis. I'm here in support of Senate Bill 630. I represent Maryland Legal Aid. I'm Director of Advocacy for Consumer Law and also supervisor of our foreclosure legal assistance project. There's an intersection at times between different areas of practice, and in housing and consumer law, there's often overlap. How this affects our client, how the situation affects our client is medical debt is a serious issue, and I support everything that the panel has said, as well as foreclosure is a serious issue for Marylanders. In our work, we're trying to save distressed homeowners from falling into default and from losing their homes. And a lien against the property is just one more layer that we have to deal with in trying to help them help themselves. As it was spoken before, liens prevent homeowners from accessing equity, from getting loan modifications, from really allowing legal service providers to do the work that will help a person to manage this financial distress. Medical debt, again, is nothing that anyone wants, and it is severe when it happens to already distressed financial situation. So SB 630 removes a layer, and it also expands the existing protections that we see that are helping people who have medical debt. So in practice, if I have one less barrier to approach in trying to help a homeowner, that's better for us. For these reasons is why Maryland Legal Aid supports this bill, for expanding existing protections, for removing barriers, for preserve home ownership, especially among the most vulnerable in our society. Thank you.
Thank you for your testimony here today.
And
Well-
I think we have two virtual panelists. We want to knock them all out, or we can do questions.
I think we're going to pause and see if there are any questions from the committee for the sponsor or any of these witnesses. All right, seeing no questions, we will move on to our virtual testimony. Bernetta Hayes, Bridge Dumais. Why don't we go first with Bernetta Hayes? All right, Ms. Hayes, we are ready to hear your testimony.
Sounds good. Thank you for having me here. Hi, Chairman Smith and members of the Senate Judicial Proceedings Committee. Thank you so much for the opportunity to testify in support of SB 630, which will safeguard the homes of patients in Maryland. My name is Bernetta Haynes, and I'm an attorney at the National Consumer Law Center, or NCLC. I provide my testimony today on behalf of the low-income clients of NCLC. Medical debt, as you've heard today, poses a severe problem, disparately impacting low-income individuals and Black and Hispanic families. Among Maryland families, the Urban Institute estimates that 9% of households in white communities and 13% of households of color have medical debt in collection. Consumers also reported as a leading contributor to bankruptcy because some healthcare providers use aggressive collection tactics like seeking liens against homes. Consumers even report fearing medical debt more than they fear a medical diagnosis. In 2020, National Nurses United reported that hospitals in Maryland sued patients to obtain thousands of liens between 2009 and 2018. Many of these medical debt lawsuits ended with patients filing for bankruptcy. This problem is not limited to Maryland. Hospitals seeking liens against patients became such a problem in New York that in 2022, the state enacted legislation banning healthcare providers from placing liens on individuals' primary residences. California, Colorado, Connecticut, Delaware, Massachusetts, and Nevada have similar laws prohibiting or limiting healthcare providers from pursuing liens against patient homes. With SB 30, Maryland now has the opportunity to protect patients in a similar way, to protect their homes by banning liens for medical debt. For these reasons, we ask that you pass SB 630 to shield consumers from this harmful medical debt collection practice. And I thank you again for the opportunity to testify. I'd be happy to answer any questions.
Thank you. We'll take questions after the final testimony here. Ms. Dumais.
Good afternoon, Mr. Chair and members of the committee. My name is Bridge Dumais, and I'm the coalition co-chair of End Medical Debt Maryland, a statewide coalition of 60 organizations, and I'm the political coordinator with 1199 SEIU United Healthcare Workers East. We're the largest healthcare workers union in the nation, representing 10,000 members in our region. 1199 members and affordable healthcare advocates know firsthand that housing is healthcare. We urge a favorable report on SB 630 to end the practice of home liens over medical debt with a friendly sponsor amendment. We are experiencing a critical short staffing crisis in healthcare, and Maryland has the longest emergency department wait times in the entire country. Healthcare workers are burning out, and patients are unable to spend enough time with their care providers. A healthcare worker recently told me that working in healthcare right now resembles working on an assembly line. That should not be. One of the ways to mitigate this crisis is to ensure that fewer individuals are forced to seek frequent medical care due to preventable illnesses, such as those caused directly by housing insecurity and burdensome medical debt. Numerous studies have demonstrated that households without medical debt and households that have housing stability have better health outcomes overall. Improved health outcomes can decrease healthcare costs for patients in the long run and can lower hospitalizations, reducing unbalanced worker to patient ratios and bolstering quality of care for all. No one should be punished for seeking medically necessary healthcare with a home lien. Please vote yes on SB 630. Thank you.
Thank you. We always welcome a Dumais in this committee. Questions for Ms. Haynes or Ms. Dumais? All right. Thank you all for testifying on behalf of this bill. That completes the hearing on Senate Bill 630. Thank you, Senator Kelly, especially. We'll now move to Senator Carter for her three bills. Senator Carter, it looks like I have Senate Bill 619 first, if that is okay with you.
Yeah. 619. Oh, nothing. So thank you, Mr. Chair and committee. I just learned that one of my main witnesses had a death just today in the family, so my condolences to him. We will proceed. It's really too bad because that person, Mr. Grand Prix, is really a subject matter expert on all things marijuana in Maryland and in the country. But I will be brief. This is a bill that I brought last year. It did not pass. I'm hoping for a better result this year. Senate Bill 619 seeks to substitute civil penalties for criminal penalties for certain cannabis-related offenses, such as possession over the civil use limit, possession with intent to distribute, and cultivating cannabis. The bill was introduced, as I said before, and did not receive a vote. According to an opinion from the Attorney General last year, notwithstanding the fact that Maryland voters decided to legalize cannabis, it is only partially legalized due to the fact that certain offenses such as possession over the legal use amount and possession with intent to distribute still carry criminal penalties. As seen in many states, the legalization of recreational cannabis uses without eliminating criminal penalties for other cannabis-related offenses will not be enough to reduce racial disparities. According to a 2020 National ACLU report, disparate arrest rates between Black and white people exist in all states, regardless of whether cannabis has been legalized, decriminalized, or remained legal. Disturbingly, while in states that legalized cannabis, arrest rates decreased after legalization, racial disparities sometimes actually worsened. For example, in Virginia, despite legalization of recreational marijuana in 2021, Black adults still accounted for nearly 60% of marijuana-related cases, even though they are only 20% of the state's population. In Washington, D.C., despite legalizing marijuana almost 8 years ago, almost everyone arrested on marijuana-related charges in 2020 was Black, despite making up only 45% of the city's population. In Maryland, Black people and Black communities are more than 3 times likely to be arrested for cannabis. However,
In Queen Anne's County, Black people are 8 times more likely to be arrested for cannabis. In Carroll County, Cecil County, Frederick County, Black people are 6 times more likely to be arrested for cannabis and 5 times more likely in Allegheny County. Between 2018 and 2019, 76% of Marylanders arrested for possessing more than 10 grams of marijuana were Black, despite Black people only making up 30% of the state's population. Moreover, we are sentenced to incarceration more often and for more extended periods of time for cannabis-related offenses than others. Therefore, with no changes made to the current law, cannabis laws will continue to affect the lives of Marylanders, especially Black Marylanders, disparately. A misdemeanor conviction record can, as we know, I won't go into that, can bar people from opportunities such as housing and food stamps. And we talk about all those collateral consequences on many different bills. We know about that. But we know that exclusion from the job market, stable housing, and countless other crucial services perpetuates the cycle of racialized imprisonment. This bill simply seeks to eliminate criminal penalties, instead substitute them for civil penalties. Kind of makes sense since we have decided to legalize marijuana, and it is completely legalized for corporate entities and wealthy people who are able to then sell it. And they are not restricted to small amounts. They're able to sell very large volumes to all Marylanders. Over the years, Maryland has used millions of dollars to enforce Maryland marijuana possession laws that continue to target Black Marylanders at alarming rates. The practice is not only counterproductive, but a waste of limited resources of the state of Maryland. It further widens the distrust between communities of color and law enforcement. For those reasons, I would urge a favorable report. Some people may ask why I focus so heavily in my testimony on the racial disparities, because I think it's important, because I believe that many Marylanders, when they voted to legalize marijuana, they thought they were also voting to end these racial disparities. But knowing that even with legalization, that there are still going to be criminalization for some and not others, I think is something that we have a moral obligation to address. And so I'm asking for a favorable report. Thank you.
Thank you. And as you come up, Mr. Brown, our thoughts and condolences are with Mr. Grand Prix, and we're so sorry to hear about the death in his family. We wish him well. And we will take his testimony written as well.
Good afternoon, Chair and members of the committee. For the record, my name is Gregory Brown from the ACLU of Maryland. Amid a growing understanding of the harm caused to Black and Brown communities by the enforcement of the war on drugs, Maryland voters have decided that the recreational use of cannabis should be legal. However, criminal penalties for marijuana-related offenses are still on the books. Under the current law, cannabis-related offenses such as possession over the civil limit and possession with intent to distribute are misdemeanor offenses. The Maryland State Commission on Criminal Sentencing Policy noted that 49% of people receiving these misdemeanor convictions have no previous criminal record. That figure is 45% for those who receive felony convictions. If these criminal penalties are not removed, cannabis will only be partially legalized. Black and Brown people will continue to be disproportionately impacted by targeted enforcement of these laws and saddled with collateral consequences accompanying entanglement in the criminal legal system, which would result in exclusion from the job market as well as access to social services and housing. We believe this bill strikes an appropriate balance of public safety and the legalization of cannabis in this state. In our view, we should be replacing these penalties with reasonable fines, rehabilitation services, and community service as alternatives. Thank you. We urge a favorable report.
Excellent. Thank you very much. Questions from the committee? All right. Seeing none, thank you very much. All right.
Is there opposition?
Oh, I'm sorry. Senator West has a question. My apologies.
I just a quick one. I wasn't here for 99% of the hearing, so if this has been covered or if I'm off base, let me know. Cultivating cannabis. Last year when we passed the cannabis bill, as I recall, there's serious limits on how much cannabis someone can cultivate. If we were to pass this bill, would this enable someone independently to set up a huge cannabis farm and only face a $250 fine for doing it.
Did you want so no, in the fiscal note, I believe that the fine is a maximum of $5,000, so it wouldn't be a $250 fine.
Okay, well, even so.
Right.
Right now, in order to cultivate cannabis, you need to get a license. And there are very few licenses given out. They're only done with lots of vetting ahead of time of the people who are cultivating the cannabis. If this bill were passed, would allow somebody to set up a huge cannabis farm and only face $5,000 fine. And presumably would make far more than that from cultivating and selling the cannabis illegally.
Right. So I don't have a specific answer to that question. I'm sure that could be carved out to make sure that people aren't specifically trying to have, big farms. However, when we're talking about a substance that has been legalized, we should not be trying to introduce people to the criminal justice system for that, in the same way that we don't do that for other things that have been, other substances that have been legalized in the state.
Well, what currently, if again, there are only a limited number of cannabis licenses for cultivation that are available. What happens right now if someone illegally turns a large tract of land into a cannabis farm? Does the Attorney General have what are the penalties for doing that, which is against the law?
Right. Well, I mean, currently, right now, that would be criminal. So those people would probably go to they would be indicted and sent to jail for doing that.
If this bill is passed, it becomes basically a civil offense for a $5,000 fine. And so if you're willing to pay the $5,000, you would be at liberty to set up these huge farms to cultivate cannabis in violation of Maryland law, right?
Well, sure, but they would also be falling outside of the amounts that they're allowed to grow. So I'm sure that what they are growing would be confiscated from them. That it's not something that they would just be allowed to have.
Oh, so under this bill, if I were to be arrested for possessing too much cannabis, I would face a fine, plus all my cannabis would be confiscated?
Well, I mean, I'm not sure what the exact process is, but I'm sure that if they were to face this fine and it's found that they are having a farm of cannabis that they're growing, that they would not be allowed to keep that cannabis.
Okay, thanks for your answers.
Sure. Oh, sorry.
Hi, and thank you. And thank you, Senator Carter, for bringing the bill, and for either of you, because I'm just a little confused. I'll use this analogy. Cigarettes are legal in the state of Maryland, right? But I think that if the comptroller has the authority, and it is a crime to be having a great number of cartons of cigarettes, because the implication is that you're, bypassing Maryland law for taxation, or you're selling them, it's a black market. So I'm trying to figure out whether this bill in its current form would allow that kind of problem for law enforcement and our whole scheme. In other words, we have a legal scheme for having cannabis. Senator West was indicating, we have licensures and things like that. We also have plenty of provisions for personal use, etc. But I guess my thought is the reason we have some restrictions on your own personal use and then the licensing is that we don't allow for people to operate or have cannabis outside of those two lanes.
Mhm.
So I get that you don't want to be putting people in jail for this, but I also worry that we would be undercutting the, I think, well thought scheme we had between personal use. If you get over that, you're really outside of our scheme of, allowing licensed, well-educated, trained in businesses to operate. So how would you respond to that? And that wasn't the best articulation, but you probably followed what I'm trying to say.
Yeah, so you're trying to say that how do we separate people that have the licenses, have been vetted, and have set up a business
Right.
and gone through all the things that they need to do to set up a business versus people that, you know, just have large amounts that kind of just want to sell them.
Which might be an indication of sort of a black market
Right.
issue, right? So that's what I'm trying to, and which I think should be a crime. You know, I don't think you should be operating outside of the setup that we've gotten. So what are your thoughts on
Right.
that?
Well, so in our view, I mean, that person should be considered operating a business without a license, and it would come with all of the things that come with doing that. That it would come with all the civil fines and penalties that come with doing that. What we don't want is for people who may be engaged in that activity to be involved in the criminal justice system.
Do you know, and you can get back to me on this, whether that's what we do with tobacco? I mean, do we view it as a criminal matter when you're operating in the black market and other areas? In other words, I don't want to accept out if we have a black market, if we have a policy in the state of Maryland, try to go after people that are engaging in black market. And yeah, we criminalize that, right? Would this be an outlier, your scheme, or would it be consistent with some other statutory scheme you could point me to maybe later, not right now, but after the hearing, if you could get back to me?
Right, sure. So as far as I know, and I don't specifically know about tobacco or like alcohol.
Alcohol, there's another one.
Right,
Yeah.
but so as far as I know, operating a business without a license in the state comes with, I think, is a maximum fine of $100,000 or something of that nature. So, but the point is, it's still civil. It's not.
I hear you. So if this is an outlier, I would generally support the idea. Let's just find out what we're doing with, you know, tobacco and alcohol and things like that. How do we deal with black market, which is a little bit different, I guess, than operating without a license. But I don't know, right? I don't know if when you go after somebody who's selling, you know, 100 cartons of cigarettes out of the trunk of their car, does somebody go, yeah, he's operating without a license? And that's one thing, or do they look at that like, no, this is not even, this is black market, and
That's a good distinction, and
Yeah.
I don't currently know, but I would get back to your office with that.
That'd be great.
Yeah,
Thanks.
no problem.
All right, thank you very much. That'll conclude the testimony for the proponents of the bill.
Can I just say one sentence and answer?
Sure, yeah.
It may not be the best response, but I think it's important to note that the goal of this bill is to ensure that persons are not criminalized for the very same activity that we allow licensees to do. When we talk about civil penalties for cultivation, the intent is that if you cultivate in your home more than the legal limit we allow for personal use, personal growth, that you would not go to jail for it, you would have a fine. I think that you raise some interesting issues, and there are other ways to deal with those people that are operating businesses or using entire land or entire farms. That's not the intent of the bill, but certainly we could look at that very high end illegal or illicit business operation and deal with it differently. But we are just talking about the things that I testified about, which is regular people who might still engage in the use, sale of and growth of cannabis that are not within the licensing process. And frankly, we did pass a relatively thoughtful cannabis bill, but it has holes in it. And one of those holes we talked about at great length, that there's no real process to steer people that have been into the illicit market into the legal market. And we have limited licensing. We have limited and certain specific criteria for social equity licensing. And so we are, under our current scheme, going to still have a disparate system that criminalizes some but not others. So that's the part that I believe we have a moral obligation to address. Thank you.
Thank you very much. Thank you. All right, so now we'll turn to the opposition panel. Mr. Steindert. Jason, welcome.
Mr. Chairman and members of the committee, my name is Jason Steinhardt, and I'm a prosecutor from Anne Arundel County here on behalf of the Maryland States Attorneys Association, and I ask for an unfavorable report on Senate Bill 619. In the past year, the General Assembly has created a legal method for adults to purchase cannabis for personal use legally without resorting to the illegal economy. The organizations that have obtained the licenses to sell cannabis are regularly inspected, and most have conducted themselves with integrity. Yet the illegal economy associated with the trade of cannabis sold outside that process has not diminished and has no such integrity. It is profit first. When people seek to protect their profit, that leads to violence. I know because I prosecute those cases. I've prosecuted 3 murder cases in the past 3 years related to disputes over the illicit sale of cannabis. Robberies associated with the illicit sale of cannabis regularly occur throughout the state. I'm in the middle of prosecuting a case in which a group of teenagers decided to rob another cannabis dealer after they felt like they were not given the cannabis they thought they had purchased. In the course of that robbery, a young man was shot and killed. Making cannabis even more accessible has not ended the illegal economy and has not ended the associated violence with drug distribution. Cannabis may be perceived as less harmful than fentanyl and cocaine, but the violence associated with it is no different. Anne Arundel County is also unique for housing BWI Airport. I prosecuted many cases involving seizures of 40 to 80 pound quantities of cannabis. We're talking about thousands of dollars, and the maximum civil fine is merely a small cost of doing business. More importantly, yes, it is an end around of the licensing process. Not all drug crimes are created equal, and this does not make the citizens of Maryland safer. I urge an unfavorable report.
Thank you for testifying. And what I would like is, because I was asking questions about the black market, which I think is what you're addressing too. There is this black market. And so could you just follow up with us and just give me some of the data on that black market? I did not know that it was still as prominent, prevalent as it was, before we passed the law. I did not realize the violence was still continuing. So I would like some of that data, if you could follow up later.
With 100%, I'm happy to do that. This is not just theoretical. I've seen it in my cases, and I'm currently in the middle of a prosecution right now involving a marijuana or a illegal economy cannabis deal going bad.
Oh, no.
It is regularly happening.
Yeah.
And we have a safe process, and it's legal. And we know when you go there, you're not going to buy cannabis laced with fentanyl or cocaine.
Right. That I'm very,
But this
very
process
worried
doesn't
about.
have those safeguards. And that's why my concern is that this is not the time.
And not to put the
Yeah.
onus on you, you're in that State's Attorney Association. I work with them all this time. I don't see Steve Call here right now,
He's in
but
trial
you
today.
put that, I'm not asking you to personally do it. Just get the organization to give me just a little bit of data, or even refer me, to a report or something like that.
I will be happy to follow up.
Thank you very
much.
Right. Additional questions from the committee? All right,
Thank you
seeing
very
none,
much.
thank you very much. Thanks for hanging in there with us. All right, with that, that'll conclude the hearing for Senate Bill 619. We'll now move on to Senator Carter with Senate Bill 624.
Thank you, Mr. Chair. I'm hoping this is going to be one of the record fastest bill hearings in the world. This is simply asking for an extension of a bill that we already passed that would have created a task force around the Public Information Act for disclosure of records under Anton's Law, which was passed in 2021. In 2022, we passed Senate Bill 777, and it passed both the House and the Senate. And that was a task force that would endeavor to work out the kinks that were existing in the disclosure of records, both in the difficulty that some of the requesters were getting from the police agencies, with them failing to release or not releasing or complaining about how burdensome it was. And that task force simply never met. And so 2 years in, I'm just asking to extend the task force deadline for two more years. It's set to sunset in February this month. Sorry, it's set to sunset this month. So there's been no progress on the implementation of Anton's Law because of that. And finally, I'll just say the only other thing I would add is that the Attorney General has requested an amendment. He'd like to be included in the task force. So that's my testimony, and hopefully we'll just pass this as we did in 2022. Thank you. It's sort of the same thing, Senator West, as your bill, where you wanted to extend yours. Yeah.
This is great. All right, so we have Ms. Hilliard and Ms. Sample.
Good afternoon, Chair, remaining members of the committee. As Senator Carter explained, this is essentially just extending the task force to ensure compliance. I will not belabor the point. We submitted many records in support of the previous bill, demonstrating the exorbitant costs that are preventing the transparency expected and encouraged by the passage of Anton's Law. I will just note, however, that we have requested files from 5 jurisdictions alone, and the MPIA, we have requested files from more than 5 jurisdictions, but the cost for 5 jurisdictions alone is totaling over $1.7 million. That is simply a barrier to us actually getting to review and see those records, and is a barrier to really accomplishing what was set out by Anton's Law. I apologize. Debbie Levy wanted to be here today. She is certainly our expert on PIA fees and policing IAD files, but she was unavailable. So if you have questions, I will do my best to answer them, but I will also share her information with you so that you can direct them to her as well. We urge a favorable report, and we thank Senator Carter for staying on top of this and ensuring that what was passed is actually enacted. Thank you.
All right, thank you to the chair and members of the committee for having me today. My name is Sarah Sample. I'm here on behalf of the Maryland Association of Counties, and we are here to support Senate Bill 624 with amendments. And so I think this committee is pretty familiar with the fact that Maryland Association of Counties has had an initiative for the last couple of years, which is trying to modernize the PIA so that it can appreciate the complexities of requests for body worn camera footage. We haven't been successful in that, but you know, it's definitely still a priority of ours. And then the other thing with this is that certainly requests to law enforcement have increased pretty exponentially over the last couple of years. And also the availability of body worn camera footage has exploded with the mandate being rolled out to all of our county law enforcement agencies. And so that's meant to be in full effect for 2025. So we think this is a really good time to be putting this study together. And we would just like to request that we have in the current legislation, the chiefs and the sheriffs have one individual per association. And we just wanted to make sure that that individual, it's clear that they are managing the fulfillment of these record requests, and also that we have a record custodian who's also a part of that fulfillment request that would be included on the task force. So it's really taking the chiefs and the sheriffs from having 1 each to having 2 each. And then the other thing is just adding just a little bit more of an extension of what the group is going to be studying. What we wanted to add was that they could potentially look towards creating procedures and guidelines for review, redaction, and release of body worn camera footage. So we have something a little bit more standardized that we can use. But other than that, I think we're really excited to engage enthusiastically. We want to be transparent. We want to be helpful. And we want to help build trust. And we think this is a really good opportunity to do that. So with these amendments, we would support the bill. Thank you.
Thank you. Thank you again, Senator Carter, for bringing the bill. I was not here during a lot of the passages of bills that this bill in particular. I just need clarification. I thought, Senator Carter, you indicated there was a task force. But this bill says it's establishing a task force. I heard you say you're just extending the task force.
It's just an extension of the task
So the
force
fiscal
that
note
was
is
passed and
wrong.
never met.
So the
Yes.
fiscal note is wrong about you're establishing one. You're just extending the existing one because they never met or anything. And then just to get a nature of one of the witnesses mentioned, perhaps it would be a cost of close to $1.7 million from 5 jurisdictions. So I guess, are we asking for, I'm thinking documents, photocopying, and you pass on the 21 cents per copy, but is this, what kind of records? What do you sense is the cost driver, even if you don't agree with that particular
Right
cost?
now,
What are
some
you
of-
looking for?
Yes, and I'm happy to share some documents with you that outline this a
Yeah,
little
you
bit
can
more
do that. You
clearly.
can follow up.
But they are document and media redaction estimates. As Ms. Sample explained, the explosion of body worn cameras has definitely sort of changed the game a little bit. And so the working on figuring out redaction
Right, so you have
costs.
to go through hours of video, maybe
Mhm.
law enforcement has to cut out or redact something for,
Yeah.
comply with other laws. So it is, could be, it is somewhat time consuming. And I guess we didn't give law enforcement, I don't know if law enforcement's not here, we probably didn't give them any more money, in their budgets to handle this kind of, obviously important obligation. Is that?
I have no idea, but
Yeah.
I think that's probably something the task force could look into and address.
Yes, is that in the task force to talk about whether or not there's been adequate funding to respond to these kind of requests? Would you be adverse to that if that's not already in there,
No,
Senator Carter?
What I recall from 2 years ago when we passed it, when we first passed the task force is that persons that were making the request, there was a lot of disparity based on the agency and the jurisdiction. So where one agency may say it's going to cost $10,000 to produce this, another may not. So one of the things that we need the task force to look at is actually how to streamline the process. And I think that the testimony from Mako was very important, and because the body worn camera footage. So there's one school of thought that because it's so digital, it shouldn't really cost much. But there's another that because they're not equipped to disperse all of this digital technology, it is burdensome. So the answer to the question is, I think that is something the task force could look at. And I'll also share that according to the Attorney General, one of the reasons that, well, maybe that they didn't meet is there wasn't anything put in place to provide resources for it. However, my understanding is there is now. So it shouldn't be a problem with getting the task force to meet.
So you wouldn't mind if we want to put in about the resourcing, that's an issue, like do the
Not at all.
resources match the demand? And you're right. I think some law enforcement entities, even within a jurisdiction you're interested in, one would be small and they don't have, this would be very burdensome. And then another larger, maybe the Baltimore City Police are very used to this and they have a lot of technology experts and capacity. So, all right, that's great. Thank you.
Thank you.
Questions from the committee? All right, thank you all very much. That concludes testimony for Senate Bill 624. We'll now move on to Senator Carter, Senate Bill 643.
Thank you. This is a Baltimore City bill, so I would ask city leaders to approach. Thank you very much. So I'm bringing this bill on behalf of the city of Baltimore. Senate Bill 643 strikes down the provision of the Maryland Public Information Act pertaining to the use and disclosure of surveillance images captured by cameras located at illegal dumping sites in Baltimore City. It is a city bill. In striking down this provision, it would allow the Baltimore Department of Housing and Community Development, which manages the cameras, to share images to the public with the goal of soliciting community assistance in identifying suspects. It's kind of similar to how we see oftentimes on the internet and on social media when a vulnerable person or a child goes missing and they ask, they show the image and they say, hey, can you help us find this person? Not exactly the same, but it's usually a helpful process. Since 2005, the city of Baltimore has been authorized to install surveillance cameras at state and city-owned dumping sites and use surveillance images to enforce litter control laws. If caught on camera, suspects are subject to criminal charges in the district court. The city maintains approximately 100 cameras, which are reviewed by the Department of Housing and Community Development. For example, the cameras can sometimes capture a face on a camera along with the vehicle being used, not always the license plate, similar to what the Baltimore City Police Department already does. Department of Housing and Community Development would like to be able to utilize the social media to solicit community assistance in identifying these potential suspects. This bill is incredibly important to the people of Baltimore. It hits very close to home for me in my district. My office gets many calls about constituents being subject to illegal dumping. And this something more severe needs to be done, something more extreme, something more expansive needs to be done to help stop it. As stated in the Baltimore Banner recently, dumping is a public nuisance that attracts animals, pests, causes unsavory odors, and sets off a chain reaction that produces more blight. It also causes health risks and can be, excuse me, a fire hazard, along with an overall decrease in the quality of life, all the while costing the city millions of dollars in the cost of cleanup. Beyond just the health and safety concerns, the dumps create a negative first impression of our 41st District communities and our entire city, staining their reputations for passersby. Our neighborhoods need to get cleaned up, and this is an important tool to help us do it. I would ask for a favorable report for Senate Bill 643. Again, it is a local bill. Thank you.
Good afternoon, Mr. Chair and members of the committee. My name is Stephanie Murdoch. I'm the Director of Legislative Services for Baltimore City Department of Housing and Community Development. We are here in support of SB 643, which is the Public Information Act surveillance images. As the sponsor mentioned, this would allow our Special Investigations Unit to publicly disseminate photos captured of suspected suspects on illegal dumping cameras in an attempt to identify them and reduce the future reoccurrence of this activity by an individual. Our Special Investigations Unit team responds to over 10,000 reports a year for suspected illegal dumping. And we work tirelessly to investigate large-scale dumping complaints and to criminally prosecute illegal dumpers when we have enough evidence to do so. Dumping is a crime, and there are serious ramifications, of some of which include up to $50,000 in fines, up to 5 years imprisonment, forfeiture of your vehicle, points on your driver's license, loss of city-held licenses and permits, loss of city contracts, court-ordered community service, and restitution for cleanup costs. Our agency owns and operates 100 motion-activated cameras. We recently got 40 new cameras with the latest technology, and we work daily to monitor and investigate illegal dumping. And when it's captured, we work to bring that suspect to justice. This is a local bill, and it would allow us to, among other things, utilize social media and solicit community assistance in identifying these suspects, very similar in a manner to what the BPD do with Metro Crime Stoppers. Again, dumping is a crime, and we need the public's assistance to identify and curb illegal dumping. We already call on the public through our 311 system to help identify suspects. We humbly ask for your support today. Thank you for your time.
Good afternoon. Thank you, Mr. Chair and committee. My name is Seth Greer, and I'm an Assistant Commissioner with the Department of Housing and Community Development for Baltimore City. And I oversee a group of prosecutors and our investigators that are in the field every day, digging through the trash, trying to find information and responding to these cameras to identify suspects. Senator Carter and Ms. Murdoch phrased it very well, so I won't reiterate that point. But we want to give our investigators a large tool as well as the community to give them the ability to work with us and show that this is a partnership and we need their help and everybody's help to identify these suspects so we can bring them into court and get some justice for those communities as well as Baltimore City. As Ms. Murdoch stated, our special investigators respond to over 10,000 311 complaints, but also are responding to these 100 cameras that are strategically placed throughout the city. They work very hard, and we want to give them every tool possible to be successful in that and show the community that we are doing our job and that we need their help. So we would respectfully request a favorable report for Senate Bill 643, and thank you again for your time.
Thank you, Mr. Chair. I just want to go on a record to say I love this bill. It's, I do a monthly meeting with MDOT and our DPWT folks in Prince George's County, and listening to it, this is something I think we need in Prince George's County as well. I don't want to be an impediment to the bill, but if there is a way to add Prince George's County on here so we can get our DPWT folks in a position to do the same thing. You know, we had people dumping tires. I'm talking about 10,000 tires, and we had a camera out there and they caught those folks, and our state's attorney's office was able to prosecute that particular person. But in terms of like holistically across the board, we've got dumping happening all over our county. And I would love to be a part of this bill to add Prince George's. If it's a problem that we can't do it, I can wait to try to put it in next year. But being a local bill and all, spread it out to the state to give a lot of our jurisdictions the ability to do this, I think would be helpful.
Thank you very much. Of course, we don't oppose an amendment, but it probably would need to go through your delegation, as it's got to go through the city delegation as well, which it is doing. But absolutely, I'm glad you like the bill. And let me tell you, the dumping is outrageous, and all of the information we have is that the majority of dumpers are not the residents of the city. It's terrible.
I get it as well, but the thing that I wanted, I guess the administration to speak to is I'm reading the legislation. I'm trying to understand what is it that prohibits you all from doing it now? Is it because the read is that you shall deny inspection? And if that's the case, I mean, I guess a broad interpretation of it would be you're denying inspection to the general public, but it's your video, so why should you not be able to use your video in a law enforcement manner that you all want to use it?
Sure. Thank you for that question. The city was advised that a provision in the Public Information Act and general provisions for 322 prohibits the city from sharing their surveillance images. This was part of the MPIA, was enacted as part of the original illegal dumping law, SB 312 in 2005. And a review of the legislative history did not reveal why the video records of the illegal dumping are shielded under the MPIA. So we are hoping to address that by this bill.
But that's the read, the shall deny inspection. You all are reading it and have been informed that prohibits you all from sharing your own. Okay. Thank you.
Following up on Senator Senior, I think it would be helpful to us for you to show us your law department or whoever is giving you this interpretation, which we're struggling with. I mean, I'm all for helping. I think this bill's very good bill and should be used wherever it can be to stop this, because you see this all the time, you know, and you see it along roads and, you know, or worse, obviously what you're dealing with. But I am struggling, just as the other senator, with how the current law is denying you the ability to inspect this, especially when it's for the very lawful, the very important purpose of bringing about, you know, bringing people that are involved in criminal conduct to heel. So you don't have to do it now, but I'd like to see what the problem is so that we make sure we craft a bill to solve it or determine that a bill's not necessary because the interpretation is in error. Thank you.
I agree. Based on the statute and the interpretation that's been shared with me from our city and our city law department, that's what was the basis for the bill. But I'd be happy to have them look more deeply into maybe the legislative history or something, if that'll, you know, satisfy you.
To get what you need here. I just think we've got to be clear about what is the opposition, what's the legal basis for that opposition. Is that the right interpretation? You say it's a local, is it a, but this is a state statute.
It's a state statute.
So why don't you, maybe you could get a quick opinion from the AG about whether the local interpretation of a
Is
state
correct.
statute is correct. Because that would, then you could go forward much more quickly, as could Prince George's County, if that's what's needed.
I agree. And
Okay,
to be honest with
good.
you, I think that I applaud the city on using an abundance of caution and not wanting to violate it, anyone's privacy rights or something like that. But I don't have a problem with getting an AG opinion. It hasn't gone through the delegation yet, so
Sure.
we should be able to get it done.
We'll do it either way.
Thank you.
Thank you.
All right, thank you, Senator Carter. Thank you to the panelists. With that, that'll conclude the bill hearing for Senate Bill 643. We'll now move on to Senator Sidnor with Senate Bill 550.
All right, Senator Sidnor for Senate Bill 550. Good afternoon, Mr. Chair and members of JPR. I stand here before you in support of Senate Bill 550. For background, in 2019, we passed the Child Sex Trafficking Screening and Services Act of 2019, creating a regional navigator program and ensuring that every sex trafficking victim under the age of 25 has access to local and specialized services. Since then, the program has expanded statewide, and countless victims of sex trafficking have been served by specialized trauma-informed providers. In 2023, we passed the Victims of Child Sex Trafficking and Human Trafficking Safe Harbor and Service Response, decriminalizing prostitution and a selection of other nonviolent offenses for minors found to be victims of sex trafficking. While these important pieces of legislation have moved us closer towards the goals of helping young victims of human trafficking, we must work towards closing the gap for labor trafficking survivors, ensuring that every young person who is a victim of human trafficking is able to access services immediately. There's a high number of youth vulnerable to labor trafficking in Maryland. Maryland has received the 5th greatest number of unaccompanied children since fiscal year 15. In the first few months of 2024's fiscal year, Maryland has resettled 616 unaccompanied children in Prince George's County, Montgomery County, Baltimore City, and Baltimore County. Because of their lack of access to language, social services, education on workers' rights, and legal opportunities, unaccompanied children and other foreign nationals are disproportionately vulnerable to labor trafficking. In fact, of the 15,886 victims of labor trafficking identified through the National Human Trafficking Hotline from 2018 through 2020, 92% were foreign nationals. For this reason alone, it is imperative that regional navigators who currently serve only young victims of sex trafficking expand to include young victims of labor trafficking too. Despite the abusive and exploitative nature of labor trafficking, unlike sex trafficking, labor trafficking of minors is not currently recognized as a form of child abuse or neglect. This means that as a state, we are not protecting and grossly underestimating the number of abused children in our communities. Senate Bill 550 will change this. Senate Bill 550 defines labor trafficking as a form of child abuse and neglect, therefore requiring a mandated report, thus ensuring that the most vulnerable among us are connected to critical legal, mental health, and social services. Currently, funding for the housing, including rental assistance, is an unallowable cost under the Regional Navigator Program. In Maryland, minor and young adult victims of sex and labor trafficking often lack options for where to live and with whom during and after their trafficking. Many of these young victims live in poverty, which is both a root cause and outcome of human trafficking, making housing stability even more out of reach. In response, Senate Bill 550 expands regional navigator funding to allow for housing costs, which is often one of the most fundamental and foundational needs of victims. For the above reasons, I ask that you support Senate Bill 550 with confidence that it will continue to move Maryland towards our goal of connecting every young victim of both sex and labor trafficking immediately to the services they need. I ask for favorable. Thank you very much.
Mr. Chair, Mr. Vice Chair, members of the committee, my name is Amanda Rodriguez. I'm the Executive Director of Turnaround, which is the regional navigator for Baltimore County and for Howard County. I'm also the chair of the Legislative Committee of the Maryland Human Trafficking Task Force. This bill comes from really the impetus is the regional navigators. There is enough funding to support some additional services being offered to the community. And in connection with DHS, the regional navigators, GOCAP and DHS sat down with our committee and talked through what those needs were that they were seeing in the community, what was being unmet, and how we could meet it. The way that we're asking to do that is threefold. The first is to simply take out a piece of the statute that currently restricts us from using funds to support housing. We're not asking for additional funds. We have the funds to be able to do it through the current regional navigator program. We're just asking for the availability of those funds to be used on housing. We want to ensure that there's parity with sex trafficking and that we would allow for the regional navigators to serve labor trafficking victims as well. And then the third thing is a mandated report required if there's suspected child labor trafficking. Currently, DHS has already developed its own protocols internally for being able to handle those cases, but the issue is getting them from the community into CPS to meet the needs of those kids. There is a amendment that will be forthcoming. There was a little bit of a snafu on that one. The amendment is essentially, if you look at page 8, it will not require that the family reunification portion be implied in this case. So there is a section currently for a child of sexual abuse to not have a presumption that they need to be reunified with their family. There's been some concerns, mainly from the Office of the Public Defender, on that specific section. It was not intended to be in the draft, so we are asking for it to be taken out in connection with the sponsors, both in the state and the Senate and in the House without issue. You are going to hear from some other regional navigators today, and I just want to say Melanie Shapiro is stuck in the House testifying today as opposed to stuck here testifying when there's another bill being called. So she apologizes for not being here. For those reasons, we ask for a favorable report. Thank you.
Good afternoon, Chair Smith, Vice Chair, members of the committee. My name is Sophie Aaron. I'm a social worker at the University of Maryland Safe Center for Survivors of Human Trafficking. We are a one-stop shop for survivors of sex and labor trafficking, and we serve as the regional navigator in Prince George's and Montgomery County. Since 2019, when this committee passed the Child Sex Trafficking Screening and Services Act of 2019, we've been serving as the regional navigator in Montgomery County. Since 2020, also in Prince George's County. And during that time, over the last 4 and 5 years, we have served 55 clients under our regional navigator program, and we've trained just under 1,000 community stakeholders to recognize the indicators of trafficking. And during that same time, we have seen a dramatic increase in the number of labor trafficking survivors in Prince George's and Montgomery County, which is the jurisdictions that we are working in. This has included a 16-year-old who suffered a pretty serious knife injury to his thigh as a result of working in a meatpacking plant in Maryland. Also includes a young adult male who was living with his grandmother, forced to work in a fast food restaurant on the weekends and after school. He ended up having to work so much to pay rent, was threatened that he would be kicked out of his house if he didn't make rent, as a result of which he dropped out of school and ended up in the hospital, as did the first victim. This time as a result of the profound emotional and physical abuse that he endured at the hands of his grandmother. So what I want to highlight here is that we are not currently able to serve these minor and young adult victims of labor trafficking under the Regional Navigator Program, but they are certainly in our communities. Because we're not able to serve them and because DSS is not in the position to serve them yet, as the senator said, we are grossly underestimating the scope of the problem, and we are leaving them vulnerable to future victimization. We urge a favorable report on SB 550 because this would allow these young adult victims, child and young adult victims, access to services that could change the trajectory of their lives. Thank you very much.
Hi, I am Andrea Carroll, Director of Behavioral Health Services at Board of Child Care, which operates the Regional Navigator Program here in Anne Arundel County. And we support Senate Bill 550, and I want to highlight 3 main impacts based on our experience. First is the proposed requirement that local departments refer labor trafficking victims to regional navigators. Caseworkers have at times contacted our program about labor trafficking cases. However, not every caseworker does this, and it's certainly not happening in every jurisdiction. We can only be sure that all minor labor trafficking victims get access to needed services if these reports are required and staff are trained to identify and make the referrals. Secondly, the scope of our program by current definition is sex trafficking. So when we do get these referrals about labor trafficking, determining if and how to respond, and also if we can even access labor trafficking training and resources is a challenge. Our regional navigator has partnered with Anne Arundel County Public Schools to deliver training to high school students as part of the county's health curriculum, a curriculum which requires training on both sex and labor trafficking. We need our scope and access to labor trafficking resources expanded to fully meet the needs of our county. Finally, one small but important change is allowing regional navigators to offer housing resources. Our law enforcement partners consistently say that the biggest gap for services for trafficking survivors in our county is access to immediate housing. Officers are typically encountering sex trafficking victims in the middle of the night, and there's nowhere to take them right now except for the hospital. We do have some great hospital programs in our state, but that's not where everyone wants to go. We've had a young victim in our program awaiting a daytime intake for shelter placement, and they had nowhere safe to go in the meantime. If the scope of regional navigators included housing support, we could offer emergency resources like brief hotel stays until shelter becomes available. Most importantly, I want to be clear that the changes in this bill will not require more staff or funding. We feel very confident that our existing staff and resources can be reallocated, allowing us to better serve our community by addressing all forms of human trafficking.
Thank you so much, Mr. Chairman, and thank you, Senator Sidner, for this great bill. I think that Ms. Rodriguez brought this up in her testimony, so I just want to make sure that we're on the same page. What you were saying was the amendment, or let me ask you a question. DHS is proposing what they consider a technical amendment in their testimony. Is that the amendment you were referring to? Or is this a different amendment? They're saying they want to align the definition, sex trafficking, which includes sex trafficking of a child by an individual. This divergence is significant as it allows for any individual responsible for sex trafficking of a minor to receive a finding of abuse or neglect through CPS. The bill should expressly include labor trafficking and the definitions of abuse or neglect that trigger required child protective services investigations.
So that's not the amendment. However,
Okay.
that has come up, and we've actually sought some guidance to make sure that the way that it's currently written into the bill will do that function. Although I anticipate that it will likely be amended in that section as well. So the definition is already in there under the definition section of abuse and neglect, but it's not under the name of abuse, like it's not named under abuse. The amendment that we are looking at actually is on page 7. The amended language actually at page 8. Lines 3 through 12 of the bill. So those sections would just go back to the language. There would be nothing added to that section.
Okay, so that is your amendment, and you are in conversations about the DHS amendment to figure out how it should work.
Exactly right.
Perfect.
Yes.
Thank you so much.
Thank you, Senator.
Thank you, Mr. Chair. So first of all, I need to ask a question about amendment. The Maryland Judicial Conference points out that the definition of labor trafficking in this bill is not the same one as found in some sections of the criminal law article. Are you aware of that concern? What is your response?
So I haven't seen the testimony from the judiciary. The language that is currently in the bill is language that was essentially cut and pasted, our understanding cut and pasted from the criminal section. That was the intention. So I'm not sure, Senator, if you have any other
Let me give you the citations that they give us are criminal law article sections 3-1201 through 1203. So could you go back and double check to see whether this language is inconsistent with the language there? And if it is, figure whether there was an intention,
Right.
whether it should be different or whether it should be conformed.
I saw the letter and reached out to Ms. Shapiro, and we'll try to address that.
Okay. And then I got a broader question. So suppose there's a family that's not very well off financially, and the parents make clear to their teenage son or daughter that it would be very helpful to the family if the kids were to get a job, say McDonald's, flipping hamburgers to bring home some money for the family. I wouldn't want this statute to be triggered by that kind of a situation. So are you convinced that the language in this statute sufficiently differentiates that situation from a situation in which I think we're all concerned about, where kids are just abused and turned into child laborers?
Yes, no, thank you for the question, Senator. So in that instance, this would not be triggered. So I worked at McDonald's actually as a teenager. Although I may have said to my parents at the time, I don't want to do this, that's not force, fraud, or coercion, which is required for child labor trafficking. Force by definition is holding a gun to someone's head, inflicting violence if it's not done. Fraud is something like, I'm going to offer you this, and then I'm not actually going to have it effectuated. Often with child labor trafficking and adult labor trafficking, to be frank, what ends up happening is in home country, they're told, come to the United States and work, and we will allow you to go to school. We'll allow you to learn English. We'll connect you with other resources. And then those things don't happen, and the child is forced to work. And then coercion is the implication of imminent bodily harm. So I'm going to, if you don't do this, I will hurt your sister. I will hurt your brother. I will hurt you. But it's that the threat of harm that is coercion. So just your parents saying, I need you to help support the family, and it's not in violation of any other child labor laws. So the child labor laws wouldn't be impacted or implicated in this. And then also there would not be the force, fraud, and coercion required for child labor trafficking.
That's very helpful. So tell me about the situation with the grandmother and the child who was abused.
Absolutely.
So where did that situation cross this line?
Sure. Yeah. Thank you for the question. That's an anecdote from the Safe Center for a client that we served. It was a minor at the time. He was 16. It crossed into the force, fraud, and coercion territory because he was living with his grandmother. She threatened to kick him out of the house if he didn't work, and then increased the number of hours, said you only have to work X number of hours, which he was doing. Then it became, quite significantly more hours as time went on, which prevented him from going to school. But where we crossed into the force, fraud, and coercion was that threat of, I'm going to kick you out of the house unless you continue to work in this way.
Okay.
Does that make sense?
Yes, it does. Thanks.
Thank you, Mr. Chairman. That, not for now, but I'm going to obviously look back to this memo, not only for that definition, but you noticed the judiciary had a second comment. You'll get a copy of it. Right. So ultimately, just would you all get back to us and let us know your thoughts on their second concern? Again, it's about definitions and, maybe trying to make sure we're not doing any kind of unintended consequences through the drafting. So.
All right. The expectation is I'll be sharing this letter with the advocates, and we'll see what we can do to address those.
Good. Thank you.
All right. Thank you all very much. Before you all leave out, we have we were joined by the Girl Scouts of Central Maryland. Just wanted to say thank you for stopping in and watching Democracy in Action. There you go. Yeah. All right. All right. Seeing no further questions, thank you very much, Senator Sidnor, and to the panelists. With that, that'll conclude the hearing for Senate Bill 550. We'll now move on to Senator Muse with Senate Bill 664.
Yeah, come right up. They're gonna take a picture of us. Thank you very much, Mr. Chairman. And this bill will be so easy, so easy. It'd be ridiculous to ask any questions, and I'm asking you not to. And if you have any questions, you can email me, and I'll get back to you. Whatever, I promise. Okay. Anyway, there you go. Senate Bill 644, landlord and tenant residential leases and holdover tenancies. Local just cause termination provision is a statewide enabling bill. It's only enabling. No one has to do it. It's an enabling bill authorizing a county, including Baltimore City, to adopt by local law or ordinance provisions prohibiting a landlord of residential property from failing to renew a lease during the lease period or from terminating a holdover tenant without just cause. establishing certain requirements for local law or ordinance adopted in accordance with this act. Housing is a basic human need, and the urgency for housing security should be a priority of this legislative body. Displacement from a home has a tremendous negative impact on vulnerable residents in our community and can lead to difficulty finding and maintaining a job. Student transiency and homelessness, among other negative impacts. Our current system creates an abundance of power when a landlord can remove a tenant from their home with just 60 days notice and no reason provided, causing many residents to avoid reporting unsafe conditions or requesting necessary repairs out of fear of retaliation. So I'm proud to introduce this bill to protect our residents and vulnerable neighbors from unjust eviction while giving localities an option. It's an option, just an option, to enact county legislation in accordance with state law. This enabling legislation will allow jurisdictions to determine their own just cause stipulations. That is all that this bill will do. So I urge a favorable report, and I do have a symbol here, and I'm asking you not to ask them any questions either. Then I got you any questions. Thank you. Thank you. Bless you, sir.
Good afternoon, Vice Chair, members of the committee. My name is Jose Coronado Flores, and I'm relaying the testimony of Claudia Gutierrez, who had to leave at 1:30 to go receive her children. Good afternoon. My name is Claudia Gutierrez, and I live with my husband and 2 children. We lived in Evergreen Terrace Apartments in District 47A for 14 years before being evicted. It all started when we reached out to Casa de Maryland because the complex manager entered our apartment without any notice under the pretext of fumigation, and we wanted to know if this was legal or not. We talked with other neighbors and the same thing was happening. So we started organizing and eventually created a tenant association. After this, we started receiving eviction orders because they said we had pets and that we needed to leave the apartment. Besides, the complex manager was reporting that she had compromising evidence of us having pets. When we heard the news, I immediately met with her to ask her to show me the evidence of the accusation against me, but she ignored me and showed me no evidence that she claimed she had. On the contrary, she issued more lease non-renewal eviction orders, not only on my family, but also on the 5 other families who organized as part of the tenant association. We firmly believe that she was doing this as retaliation for seeking revenge only for organizing ourselves as neighbors to understand our rights. We demand that these unjust evictions be stopped. My neighbors and I eventually went to court and were represented by Casa Legal Services on retaliation cases, but we all lost our cases and were ultimately evicted. That's why I'm here today asking for this law to be passed, to protect tenants like me and my neighbors from losing our long-term homes. Thank you.
Thank you, Vice Chair Wellstreicher, members of the committee. My name is Zephyr Shah, Assistant Advocacy Director for the Tenant Right to Counsel Project at Maryland Legal Aid. We urge passage of this bill this year. This bill is about what is fair for Maryland households that are renting at the financial edge, who are increasingly unlikely to find safe, affordable options when their lease is non-renewed. Just cause eviction policy offers a structural reform. Yes, it's about landlords versus tenants. It's about contractual rights between parties, but it is very much structural in this housing market, which has virtually locked out a generation from owning a home in Maryland. In that context, it's about what is fair. It's not an attack on landlords. On page 3 of my written testimony, you'll see a chart of 21 different just causes for eviction from 9 jurisdictions in the United States. This is just a sample. You'll see an even split, 11 causes for eviction based on renters' conduct, 10 exceptions to just cause based on property types or business uses. So on one hand, you have non-payment of rent, breach of lease, nuisance, waste, etc. fault of the tenant that can be grounds for eviction. On the other, you have a change of use, renovation, conversions, exceptions for owner occupied properties, single family properties, etc. That's on the other ledger. Tenants don't even control that. Landlords do. This is the balance in just cause eviction around the country. And localities will have the option under this bill to enshrine whichever they choose. This does not look anything like a quote life estate or infinite lease that opponents have called this bill. This bill resonates with your values, keeping families in your community for the long haul. We urge your favorable report. Thank you.
Thank you. Questions for the senator, the sponsor, or Mr. Shaw, or any of our other witnesses? Senator West.
Thank you, Mr. Chair. Well, just as a matter of interest, if a county were to enact an ordinance that says that in this county, just cause would not include the refusal of a tenant to pay a higher rent, would that enable the tenants in that particular county to continue to live in their units for the same rent and not have to pay higher rents as the tenancies expired sequentially over the years?
Okay, the senator and to the senator next to you, I don't know what part of email you didn't understand, but email me any question. No, I'm just kidding. Go ahead, give me just a minute again. I was in shock because you asked. Go ahead.
I'm sorry, that's sort of my job. So
I know.
So let's assume a particular county enacts an ordinance that says in this county, if the landlord tells any tenant that the tenant's rent is going to be increased when the lease is renewed, it would not be just cause for the landlord to terminate that tenant in the event the tenant declines to accept higher rent. Did I explain that well? The landlord wants to raise the rent. The tenant says, I'm not going to pay a higher rent.
I got it.
And the landlord says, well, I'm not going to sign another lease with you. And the county says that would not be just cause. And the landlord therefore cannot terminate the lease.
Correct. First of all, each jurisdiction can determine their own what provisions and under what provisions this law would apply. I would not see anyone, saying because my rent is being raised, that's an unjust cause and you can't convict me. People can do whatever they want, but should they do that, I'm sure that there's enough legal. Did I get your question right?
Well, I think so. So it sounds to me as what this bill is doing is enabling any county in the state in Maryland to enact rent control.
I wouldn't call it rent control at all.
If just cause would not include a refusal to pay a higher rent, and the landlord has to therefore continue to lease to that tenant at the existing rent indefinitely, that sounds like rent control to me.
Well, it doesn't to me, but I'm sure you have reasons, some reasons for thinking that. Again, every jurisdiction would be able to do that, and this is not some way to get around rent control at all. So we can talk about that.
Mr. Shaw, could you stand up at the podium and do you agree with that this would not enable a county to implement rent control under the guise of using just cause as the excuse?
And I appreciate the question, Senator West. So it's already the case that every jurisdiction in Maryland can enact rent control. That's not preempted. And so just going back to the purpose of this bill, it is simply to lift what exists now in the real property code, which is essentially a preemption, an indirect preemption on any restriction on the right of the landlord to move for eviction after expiration of the lease. So in your example,
well, if counties can currently implement rent control, why can't counties implement what's in this bill?
Well, and I was going to that. What the real property code says in what we call the tenant holding over statute 8-402 is that whenever the landlord desires to take possession of the property after expiration of the lease, on notice, which is 60 days or a different number depending on the type of tenancy, the landlord may do so. They go to court, they get that warrant of restitution, and they can evict that tenant if they've refused to stay. The state law does not require that landlords have a reason. It does not require that they state a reason at the time of that 60-day notice, nor does the court have any discretion not to grant possession to the landlord based on their failure to prove a certain reason. So,
Okay, but I think what you just said a minute ago was under existing law, if the county wants to say that a landlord can't refuse to sign a new lease with a tenant for some reason, the county can enact as a matter of local ordinance that reason, including rent control. Is that what you're saying? The counties have the right to do that right now?
well, all I'm saying is that they have the right. There is case law on this. It's quite old. That counties can restrict increases in rent, but they cannot restrict the procedure by which a landlord would repossess the property. That's
Okay.
the state law.
Thank you.
Yes,
So,
I
but to your-
understand that,
But just to,
I think if there are
I may-
further questions, we can perhaps have, you guys can have a conversation offline and,
Oh, of course.
yeah. Okay, Senator Sidnor.
Thank you very much. One question I have for Mr. Shaw, if I were to be an opponent and say we have a retaliation law, why do we need this? How would you respond?
Well, a couple points. One is that our retaliation law, unfortunately, it doesn't cover every circumstance in which a tenant does feel the chilling effect of the landlord's ultimate power to non-renew the lease. I think that was the testimony of the client that you just heard. Leases that are not periodic, so they're just for a 12-month fixed term, are not covered by our existing anti-retaliation statute. So that is one of the most common leases that you see in the marketplace. Those tenants are not protected from retaliation for any means. For those who are protected by retaliation, they're only by the retaliation statute, only certain protected activities that the tenant can prove happened are going to be protected. They have, under the retaliation statute, have all the burden of proof to try and prove the landlord's mental state, their motive for terminating or non-renewing the lease. It's very difficult. I've tried those cases many times. Short of having a smoking gun type of evidence, a tenant, and again, this is in a procedure where discovery is not allowed, tenant holding over case, the tenant has almost no way to show conclusively what the landlord's state of mind was. It's actually the inverse with just cause. In just cause eviction, however it's established in the localities, when that type of case gets to court, the landlord does have to show the burden that they provided a just cause as enumerated in whatever the local stipulations were.
What if I were to say that this legislation would drive up the cost of evictions because now forcing people to have to go to court? How would you respond to that?
I would respond, Senator, that empirically there is a study, it's cited in my testimony, showing that in just cause jurisdictions in California, eviction filings had gone down. There's a statistically negative impact on eviction filings after the introduction of just cause requirements. But more so, it is the case that anytime a tenant, okay, so in the landscape we have now without the need for a just cause to evict, a tenant can refuse to leave the property after the 60 days. That case must go to court. Landlord's gonna have to file that case whether there's just cause or no just cause. Personally, from my experience with tenants over many years, I think that when they don't know the reason why their lease is being non-renewed, they are probably going to fight that case. If they understand at the outset of a non-renewal what the good cause is, if it's established, it's written down, and it's true, that tenant is probably not going to fight that case. So that it's likely then that you might have less litigation.
Thank you very much.
Thank you, Senator Sidnor. Senator McKay has a question, then Senator James.
Thank you. Thank you, Mr. Chairman. Senator,
Yes.
you and I, well, I'll email you, but we need to have a serious talk about this bill.
You're right.
I don't want to put you on the spot.
Okay,
Okay.
send me your email
So I
right
want you
away.
to be prepared and all that kind of stuff.
I'm
And
waiting.
And I look forward to the vigorous debate that we will have about this. There are serious consequences of getting rid of the just cause. And to answer your question, sir, about the 60 days, it has to be 2 calendar months. So therefore, if you had a tenant over a period of 2 months who had failure to pay rent, you had to take them to rent court. You had to give the 10-day notice to tell them that they were late on their rent, get the date, they pay up because you want them to stay there. The next month comes on, you still have to do the 10-day again. You get a particular court date, say the 7th of December. If you say your lease is up in 2 months, if your lease is up or you're already in holdover from month to month, you have to give them 2 calendar months. So they get December 8th all the way to the 31st. They get January 1st through all the way to the 31st, and then get February, in this case, to February 29th because it's leap year. So the understanding of the just cause, in my mind, the tenant understands why the just cause is there. It just hasn't been a good relationship. And the way that the laws are set up here, it gives that tenant plenty of time to start planning on where the next place they're going to rent. And so, Senator, you and I can discuss it a little bit more, but
Great.
Thank you.
Okay.
Good idea.
Look forward to some amendments and all that sort of thing.
Yes.
Absolutely.
Senator James.
Thank you, Mr. Chairman. And you all can follow up with me afterwards. And I'm sort of in the vein with Senator McKay a little bit. First of all, get back to me on, how prevalent the problem is that you're trying to address and where it is occurring. Because I know that oftentimes an awful case with bad facts, people run and say, let's put a law in. And I'm one who says, let's be very careful before we put a law in, because maybe the passing a statute isn't the best way to solve a problem, or you might be creating more problems in jurisdictions that are not experiencing whatever issue you're trying to address. And here's my second question is more about my own circumstances, but not because I want you to tell me how to conduct my own business, but I just want to see how this works. I have a farm. I have 6 rental properties. So on the farm, we see each other every day. We have to get along. If one of my tenants tells me another tenant just is a difficult person to be around, they don't like them, and then I hear that from somebody else and there's disharmony, I'm probably going to want that person to leave. What I'm worried about with something like this is that suddenly I would have to have only certain limited circumstances that don't amount to disorderly conduct necessarily, or substantial breach of the lease, or that I want to, take the property back for some other reason. I simply want to create the atmosphere and circumstances for my tenants that I think is best for them and they think is best for them. And if somebody's not fitting in, that's the end of it. Maybe that person has been terribly disagreeable. Maybe that person perceives that they're being punished, or there's retribution. He lied about me over here to get me, evicted or whatnot. But I don't know how this law would play, how that it would affect what I'm currently doing, or for anybody else. I'm only using myself. I don't really like to inject myself. I'm just trying to give you a circumstance that you could, use the facts of to tell me how this bill would work.
Well, I appreciate the concrete example, Senator James. So I just want to say 2 preliminary things. One is the list that you're looking at in the bill of just causes is permissive. It's not mandatory. It's suggestive of what just cause is around the country, but certainly if Harford County, for instance, wanted to do something different, if Harford County wanted to, and I'm assuming the farm is in Harford. If they wanted to exclude properties of, fewer than 10 units, for instance. Well, that's not what legal aid wants to do, but if Harford County wants to do that, that's their prerogative, right? It's local control of based on what they see in the housing stock and what's appropriate there. Secondly, fitting in is actually that is an analysis that we do see. So that you're what you're saying really resonates.
Yeah.
And I will say that fitting in is already problematic under laws such as fair housing laws, anti-discrimination laws. We already restrict landlords' ability to ask someone to leave, to move out of a property because folks don't like them or their kind or something. I'm not saying that's what you're talking about, but I'm saying that in the world we live in, the world we've been in, there's already public policy to rein in that type of behavior in a contractual relationship. So the basis, there's a precedent there. And then the next thing is I'll just give you, I believe I have this example in my written testimony of a tenant who did fall into disfavor with her neighbors because she was the type of person who wanted the proximity, the sort of vicinity of her home to be nice looking. Okay. Other neighbors didn't like that. There was tension around that. And the folks who didn't like her went to the landlord and said, she's got to go. And the landlord obliged and provided the notice to vacate. Provided the right amount of time, those 60 days, the 2 months that Senator McKay's talking about. And she would have had to leave her home. The only thing that prevented that was the fact that this was a mobile home in a park. And under Maryland law, mobile home parks already have to follow, they already have to have a good cause requirement. So we were able to defend that case based on the fact that the neighbors not liking each other is not a good cause for mobile home parks. I hope that provides you some analysis of what might happen.
What I worry about with this is that we've never had a situation where somebody's going after somebody that you would otherwise consider in a protected class. That's not it. And the problem is that if 5 of my tenants are absolutely miserable, I may lose their business. I want to keep not only harmony, but I want to keep as many tenants in my homes. So I'm just giving you this as a thought about how every time we try to solve one problem, we can create others. And I'm not going to belabor that point, but thanks for your reply. And then if you get back to me on some data,
I will.
With this, what's driving this bill, I'd appreciate it. Thank you, Mr. Chairman.
Thank you to the sponsor. Thank you to our witnesses today. Thank you for your testimony and for bringing the bill. We'll now move to the opponents of the legislation.
Thank you. I do urge a favorable report. We do have opponents to the bill, but I ask you to not listen to one word that they say. They don't know what they're talking about. Act like you never heard them. Thank you.
Thank you, Senator. The order in which we have it here is Bob Enton and Bill Castelli.
Thank you, Mr. Chairman, members of the committee. Thank you very much. Robert Enton on behalf of the Maryland Multi-Housing Association. We've seen this legislation on the House side for many years. It was first introduced as a Montgomery County local bill in 2019. That bill never got out of the House. This year and last year, we saw it in the form that it's in front of you today. I have to say that not only are the landlords terribly concerned about this bill, but you have in your packet of information today a memo from the judicial branch. Now, they weigh in on a number of bills, particularly in this committee, and usually it's for informational purposes. This starts out by saying the Maryland judiciary opposes this bill. They oppose it. They oppose the notion that you're going to have 24 different standards possibly for what constitutes just cause eviction. That's very unusual in my opinion. Secondly, I would say to you that the tenant on a month-to-month lease gets 60 days notice. And if it's more than month to month at the end of the tenancy, he gets 90 days notice. There's plenty of time if they can find another property. The other problem with this is how in the world are you going to get the neighbors to come in as witnesses? Because whatever you say is going to be hearsay. It's not going to be admissible. What other contract do we have anywhere in the state of Maryland that says when the contract term is over, either party can continue in full force and effect, regardless of whether or not one party wants to go? We don't require that the tenant continue the tenancy unless they have a just cause. And it just seems to me that it is a huge overstep. And one of the most critical things, and I'll wrap up,
Mr. Chairman,
that we have in front of you, and you're going to see all these bills that deal with maintaining a stock of affordable housing. That means having rental housing that's available and affordable. This bill will have a chilling effect on that. We'd urge you to give it an unfavorable report. I can just say that Mr. Foxwell came all the way down here. He's with representing Southern Management. They're one of the largest residential rental companies in the state of Maryland.
Mr. Renton, your time has
and they're very
expired.
opposed.
Thank you so
have
much.
his written. Thank you.
Mr. Castelli.
Thank you, Mr. Chair, members of the committee, Bill Castelli on behalf of the Maryland Realtors. And as realtors, we do represent a number of property managers. I would say at least 20% of our membership is engaged in property management of some kind, mostly representing owners of single family properties. And many of our owners own maybe just a couple of properties. Some of them are investors with a larger portfolio. And one of the reasons we are very concerned about this bill is that even though it is enabling, it does lay out the elements that a local county or a local jurisdiction would be able to choose. And one of those elements is that a tenant commits a substantial breach or substantial damage on the property. That contemplates, of course, that a tenant can commit some damage. Tenant can commit some breach. Does that mean repetitive breaches? So if you do, as Senator James indicated, if you have a tenant that is throwing parties, and we have had these complaints, and in the single family, I will tell you, it's the neighborhood that's complaining to us, or possibly the HOA association. And that person, evolves. Is that a major breach of the lease? We would consider a major breach. I don't know that a court would consider a major breach. And those are the problems that we have, but it's all kinds of conditions like that. We have had complaints about tenants who live in a single family property who drive their car too fast down the street within a neighborhood with children. Every week, complaints sent to that property manager. That's not even regarding the property itself. That's just neighbors who having a problem with a tenant who's there, who really is not a good fit for that neighborhood. So there are all kinds of conditions like that. It gives us a lot of concern about what you can do in situations like that. And it's not just for the landlord's sake, but it's also for the neighborhood and the other tenants.
Thank you for your testimony. Questions for the opponents of the bill, Senator West.
Thank you, Mr. Chair. So I want to renew my question addressed earlier to Senator Muse and and the other witnesses. Namely, could a county add a provision that says it's not just cause if the tenant refuses to accept a higher rent?
Yeah, we were talking about that. I mean, the way the bill lays out, it says that a county may include, and then the 6 elements.
Right.
So would they be able to go beyond those 6 elements, or would they have to?
It starts out by saying just cause means grounds established by the local law or ordinance. It seems to be quite broad and permissive.
Senator West, it could be anything, quite frankly. There are no limitations in this bill whatsoever on what an individual county could constitute to be just cause. None. whatsoever. So in your example, I see no reason why that wouldn't go in effect. A county could pass a bill that says it's not just cause if you increase the rent by X amount. Once again, the lease is a lease. It's not a grant of a life estate in the property. Under this bill, if you enter into a month-to-month lease with someone, that tenant would then have the right to stay there for the rest of their life. Unless you could show you met one of whatever criteria the county adopts.
And in response to my earlier questions, Mr. Shaw said, well, the counties can do that already. So this bill would be enabling legislation to enable counties, if they want to do it, to establish this just cause regime. Is it correct that currently the counties have the right on their own, without this enabling legislation, to say impose rent control?
So let me say that that's a good question. I can tell you that I'm not aware that other counties have done this. Other subdivisions have done this. I don't know what would restrict them from doing it. Perhaps it would. But this has always been a policy decision up to this body to decide. And having seen this bill for the last 6 years, this body has said no. Right now, it's funny, I counted today, we have 102 pages in the Maryland Code of Landlord Tenant Statutes. 102 pages. It's Title 8 of the Real Property article. And for the most part, landlord-tenant relations are regulated here. Now, could they pass a bill? Well, if they can, let them try it, and I guess they'll end up in court and the judge will decide. But we don't think it's appropriate for you to pass a bill which says, yes, you can do this and you can do whatever you want.
Okay, well, last question. Then I saw Mr. Hill nodding from the back to my last question. So here's the question. Why do we need this bill? If counties have the right now to impose rent control or just cause regimes or whatever they want, why do we need this bill?
Hear, hear.
All right, Senator Sidner has a question.
Have you represent clients that provide?
Senator Sidner, my hearing is bad. Could you speak a little louder,
Or
please?
do either of you provide or represent clientele that that provides affordable housing through the low income housing tax credit program?
I'm sorry, say what?
Through the LIHTC program, the federal LIHTC program.
I couldn't hear him. Yeah. My translator will translate.
Yeah, do any of your folks represent LIHTC properties, federally subsidized properties?
I think we have landlords that participate with that, yes.
Have they had problems with this type of legislation?
I could get back to you on that. I don't know the answer to that.
All right, because through the LIHTC program, good cause is required.
I just, I don't know what to say. This bill what it does is it enables local jurisdictions to pass anything they want and to say you can't terminate at the end of the lease unless you meet this criteria, or that criteria. End of story.
I'm just trying to say that many of us have affordable housing, multifamily housing in our districts that were funded and helped financed by low-income housing tax credits. And you all are saying that the sky is falling, and I'm just pointing that out to say the sky hasn't fallen in the state of Maryland with this low-income housing tax credit program.
But I would say a couple of things to that point is good cause is not the elements that you see in this legislation. Good cause includes things under the federal rules, things like repetitive minor violations of the lease. So this is substantial, violations, substantial breaches, substantial damage. So there are many other elements under good cause that I don't think you see contemplated in this bill.
So if this legislation somewhat closely married, maybe what was under good cause with LIHTC programs, would your opposition fall by the wayside?
I don't know that our opposition would. I think a lease is a lease. Two parties sign it. Two parties understand that it terminates at a certain date. But I think you know, if it had more elements, it would make it less worse.
And I just want, just saying it for my colleagues, I wasn't informed, I think there are about 80,000 units in the state that are financed this way, so the sky has not fallen. Thank you.
Questions from the sponsor?
I just would say, whatever, you come up with some parameters or something that you think that we can sit down and talk about and see if there's some version of this bill that you will be happy with. As my colleague said, the sky never falls. And we pretty much, like you said, they can do what they want to do anyway. If they want to do it, they can pass it. You said the power of a county or jurisdiction is to do whatever they choose, and I agree with you. It is, but there are also a lot of things in place to make sure that they don't, like the courts, et cetera. But if you come up with something that we can live with, just present something, and we'd appreciate it.
Senator Muse, I've known you a long time. I'm always happy to see what I can work out anything that we have between us.
A nice,
And we always have.
a very nice note to complete our hearing on. So thank you, Senator, for bringing the bill in. No, in all honesty, this bill has lingered in the House for many, many years without a Senate crossfire. So I'm glad we had this opportunity to have a conversation wherever you are on the issue. So that concludes the hearing on Senate Bill 644. Senator Charles, you're next up with your 3 bills. We have Senate Bill 663 first, if that is good for you.
Very good. What a long day. All right. So this is my first bill hearing, not first time coming before this committee, but my first time as a senator. So I'm waiting for Senator West to hit me with a barrage of questions. So I'm waiting for you, sir. All right. Good afternoon, Vice Chair Wall Striker and the honorable members of the Judicial Proceedings Committee. For the record, I am Senator Nick Charles, testifying in support of Senate Bill 663. This bill establishes a rebuttable presumption in child custody proceedings that joint legal custody and joint physical custody for approximately equal periods of time are in the best interest of a child. It also still allows for the court to award sole custody or visitation based on reasonable and significant evidence that a joint custody arrangement is not in the best interest of the child. This bill is about ensuring our family law courts are truly operating under what will be most advantageous to Maryland families. If there is not sufficient evidence shown that one parent cannot contribute to the best interest of the child, what is the basis to limit the access that a child will have with both guardians? By embracing joint custody arrangements, we acknowledge the importance of both parents in a child's life. Published in the Journal of Family Psychology by the American Psychological Association, children in joint custody arrangements had less behavior and emotional problems, had higher self-esteem, better family relations, and school performance than children in sole custody arrangements. As we hear countless bills this session and ideas about how to transform the lives of our juveniles, I truly believe that we must put more focus on fixing our family court system. This bill is not just about the legalities, it's about the emotional well-being of our children. By promoting joint custody arrangements, we are not just ensuring fairness in the courtroom, but we're also giving children the opportunity to maintain strong bonds with both parents. It's about creating stability and security in their lives, something that every child deserves. You will hear unfavorable testimony today that details that this approach is a one-size-fits-all solution to complex custody hearings. This is simply inaccurate. We are not forcing the courts to issue joint custody arrangements at every hearing. We are asking them to begin at an equitable and just starting position, hear unbiasedly all the evidence presented during the hearings, and move away from allowing a child to have access to both parents if and only if it's not in the best interest of a child to have joint custody arrangement with their parents. Other factors, including abuse, parental neglect, domestic violence, sexual assault, and predatory behaviors, would and should be presented in the court of law, and no judge that has sworn to protect our children would issue a joint custody decision in those cases. Other unfavorable testimony says it limits the judiciary's ability to make decisions. In fact, this bill does quite the opposite. On page 2 of the bill in section B6, it states any other factor that the court finds relevant, which allows the courts to still come in. The courts still have the opportunity and the ability to make any ruling against joint custody when there is a preponderance of evidence to do so. Additionally, some testimony addressed the best interest of the child factors that will be addressed in another bill, which you'll hear next week on February 20th, where that bill will work to codify some of the same cases the courts use today for custody, the Taylor v. Taylor case and the Montgomery v. Sanders. This is not a new or novel to parity for families across our state or across the country. There are multiple states that already implemented shared parenting laws. Alaska, Arizona, Colorado, Connecticut, Delaware, Florida, Kentucky, Maine, Massachusetts, Minnesota, Missouri, Nevada, New Hampshire, New Jersey, New Mexico, North Dakota, Vermont, Virginia, West Virginia, Wisconsin, and Washington, D.C. When will Maryland join the ranks of states that have already understood that children need access to both of their parents on a frequent and continuing basis? I hope that happens this year. You know, just from a standpoint, 10 years ago, I came before the House Judiciary Committee on this same bill when Senator Muse was the Senate file and Senator was our House file on the particular bill. And I had my 10-year-old son who sat on my lap as we testified in support of this bill 10 years ago. And I find it ironic that 10 years later, I'm hearing about bills and I'm listening to bills that are going to address criminal justice issues addressing 10-year-old children. And if we want to truly affect change in our criminal justice system, we have to start with the families. We have to start with our families. And so that I ask now, I'm more than open to amendments for this bill and working with anybody that's opposed to it. But I urge a favorable report if we truly want to make an impact on our families across the state of Maryland. Thank you.
Thank you, Senator. I see Senator Muse's light, but first we have testimony signed up by David Smith. Is Mr. Smith here?
Yeah, David texted me earlier, said he had an appointment.
Got it.
So he
No
may be able
worries.
to come, but I know he submitted written testimony.
Perfect. Senator Muse.
Thank you. Just one question. I've sponsored this bill a number of times and objectively listened to the opposition. I've never understood the kind of opposition against what I call a very family-friendly bill. My questions would be, one, if it's enacted today, what harm, what irrevocable harm would this bill have on in any custody case, as opposed to I asked Judge DeMay this as well when she was in the House. I said, what harm? And everybody starts here. What's the problem? They never could answer that, and I never could understand why the type of opposition and the fierce opposition. Do you know at all what harm would this have? It can do a lot of good. It will do a lot of good, and a lot of people are pushing for this because it's an equal. It's equal rights. It's something that ought to be done. I just wanted you to just talk to me about some of the opposition that you remember. So why the sky is going to fall again?
Yeah, exactly, Senator. And this is something that, you know, back when you were pushing the bill on the Senate side, when Senator Carter pushed it on the House, and then she ended up taking the bill over. You know, I've been coming out before getting elected into the House or the Senate, pushing for this, and we've constantly been met with the same storyline, which is inaccurate. This gives the courts still have the ability to make decisions. We do not want to put a child in an endangered position where they're going into an environment where somebody can have undue influence and being abusive, putting them in an abusive environment. That's not something that this will allow for. And so I'm still baffled the same way you are, Senator, as to why we constantly get the same people in the same argument against this bill. This is truly about making an impact. And I guarantee all of the organizations that are against this particular bill are going to come, they probably came up or had testimony or had something to say about all of the crime and the issues that's happening in our community today. So if we truly want to make an impact on changing the lives of our constituents, changing the lives of all of the folks in the state of Maryland, we have to start at the family. I know this is not this bill, but I hear it's a bill that's coming that's going to address holding parents accountable in terms of when you're dealing with the juvenile issues. How are you going to hold two parents accountable when the courts are only allowing for one parent to get the children every other weekend? Like, that's not, it makes no sense. We need to focus on truly bringing our families together, even when there are issues that come about. Everybody probably has issues one time or another, and we have the ability to do it, and we should do it, because this is going to make the impact that impacts all of our children in a better environment, put them in a better environment.
Thank you. Thank you, Mr. Chair.
Appreciate the passion. Any other questions for the sponsor? Senator West.
Thank you, Mr. Chair. I have no questions.
I know you had some questions, but I was waiting on you, man.
All right. Thank you, Senator, for bringing the bill. Always an important conversation to have in this committee. We'll now move to the opponents of the bill, in person, Melanie Shapiro and Brett Smoot. And then we'll have virtual testimony from Lindsay Parvis. Whomever.
Thank you, Chair, Vice Chair, and committee members. My name is Brett Smoot, and I'm a staff attorney at Maryland Legal Aid and a co-chair in Maryland Legal Aid's Family Law Task Force. Maryland's family courts currently make custody determinations using the best interest of the child standard, which is comprised of numerous factors that allow the court to consider the individual facts of each case before making its decision. This bill, proposed bill, would create a presumption of joint legal custody and joint physical custody with approximately equal amounts of parenting time. And this presumption effectively ignores the very fact-specific nature of these cases and the reality that no two families are alike. The bill also makes no mention of domestic violence or abuse as it relates to whether or not something like that would rebut the presumption, which is troubling given as advocates for victims of abuse, Legal Aid knows that in those cases, an award of joint custody is especially problematic and oftentimes dangerous to victims of abuse and can subject them to further harm. Additionally, SB 663 ignores the impracticality of joint custody in high conflict child custody cases. If a case is not able to be settled and proceeds to trial, typically these parents do not communicate with one another. They cannot agree on matters pertaining to the child. And in those types of cases, joint legal custody is almost always not in the child's best interest. And so yet we're putting those cases at a starting point. And again, those are most of the cases that proceed to trial. They're very high conflict, and they're the cases that we deal with at Legal Aid very often. And so for all these reasons, Legal Aid urges an unfavorable report on Senate Bill 663. Thank you.
Good afternoon. Thank you, Mr. Chair, members of the committee. Melanie Shapiro with the Maryland Network Against Domestic Violence. Here in opposition to Senate Bill 663. Senator Charles, I wanted to address first something that you mentioned in terms of our position on this and other bills. Something you may or may not know about my background is I actually did juvenile defense for 20 years. And one of the reasons I moved into this role is because I saw the impact from the trauma that children were exposed to and thought that if I could help address domestic violence, I could help reduce the trauma that they're experiencing and divert them and help them not enter the juvenile system at all. I do, however, have concerns about this bill in context of domestic violence situations where there is inherently a power imbalance. And so starting at a presumption of joint custody without recognizing the nature of the power and control dynamic that exists for a victim parent to then have to rebut a presumption over joint custody is going to be incredibly problematic. It's one of the reasons that in courts already they're screened out from mediation, because mediation assumes that parents are on an equal playing field, and that is simply not true in a situation where domestic violence is present. That's not to say that there aren't cases where there is domestic violence in the home, that it's not 100% appropriate for that child to have equal time with each parent, because those cases do exist. However, we think that the best approach would be to retain the best interest of the child standard. There is a factors bill. I know that there's two different bills. Senator Charles has one, Senator West has one. We think that having those factors would be most appropriate, because then it gives the pro se litigants the opportunity to understand exactly how the court is deciding. It retains the best interest of the child standard, which we think is how custody cases should be decided. So for all those reasons, we are opposing Senate Bill 663.
All right, we'll now hear from Ms. Parvis. Welcome.
Thank you, Mr. Chair and members of the committee. I am here on behalf of the Family Law Section Council and Family Law Section of the Maryland State Bar. We are opposed to Senate Bill 663 for the same reasons as have been already articulated. I will not repeat those. I think that we submitted very detailed written testimony that I'm also not going to repeat for you, but I commend that to you because it talks about some of the significant disconnects within the bill were that to pass. And one of the concerns that I will voice about this is that having a presumption, and maybe this is because I just still have the custody evaluator standards bill and the testimony I was hearing there from yesterday on my mind, but having a presumption increases the likelihood, or I guess I'll say it invites the opportunity for decision makers to be less thoughtful about what a specific family needs and focused on the best interest factors. And when you have some of the highest conflict, most complex cases going to trial and having this 50-50 were this to pass standard apply, it would be a real disservice to those families, because those are the families who have been unable to resolve their differences any other way and have turned over decision-making about their own children to a judge, either to make important factual findings, I'll just finish this thought, to make important factual findings or to decide it for them. Thank you.
Thank you very much, Ms. Parvis. All right, questions from the committee. We've got several. Senator Muse, you're up first. Yep.
Thank you very much. And to either of you can answer this. Show me where I'm wrong. All we're saying is that each starts equal. And the more information the judge gets, you either go down or you remain where you are. What about this? You made a statement that it appears that you have knowledge that anytime if this were enacted, it shows that almost always it has a negative impact on the family. I'd like to know how, give me some concrete, because sometimes we talk as if a judge cannot say, oh, gee, that's bad, shouldn't be. That's how it's been talked about. So I want you to explain to me how, for example, concretely so, that this bill would have a negative impact on domestic violence cases and families. I'm kind of baffled at some of the hypothetical situations that you're giving. That seems like judges either stupid or they wouldn't know the difference in how to apply it in a way that would not have some negative impact. I just want to know from those two examples, give me sure anybody.
Sure. So let me, there was a couple of things in there. So let me just the first one, and it actually relates back to something that Senator Charles said. So the idea that you're starting at an equal place, that already exists, in fact. So in the statute, in the family law article, I believe it's section 5-203, subsection D2, something like that. It says neither parent is presumed to have a custody right that is greater than the other parent. And so you have two parents with the same legal standing, starting on the same equal footing, with this legal standard that encompasses all the factors, the totality of the circumstances, and either parent can present evidence to try to persuade the court that one arrangement or the arrangement that they want is in the best interest of the child as opposed to the other parent. This proposed legislation tries to a certain extent, predetermine the result to try to work towards a goal that parents have equal custody and equal parenting time, approximately equal periods of parenting time. And ideally, if that were to be found to be in the child's best interest, then that's great. And legal aid is all for that. We're certainly not against joint custody and approximately equal periods of parenting time. It is the presumption that that is in each and every child's best interest. In any individual case, that's problematic because every case is unique and every case requires its own unique solution. So that's why I think that the parents do start at an equal starting point right now. And what is proposed now as well is with the rebuttable presumption by a preponderance of the evidence. So that doesn't necessarily work like you have a 50-50 split right now and you present a little bit of evidence and it might go 51-49, 52-49. To overcome the rebuttable presumption, as Senator Charles said, that requires, in his words, significant evidence to rebut the presumption at all, or we're going to have this 50-50 split. So that's kind of where I think now we have a legal standard set up in a way where both parents per statute start on equal footing and either one has the opportunity to present evidence and make their best argument. And the court is the one who's, as of right now, unencumbered by any presumption to make the decision about what's in the child or children's best interest. And so, and I think that is, equitable, at least from the child's standpoint, as opposed to the parents having necessarily equal rights, or they do have equal rights, equal parenting time, because they do have an equal constitutional right to parent their child. And right now the statute says that neither one is presumed to have a greater custody right than the other one. So they do start on equal footing. And just in relation to the domestic violence example, yes, we would hope that the court in those extreme cases where they're really high conflict or there's domestic violence involved, that they would recognize that and that would rebut the presumption. But right now there's no language in the bill that suggests that is assured that that's going to happen. And so for that reason, it's problematic.
Why don't you put the language in and let's take a look at it. I'm still as confused as I was before, and pardon me for not understanding, but it just seems to me if this could go a long way in making sure that right now what we're faced with is that 72% of our children are being raised by single parents. What do we do to ensure that there is an incentive for both parents to be involved? And so this is just my little sermon on it. I don't understand it. I never will. Maybe somebody else can enlighten me on what it is that I'm not understanding. But thank you.
You're welcome.
Thank you, Mr. Chair. So one of the things you mentioned was when domestic violence is present, we don't have anything that the courts can necessarily use, right? Did I get that correct?
So thank you, Senator. So the bill as drafted does not address domestic violence specifically, and inherent in domestic violence is an imbalance in power and control. It falls under the gender-based violence power and control dynamic. And so the parties aren't starting on equal footing, which is part of why the family law already recognizes and screens out domestic violence cases for mediation, because inherent in mediation is that the parties are in an equal playing field. So you're then putting, and some families, the domestic violence, the solution is one party seeks a divorce. It's not that they get a protective order or call law enforcement, they seek the relief of the family court to exit the violent situation. And so a case there's no screening out for domestic violence present in the rebuttable presumption, and you're putting a victim parent, understanding that could be either party, in a inferior position because they already are in an inferior position with that power and control dynamic.
So question then, this kind of reads clear as day to me in the bill. It says any other factor the courts find relevant. Any other factor. So if we're talking domestic violence, if we're talking abuse, if we're talking anything, it says any other factor. It's clear. And so I'm trying to understand where you see that cannot be tied into that particular piece of language.
So let me see if I can explain it differently. So you're still putting the victim parent in the role of having to demonstrate the violence to the court, and just having to go through that process, one, is incredibly traumatic. And two, it's not appreciating that they might not be able to do so as the victim who has experienced the domestic violence. They're already in an inferior position.
So question to that then how would that information get out there? They're not going to come into court and the judge is just going to automatically know out of thin air that domestic violence was taking place. Somebody has to say something so that the courts understand domestic violence is a part of this particular case. So they have to say it.
Well,
Correct?
if under this bill as drafted, they would have to say it. They would be the same as any other party if they are represented. It's different. Many of these cases are pro se. And so one, without the factors, they don't know what they need to prove. Two, rebuttable presumption is an incredibly high presumption. It's not clear and convincing. It's not reasonable doubt, but it's a preponderance of the evidence is a very high standard. And there are already cases that are screened out for domestic violence in the Maryland rules because we recognize that they are naturally not the same. It's not the same as any other divorce where the parties simply, for whatever reason, don't want to live together anymore. It is an entirely different dynamic. And so by not identifying one specifically domestic violence and any other court that the court finds relevant, certainly I would hope that they would find domestic violence relevant and they would weigh that in terms of the best interest of the child, because like I said, there are cases where even if there's domestic violence present, it's appropriate for the child to have. So
how about this? How about we add an amendment that specifically calls out domestic violence? And this, I thought I put the bill, the latest bill we did, this was because we ended up putting that in, I think a later bill that we pushed a couple of years ago. But let's add that in there. Would that make you happy? So
it's a start. I think I would want the cases that involve domestic violence to not, I have not read it. I know DC has specific language, and I think it carves out domestic violence cases entirely from the rebuttable presumption, but I would have to get back to you on that.
I just go back to say we got 20 states already that's doing this. And so the fact that Maryland has not taken a position on this, all of these years and that we're dealing with right now, when it comes to violence in our communities, 70% of our children are in single family households. This is something we have to address. It is something we really need to take serious as a state. These children need both of their parents in their lives. Thank you, Mr. Chair.
Okay, thank you, Mr. Chairman. I'm all over the place. I've been writing down questions so frantically. I never wanted to ever be in this bill hearing because I'm just extraordinarily conflicted about this. I mean, for the last 14 years of my time in the legislature, I do have a question for Mr. Smoot, but I just want to start by saying I completely agree with Senator Charles and Senator Muse about the importance of fathers. I have 50-50 custody with my kids. I think it is profoundly important, and I would like to see us move in a policy direction that recognizes that. That being said, I have so much compassion and empathy for the advocates who are concerned that a vast change like this might really put the most vulnerable in an even more vulnerable position. So that is what I am struggling with, because I am hearing what Mr. Smoot and I think Ms. Parvis said about sort of the folks who end up in the court are those folks who are in the most high conflict situations. And I had a extraordinarily high conflict divorce. It lasted 3 years and we still didn't end up in court. So I can only imagine what the folks who end up actually in court, what their situations are like. So that's my question to you, Mr. Smoot, is can you just sort of tell us a little bit about sort of what percentage of these cases where there might be child custody involved and end up in court, right? Like it's a small fraction.
It's a small fraction, and I will say that I don't know that exact statistic. I know that just a few days ago, we were here for a different custody factors bill hearing, and it was said that 80% of cases settle and 20% or so proceed to a hearing. I would have to,
No,
verify
that's helpful. That's a good
but it's a
starting
smaller
point.
percent.
Because that was sort of my other question, and I'm not sure if Senator West was going to ask this, but I would like it if you would frame for me sort of the difference between the two approaches, the factors bill
Sure.
and this bill.
Sure. So the best interest factors, they are currently contained in case law. And so there's a number of factors, a list of factors. They can range between what case or cases you're looking at, between 10 to 12 or more. And then there's a catch-all in there, I believe. But, as I mentioned, currently in the statute, we have that neither parent is presumed to have a greater right to custody than the other parent. So when you're talking about equal legal footing or standing, they are coming to court with equal standing, and their right to the child at this point, assuming there's no prior order or anything like that, the right to custody is the same, or to be granted custody is the same. The right to access is the same. And each parent has the opportunity to present testimony and evidence about what they believe is in the child's best interest and what the custody arrangement should be. And then the court gets to make a decision unencumbered by any presumption before even walking in the door. With this bill, with Senate Bill 663, before you're even coming into court, you are presuming that it is in the child or children's best interest in that individual case, before any evidence has been heard, that it is in that child or children's best interest that the parent should have joint physical custody with approximately equal amounts of parenting time, which is very specific and I would say kind of rare, especially in high conflict cases to happen, and also have joint legal custody, which in high conflict cases is even more rare. So it's presuming that in these high conflict cases, the ones that are most often going to court, that it's almost assuredly not in the children's best interest to have that sort of arrangement. So could you rebut it? Yes, possibly. But again, as it was said, a preponderance of the evidence is not the easiest legal standard. And it doesn't necessarily go 50-50 with you have a rebuttable presumption that, oh, you can get to 51-49, that's what it's going to be. You have to get to a certain preponderance of the evidence level to rebut the presumption at all, or the presumption is going to prevail. And that is what the arrangement is going to be, along with what the court orders. So that's the difference in the two approaches. The best interest factors is a more holistic approach that allows either side the equal opportunity to present testimony and evidence, and the court, unencumbered by any presumption, can determine what it feels is in the child's best interest. And as my fellow panelists said, that is what they've tasked the court with doing by filing the case and being unable to settle and going to the finder of fact, which is the judge.
And do you think that under the current system, there's a bias against fathers? Have you seen that? Does data prove that out?
I don't have the data, but I have not seen that in the cases that I handle, that there's, any particular leaning one way or the other. I would say, if anything, it has gotten better over the years. I think historically there may have been a bias towards mothers, or that may have been a thought. I think that as we've progressed, that has lessened.
Thank you very much.
Thank you so much, Mr. Chair. This is a very important issue that's been around for a long time, and I hope that finally its time has come. I want to ask a few questions because I apologize, I was late. I missed the beginning of the hearing, but I haven't heard you state any specific facts or empirical data, only your opinion or your experience in the cases that you've handled. Do you have any facts? Do you have any information or data about in Maryland currently, when these 80% of cases that do not go to court, which party is the primary custodial parent, and in what percentage of those cases is there an equal shared parenting arrangement?
Sure. So I don't have any data on that specifically, but what I would say is that in those scenarios, when cases settle it is because, obviously the parents have agreed on something, but also they have to have that agreement ratified by the court and found to be in the child or children's best interest. So, I've seen cases where parties agree to something.
But you don't know like what percentage wind up being one parent favorite for the primary physical custody over the other versus when it's equal. You don't know. Can
No.
you guess at a percentage based on your experience?
A percent, guess at, I'm sorry, what percentage are you
Yeah,
asking?
so the
about?
80% of cases that you say don't go to court,
Mhm.
what percentage of those settlements are an equal parenting arrangement?
I don't know the answer to that. It's, again,
Would you
whatever.
agree that historically and traditionally, mothers have been assumed to be the primary caregivers?
I think that may have been the thought in the past, and it may continue, but again, I don't think that necessarily biases any court, any fact finder who is tasked with making these sort of decisions. And again, if parties have agreed to one arrangement and the court finds it to be in the children's best interest or the child's best interest, then the court's going to go with that. They don't necessarily want to intervene and have a custody hearing if they don't have to.
So you've said a number of times now that you don't have any actual data, but I've read, and I'm happy to produce for anybody that's interested, a mountain of research that contends that children generally thrive in environments where they have a relationship, a strong relationship with both parents. And so, since we know, if we accept that as true,
Sure.
Then would we not need to accept that we need to start with the presumption that we should have these arrangements involve both parents at the start?
I think
Or
that
do you not accept that as true?
I accept that, and legal aid would accept that both parents being heavily involved in the children's lives, if found to be in their best interest, given the fit and properness of each parent after the finder of fact finds that, is absolutely the case. I think that in those cases where, and it's a little bit of chicken and the egg perhaps, where yes, cases in which, the parents have close to equal parenting time, 50-50 access, joint custody. Yes, it makes sense that the children are flourishing in that sort of arrangement, but those are also the cases in which that particular arrangement was found to be in the child or children's best interest.
So what about a rebuttable presumption of joint custody where it is not in the best interest of the child, it's then rebutted? What about that do you take issue with?
Sure. I take issue with, and we, would say that to have this rebuttable presumption that any particular custody arrangement is in any given child or children's best interest is problematic because it hinders the court from hearing the totality of the circumstances to the maximum it actually can to determine what's in the child or children's best interest.
Would you support legislation that reversed the child support guidelines where there's a rebuttable presumption that these guidelines are going to be in place for all child support arrangements? It's a rebuttable presumption the guidelines apply. Is there a problem there?
No, and I agree that both parents have a financial obligation to support their children. That's very important.
But it's a rebuttable presumption that these guidelines are accurate, that they have to be followed. Do you see what I'm saying? So we start at a place there. We start somewhere.
Yeah, and I don't know the child support statute in particular and whether it has the same sort of language that is located in the family law article that states that each parent, or excuse me, neither parent is presumed to have a greater right to custody. I'd have to look into that.
So this is really about the child's best interest because all of the research does show that children fare better when they have a strong relationship with both parents at different stages and all stages of their development. I believe that the advocates for this bill, and I am a proponent of the bill, simply want better families and a better society and better outcomes for kids. We know that traditionally, and you don't have the evidence or the data, but I've seen it in the past, and for anybody that's interested, I'm happy to find it again. We know that overwhelmingly, these arrangements, even when they settle, a mother as primary custodial parent, even where both parents are fit, and even where there is no history of domestic violence. And we know that inevitably, there are arrangements where when mother is primary custodial parent, father is secondary custodial parent or a visitor, for the most part, a visitor with the children who pays child support, the lion's share of child support. That's not always the case because we have a society that's always evolving and we have same-sex marriages and we have gender equal relationships. But traditionally in that traditional family, mothers are the primary custodial parents. I think it was 85% years ago when I looked at it. 85% of the time. This is a case that's settled. And finally, I want to just, I guess, I don't know if it's a question, Mr. Chair, but I want to point something out to you. You've said a couple of different ways and times that this small percentage, this 20% that go to court, most likely it's not the right thing. I don't think we're talking about that. I think that even more cases would likely settle if parents knew that they're starting at an equal footing in the beginning. Because you've talked about your experience, I'm going to tell you briefly about mine. My experience is I have people that I know, I have clients, I have relatives all over the state of Maryland, and they have had so many different custody cases. And although even when I'm not a primary attorney for them, they come and they bring their situation to me and they ask me my opinion. I would say that I would guesstimate that 99.9% of the time, they hire an attorney, a family law lawyer, the male, the father, leading up to from the time they hire the attorney until very close to the trial date. The attorney advises them that they're going to fight for them. They're going to fight for them to have shared custody. And then inevitably, very short order prior to the trial, they say, oh, the judge is going to look really bad upon you if you have to fight this. You don't want to fight this. The best you can do is go for joint legal custody, let the mother have the primary physical custody, and we'll work out a fair child support arrangement for you. And so, yes, I agree with you that 80% of the cases settle, but they don't settle because people feel that this is they feel like it's the best they can do if they're on the losing sort of short end of the stick. So what this bill would do is not put one party in a position where they feel like, I can't win this. I absolutely can't win. I got to take whatever I can get. They would put them in a position where they know that they are viewed as having a value in the eyes of the law and their children. And if they are in fact in a situation where they cannot share equally because either they don't live in close enough proximity where it's in the best interest of the child to go back and forth, or some other reason their job is too demanding, that a myriad of different factors would rebut that presumption that they would be an equal parent. But in this state and in my city, where there are so many single head households, anybody that stands in front of us and says that our system is currently fair and equal, and that we are having fair and equal outcomes for children and fathers, we have a system that is based upon relegating the father to a second-class citizenship, removing the father from the child's life. And after all of the years that this legislation has been around and been debated, I actually find it appalling that you would stand here and tell us that the system that we have works, because it does not. Thank you.
I'm curious, because and I think my colleagues on the other side, they've already mentioned one of the questions that I had, which was about, the reality is culturally, I think we all believe that mothers are more nurturing and more deserving to raise children. That's our culture. I think a number of them, they've asked about data that we don't have. So I guess my question is, how do we get that data? Because I can remember Senator Charles, since when he was Nick Charles, not in this General Assembly, advocating for this same thing. We hear it each year. So how do we go about getting this information? Who is there anyone that can collect this information so that we'd have it to look at?
Sure. I would say I don't know necessarily how we can collect that data, but what I would say is that in terms of trying to ensure that the parents start at the same place, again, I can't stress enough, standing wise, they do. They have the same legal standing, and I
Right,
completely.
that's legal standing, but culturally, as I think is what I've been hearing my colleagues talk about, culturally in this country, I think most folk are gonna lean towards mothers. Right?
Sure, that's a way of thinking.
Okay. So go ahead.
No, I was, apologies. And so, what I was just going to say that in terms of, starting at an equal place, I mean, standing wise, they do, to put the presumption in there that in any individual case, it's in the best interest of the child for there to be a exactly split arrangement, that assumes a lot. And especially in these high conflict cases, and again, the ones that most often go to court, the ones that involve domestic violence and child abuse. Again, while the presumption could be rebutted, it's problematic.
But what if it doesn't involve domestic violence? It's just two people that they really just don't get along, but they love that child equally.
And if they're both fit and proper to do so, then I would think that in those cases, the court using the best interest standard, best interest of the child standard, would grant some type of shared physical custody arrangement, perhaps with joint legal custody. Maybe if they're particularly poor at communicating, one parent has tie-breaking authority. But
Right, so I mean, what does,
sure,
I guess it goes back to the question, what does the data say? I mean, how are the judges ruling? What's happening in reality? What's happening out there? Is really, I think, the question that many of us are kind of just asking.
Sure. And I would say that while, again, legal aid completely agrees that it is best when the child has both parents involved heavily in their lives, it's to presume that this specific type of arrangement at a starting point is the best in every individual case is misguided.
Okay, thank you.
Thank you, Mr. Chair. Let me direct my questions to the representative of the State Bar Association, who is still online, but has been very silent for the last 25 minutes. So when we're talking about a rebuttable presumption, here's my impression of what happens. These cases, and I'm trying to direct my remarks to Senator Kelly as well, because she expressed some genuine indecision about where she comes down on this thing. These cases are probably the most difficult, nasty, protracted, embarrassing decisions that come before a court. If the parties could work them out, they would have worked them out. The reason why they're in court before a judge is because the parties couldn't work them out. And the information that comes out in court is incredibly personal, incredibly difficult to present and to hear. And so when you have a rebuttable presumption, isn't it the nature of many judges to say at the end of the hearing, you know, there's arguments on this side, there are arguments on that side, but the rebuttable presumption is joint custody. And so that's where I come down. So it enables the judge not to make the difficult decisions that the standards, which I presented a week ago in my case, in evaluating these standards on a one-by-one basis, and then trying to figure out how they cut when they're all evaluated as the law requires. It makes it easy for the judge to say, well, there's a rebuttable presumption of joint custody, and therefore I'm awarding joint custody. Am I correct in that?
That's right. There's first a philosophical piece, and then I'm going to use the child support guidelines as an example, since that had come up in other questions. So the philosophical piece is the custody or best interest factors that is focused on the kids, right? What is in this child's best interest? The 50-50 presumption from a philosophical standpoint is about the parents' rights. What are the parents' percentage time rights with the child, right? So there's that driving it, and therefore in these highest conflict cases, it's putting the emphasis from the start on the parents as opposed to the children. Now, to use the child support guidelines as an example for what a rebuttable presumption looks like in action. So the child support guidelines, because they presumptively apply, this is what is calculated. And it puts the burden and the responsibility on the parents of having to persuade the decision maker why those guidelines should not apply. And the purpose of the guidelines is to help make it standard and the same across the state, across the board, so that every child is treated the same way support wise. Okay. So what that does is it has this it can be viewed as very beneficial, but very sort of automatic approach to making the decisions, because it's the rebuttable presumption, the guidelines apply, and then the parents have a much heavier lift to try to show why they don't. So to take that real action experience, just advance it to a presumption of joint custody. But here in Senate Bill 663, it's not just a presumption of joint custody, right? Because now we have, because of how shared physical custody is defined in our guidelines, it's a spectrum of 92 to whatever the other end of, I'm not doing math well at 4:06 on a Friday afternoon. It's this spectrum of shared physical, right? We're not talking about this sort of spectrum of time even within this, right? We're talking about 50-50 time regardless in this bill. We're talking about it regardless of all the other factors, regardless of the distance between the parents, regardless of the status quo on a pendene lite basis. So the pendene lite is a temporary hearing meant to look at, okay, where are we starting out and how can we help kind of preserve some normalcy here while this case is going on. And the bill doesn't take that into account, and it includes on page 2, it's section B, these factors that can be considered for the best interest. And those factors are, they may resemble, some of them, the factors under existing law, but this bill not only creates a rebuttable presumption and 50-50 parenting time, kind of regardless of the facts and circumstances, but it also creates a new legal standard for determining best interest factors. So,
okay, well, that's helpful. Let me just finish up by going back to my concern that a judge who's heard lots of testimony about that spaghetti dinner, which ended disastrously, the visit of the mother-in-law, which was a total nightmare, et cetera, et cetera, et cetera. It's so easy. It's my view of the rebuttable presumption. It's so easy for the judge to say, well, there are arguments on both sides, but because the law says rebuttable presumption, that's where I'm coming down. I'm awarding joint custody because that's what the rebuttable presumption provision in the law says. Isn't that what's likely to happen if we adopt this as a matter of law?
It invites that, and it invites it with the sense of the family can try it and fail, even though the facts and circumstances may already point to this is not in the child's best interest. And then they're left to go through more litigation to modify when it doesn't work. And then they're still going to butt up against this rebuttable presumption.
Okay. Thank you so much for your answers.
You're welcome.
Sorry, I never try to ask 2 questions, but since Ms. Parvis is here, I thought she had a lot of expertise. So forgive me for taking too much time, but this is such an important issue. What I'm hearing kind of unfolding in this hearing, and I would like your response to this as just a professional who understands this stuff. Near as I can tell, it seems as though people have really different understandings of the impact based on sort of their social and cultural location, and that maybe someone might be looking at the laws as, or the current process as something that, you know, men are powerful and a system might be designed to benefit them. And other people might be looking at the same exact process as men are disempowered and this system has been designed or has the effect of really not leaving them empowered at all. And both things can be true depending on your social and cultural location, right? That the current system maybe is designed in certain ways to protect some parents, and certainly the children, which is what we're really focusing on, you know, protect the children of some parents, and that may be actually disadvantaging the children of other parents in certain ways in terms of making sure that their fathers have appropriate access and those types of things. So this is what I'm struggling with, right? Because I genuinely believe both sides in this conversation, because I know it. I hear Senator Carter's passion on this. I hear Senator Charles's passion on this, and I believe them to be telling the truth from their lived experience. And yet I also have the lived experience of other folks I have spoken to who have an entirely different experience within the legal system. And that this is why I'm really struggling with this. And so I would like your thoughts on if that could be true, and the bigger picture, sort of coming back to Senator Sidner's point, which is we don't have data. And even if we had data, we would have no idea what those individual parents were actually looking for, because every family was unique. Right. So in my situation, I desperately wanted 50-50 custody, and my ex-husband didn't want custody and didn't want to be a dad. He said, let me give you as much money as you want. You go be a full-time mom. Because that's what happens in Bethesda, right? But maybe not in other parts of the state. It's true, right? I had to fight for 3 years to get him to take 50-50 custody. And I know that's not why this bill was put in, right? For situations like that. So I would like for you to help me reconcile the fact that this system can be designed to protect children and women in one situation, and also could have potentially the impact of hurting fathers and children in another situation, and how we can maybe move forward with a policy statement in some way that, you know, affirms that we want fathers to have equal rights in the state of Maryland. I know it's a big question, but I want your thoughts on that.
In doing my best to unpack that, what I was hearing is you're seeing the and in this, right? Like that there can be, that there are the different experiences, and even if you have the same parents go through the same experience, same situation, they can view it entirely differently. Having said that, which is not, I think, helpful at all, is that one, to the data, to my knowledge, I'm not aware of the Administrative Office of the Courts or anyone else tracking the data to the granular level that this committee is requesting. I understand the request, but I am not aware of it existing in terms of what specifically was requested, what the outcome, what the result was, much less what occurred afterward. And my sort of high level response is that the families who go through litigation, I mean, I represent parents in contested custody litigation. I've represented children in their parents' contested custody litigation. I've not had the experience when these families who go through a contested trial, I'll circle back to settlement just in a second, but who go through a contested trial, none of them have said to me, and I would think I'm not someone who believes none is the answer, right, ever in things, but like, none of my clients have ever said to me, that's an experience I want to have again, right? The trials can be so very destructive to the family unit, right? Like in the pursuit of what you're talking about, in the pursuit of under Senate Bill 663, this 50-50 parenting time, they go through a very destructive legal process where they are testifying against one another. They're witnesses, they're bearing the innermost details of their family, the good, the bad, mostly the bad and the ugly. And then they are supposed to come out of that experience as if they can now functionally and safely co-parent their children under this 50-50 arrangement. So there's that one piece. So when you get to these highest conflict folks who are going through that experience, you know, it's a smaller number. I'm saddened to hear that it may be as high as 20%. Historically, in my experience, the number of cases that go to contested merits trials tend to be, you know, a much smaller, the single digits. So I'd be curious about what shifts may have happened there, if any. But when it's settlement, to your point, right, that on the settlement side of things, if parents would have settled their cases, then it's settled, right? They have their chosen outcome. And the presumption, the presumption in action isn't really going to drive the outcomes. I'm not saying it the way I'd like to. The cases that are going to settle, like they're going to get there. It's really this small group that just are heading to the end. And that's where you can really, for this small group of high conflict people, this is how you can end up in the and, right? Because people are handing over the decision-making about their children, who often are the most important people in their lives, to a stranger to them, who over the course of this short period of time has to figure out all the finer details. And the trial system is what it is, right? But it's never going to know people's children the way the parents do. And that's how you can end up with these very different
experiences. Just to cut you off, because I think I love everything you're saying, and you've completely, I get where you're saying, where you're at for the cases that go to trial. It makes sense to me. It's been explained to me thoroughly why the structure of this is not necessarily in the best interest of children. That being said, Senator Carter's point, which I thought was very good, we still haven't addressed, which is I believe, having gone through a pretty high conflict divorce and custody negotiation, that what a judge would do is something that becomes a major factor in the settlement process. And so I think for me, the policy question becomes, how do we not let what a judge would do influence people away from shared custody in the settlement process? I think that that's a really big question to answer. I don't know that we have the information to answer that yet, but you were talking a lot about the, you know, single digits of cases that go to trial. And it sounds like, from your professional opinion, you don't think the concept of what a judge would do influences how people settle?
Well, I mean, the concept of what a judge would do, I think of more as being, one starts the case in one place of knowing or not knowing the facts and circumstances. They develop over time as the evidence develops, right? And I'm not saying evidence before a judge, but through this discovery and gathering information that parents may do, then one starts to think about, okay, how does this measure up against the law? And that is where the question comes up of, what would a judge do? And what I have experienced myself over time is that in the counties where I have practiced, and it's been a variety of counties, but not statewide, and I don't claim to have that knowledge, but there has been a shift in, I think, the thinking about the family and involvement of parents and what significant, what preserving the relationship looks like for separated families. One can have that thinking about how can we help preserve the relationship without also having a
We're gonna have
50-50.
to, thank you, Ms. Roberts.
Thank
I
you.
was gonna, if we could just curtail some of the answers a little bit. I know we've got a
course.
lot to go. Just, apologies. It's been a long week. It's Friday at 4, and we got a little bit to go. All right, Senator Carter.
Promise to be brief. I don't know that we're gonna see eye to eye at any point if we went for the next million years. But I think it's sad because of the current state of our families and our societies, because of the laws that we've had in place that have had an inherent bias. My question to you, Ms. Parvis, is because several people, or at least 2 senators on this committee, have stated that you are an expert. Clearly, you have a long history of practicing in the family law area. So if you can give us some idea of this, how many custody cases have you handled? And of those custody cases, what percentage of those cases resulted in shared custody, equal parenting? What percentage resulted in the mother having the primary physical custody and the father being a child support payer that visited?
First, I'd like to dispel the idea that I am an expert. I'm somebody who's passionate about this, but I cannot give you a specific number of cases that I have had. I can tell you I've been practicing family law since 2002. I've had more cases than I can count over that period of time. The majority of my cases have resulted in shared physical custody, pointing to that spectrum, right? Shared physical custody for the vast majority. And I mean, in fact, I've had cases, if one's going to be gendered about it and speak to a mother-father family, as not all are, I've had cases where fathers end up as the primary caregiver.
What percentage of those cases?
So
what percentage of those cases?
It's a smaller,
We're not saying it never happens. We're saying it's,
Yes.
I believe it's in a minuscule number of cases. So I'm asking, of the vast majority of cases you've handled since 2002, and I probably should have asked, do you equally represent either side, or do you have one side that you tend to primarily represent?
I'm equal in the clients I represent. Yes,
So of
in
the
terms of their
cases that have been
genders.
resolved that you've handled, would you say that the vast majority of those cases end up, even though you call it a shared parenting arrangement, where there is more physical time spent with one party or the other? Or are they 50-50 cases? Or do most of your cases result in 50-50 shared equal parenting? Joint custody?
In the last decade, yes.
The majority, actual
Yes.
joint custody
Yes.
in the last decade?
Yes,
What
and this is a norm that I have seen develop across the state, but I'm trying to
Do you
honor
handle cases in every jurisdiction?
the brevity around the. No, as I stated before, I do not. I will list them if that's of use to this committee.
No, I'm just curious because, again, I said other senators have deemed you an expert. I don't know, but I'm assuming you've had a lot of cases. And so I was wondering, since you have a particular opinion, what the result of those cases has been. But you've answered it. You say that you just testified that over the last decade, the majority of cases that you've handled in custody have been a 50-50 joint custody arrangement.
Ms. Parvis, I think.
All right.
Asked and answered. Good. Further questions from the committee? All right. Thank you very much. I appreciate it. With that, that'll end the hearing for Senate 63. We'll now move on to Senator Charles, Senate Bill 664.
Mr. Chair, it is Friday and I promise to be brief with these last two bills that I have. Obviously, you know how I feel about that other bill. So thank you. Good afternoon, everyone. For the record, I'm Senator Nick Charles testifying in support of Senate Bill 664. This bill aims to enhance the safeguards for individuals engaged in land installment contracts in Maryland. In 2022, the Brookings Institute released a national study on appraisal bias that showed the cost of de-evaluation across 113 metro areas in the United States of America with at least one majority Black neighborhood, which is approximately $162 billion in lost equity for Black families across our country. After the study, I asked the Brookings Institute to help come up with a solution to the problems they found in the study, and they submitted a package of bills, with this being one of them, addressing land installment contracts. These contracts are non-traditional property financing arrangements where a seller finances a buyer instead of a bank, with the buyer managing the property and making payments until the full purchase price is met. Land installment contracts serve as a vital pathway to home ownership, particularly for those facing credit challenges or emergency housing crisis. Benefits exist for both parties engaged in these contracts. However, historically, these types of contracts have been associated with predatory selling practices that exploit vulnerable and unsophisticated buyers. Maryland's current regulations framework provides some protections for buyers. However, there remains critical gaps that expose land installment contract buyers to abusive seller practices. Senate Bill 664 proposes essential amendments to Maryland's code governing land installment contracts aimed at providing greater protections for buyers. The proposed revisions outlined in the legislation include requiring comprehensive documentation of the contract, including signatures, dates, and copies for both parties, and mandatory title searches and disclosures of findings. It also reduces the threshold for vendors to mail or deliver statements to the purchaser when 20% of the original cash price of the property has been paid. This drop from 40% to 20% allows for the buyer to see sooner their ownership and equity in their property. This bill received a unanimous vote in the House during last year's session, but was scheduled for a judicial proceedings hearing on the 23rd of March and did not have enough time to move forward. So I'm hoping now that I'm on the committee, we can move forward on this. Supporting this bill is the Assistant Attorney General, Kira Walton-Welburn from the Consumer Protection Division, and she noted that the division has received complaints regarding unfair practices associated with land installment contracts. The Consumer Protection Division's testimony supports a favorable report for this bill, citing the enhancements as beneficial for consumers and urging the committee's approval. By strengthening the language and closing these regulatory gaps, Senate Bill 664 will grant increased safeguards for land installment contracts buyers, mitigating the risk of exploitation and abuse. I urge a favorable report. Thank you.
Thank you very much, Senator Charles. Questions from the committee? All right, seeing none, that'll end the hearing. Oh. Yeah, that's gonna end his testimony. Then we have opposition panel, right? No. He's on 665. We're on 664. With that, that'll end the hearing for Senate Bill 664. We'll now move on to Senate Bill 665, Senator Charles.
And this is my last bill, and I got my good friend Bon Mitten up here who's going to come up, who was once against the bill, and then he became a good friend of the bill. So we're all good up here now. So, all right. So for the record, I'm Senator Nick Charles testifying in support of Senate Bill 665. This proposed modification will permit the boards and council of unit owners to make amendments to their community's declaration of covenants with a supermajority of 66 2/3 of unit owners, as opposed to the current requirement that 80% of unit owners of mortgagees must support any proposed amendment or change in their community's declaration. The current requirement under the real property statute of requiring 80% of unit owners and/or mortgagees to support any change is exhaustive. It presents an insurmountable barrier to enact reasonable change, particularly if and when there are lopsided benefits to maintaining the status quo for some unit owners at the expense of others, such as the definition of common elements and how a community's dues are calculated and enforced. The bill came to me after having several conversations with condominium owners who lived alone in their dwelling, yet were getting hit with water bills that were the same price as their neighbors with 5 tenants in that same building. The only way to change the provision that allowed the inequality in the distribution of fees was through an amendment to the Declaration of Covenants. In most communities, it is virtually impossible for 80% of the unit owners and mortgagees to agree on things, yet changes in evolution are inevitable and healthy for any community to thrive. In 2017, Section 11-104 of the Real Property Statute was similarly amended, and it amended for the same reasons to make it easier for the communities to amend their governing documents, such as their bylaws. It is imperative that a similar modification to Section 11-103 of the Real Property Statute be approved and applied so the amendments to a community's Declaration of Covenants can be approved with just a supermajority of 66 2/3 of votes from those unit owners and mortgagees. The changes being proposed to Section 11-103 focuses solely on the voting requirement for undivided percentage interest in the common elements as defined in the community's declarations, and leaves the other provisions in the current statutes as they are, without disruption to the 100% voting requirement for changes in such definitions as the boundaries of the units and liability for common expense. The changes would undoubtedly ensure the communities can continue to thrive without being impeded by unrealistic voting thresholds that are impossible to meet. This bill is a revised version from this bill in 2022 and considers the concerns raised by the banking and building industry regarding the new voting threshold being used to change an owner's stake in the property, as well as accounts for other exceptions that will pose significant interference to the property owner's rights. We have workshopped this bill with all necessary stakeholders, Bob Enton, and he's here at the table, and have come to a compromise that works for everyone. I urge a favorable report, and we'll be done after this. Bob, come on up to the front.
Mr. Chairman, members of the committee, Robert Enton on behalf of the Maryland Building Industry Association and the Maryland Bankers Association. Me too.
Brilliant testimony, Mr. Enton. All right. All right. Questions from the committee? Thank you all. Thank you both very much.
Thank you.
All right. That'll end the hearing for Senate Bill 665. We'll move on to our final bill of the day. Vice Chair Wallstreicher with Senate Bill 538. Yeah.
Thank you, Mr. Chairman. I appreciate everyone's patience. And whoever would like to be on the first panel, I'll let you. Thank you, Mr. Chairman. Members of the committee, Senate Bill 538 removes arbitrary government-imposed restrictions on non-economic damages. But that's not really what the bill does, because the phrase non-economic damages is not a particularly useful one. It's just a legal jargon. It's a euphemism for a very human issue. What are non-economic damages to real people, the constituents we were sent here to represent? The best place to start is actually in the fiscal note. So if you pull out the fiscal note at the bottom of page 1, non-economic damages are defined in more human terms. Non-economic damages is pain. When someone is willfully or negligently injured by a bad actor, they often suffer terrible pain. I want you to think about the worst pain you've ever experienced, the feelings you felt, the way your body reacted, the thoughts that raced through your head. Pain can reach levels you never thought possible. Pain can be unbearable. Non-economic damages is pain. Non-economic damages is suffering. When someone is willfully or negligently injured by a bad actor, they often suffer terribly. How is suffering different from pain? Because suffering is longitudinal. Suffering is pain over days, months, years. Suffering is exhaustion. Suffering is the inability to get any relief, to function during the day, to sleep during the night. Suffering eats away slowly at your soul. Non-economic damages is suffering. Non-economic damages is disfigurement. When someone is willfully or negligently injured by a bad actor, they are often disfigured. Imagine losing a hand or an arm or a leg. Imagine burns or scars across your body. Imagine losing a portion of your face. Imagine looking at yourself in the mirror and not recognizing the person looking back at you. Imagine being embarrassed to simply leave your house. Disfigurement isn't just about loss of function. Disfigurement is about the loss of self. It's about the loss of dignity. Non-economic damages is disfigurement. Non-economic damages is loss of consortium. And here's another legal euphemism. Loss of consortium is just a fancy way of saying loss of sexual function. When someone is willfully or negligently injured by a bad actor, they are often injured in a way that eliminates their ability to be intimate. Think about how that might impact someone's life, how it might impact someone's perception of meaning in a relationship, how it would impact the sacred bonds of marriage. Non-economic damages is loss of consortium. And so you have two sides of the ledger. On one side is economic damages, your medical bills, maybe lost wages. On the other side is the pain you feel, the suffering you endure, the disfigurement you see each and every day, the loss of marital intimacy. And ask yourself which side of the ledger is more important to you. And if it's the latter, I think everyone here, it's the latter, ask yourself why that side of the ledger is where full recovery is disallowed by arbitrary government-imposed limits. SB 538 fixes this. It simply allows our constituents to recover on the more important side of the ledger. Now, I'm trying to anticipate what you might be thinking at this point. And what I think you're thinking is that as a policymaker, the moral case for this bill is strong, but you still have to balance that against other policy interests. And you're right. You need to balance the victim's rights against things like the cost of malpractice insurance for doctors. Except this bill does not impact medical malpractice at all. Suits related to doctors, hospitals, nurses, and health facilities fall under a totally different section of code where the caps remain. They fall under Title III, Section 2A. This section, the section we're talking about today, 11108, does not apply to medical malpractice. You need to balance victims' rights against things like the cost to your local jurisdictions. Well, you're also right to do that balancing. Except this bill does not repeal the Maryland Tort Claims Act or the Local Government Tort Claims Act. Those sections of code are untouched by the bill. And so we exclude medical malpractice and we exclude the state and we exclude the local jurisdictions. What about other types of insurance like car insurance or homeowners insurance or business insurance? And that's where you're going to hear some of the opposition today. That nobody will be able to drive a car because insurers will leave the state. Nobody will be able to own a home because homeowner insurers will leave the state. And that nobody will be able to open a business because insurers won't cover business risk. And that's where I want you to look at the map that we're going to see later today. I don't know if the committee manager has time to pull it up, but we have a map that shows which states have the same caps that Maryland do. There are only 10 of them. Is it easy enough? Thank you to the committee manager. So I just want you to look at this map. Maryland is one of only 10 states where the government arbitrarily imposes limits on the important side of the ledger, the human side of the ledger. The 40 white states on this map, including all of our neighbor states, conservative states and liberal states, they all have cars and they all have homes and they all have businesses. Pain, suffering, disfigurement, loss of sexual function, When a bad actor willfully or negligently victimizes our constituents, let's let our constituents know we're standing up for them. I ask for a favorable report.
Mr. Chairman, members of the committee, my name is George Tolley. I'm here on behalf of my law firm, Dugan, Babbage, Tolley and Kohler in Baltimore County in Timonium, District 42. And I'm here on behalf of my family in Millersville and Anne Arundel County. I'm here on behalf of my friends and neighbors and everyone who wants justice in Maryland courts but can't be here today to testify in favor and in support of Senator Wallstreicher's bill, Senate Bill 538. That map that you saw, those 10 states, how did we end up being one of those 10? And the answer is in the 1980s, there was what we now understand to be a very predictable and cyclical change in insurance profits. And the industry came to state legislatures like Maryland, and a small handful of them passed laws that at the request of the insurance industry to limit the rights of their own citizens and members of their own populations to get justice in court in order to make it easier for the insurance industry to recover from this cyclical downturn in their profits. Unfortunately, the laws that were enacted back then were permanent, even though the insurance industry cycle goes back and forth, and they've certainly been plenty profitable since 1986. We now understand, although it was poorly understood in the 80s, that these things are cyclical and these things don't cause all of the insurance companies in a state to flee. What the repeal of 11108 would do is not affect doctors or local and state governments, as the senator mentioned. It would, in all other kinds of personal injury cases, allow juries in individual cases, based on the individual facts and circumstances, to determine the damages, and under the watchful eye of a judge, as you'll hear, decide how much compensation is appropriate for an individual plaintiff who has suffered either deliberate or negligently wrongful conduct. We ask that you return a favorable report. Thank you very much for your time.
Good afternoon or good evening, Mr. Chairman, members of the committee. My name is Chris Figueres. I'm with the Maryland Association for Justice. I'm a Marylander. I'm a wife. I'm a mother. I'm a daughter. And I wanted to stand up here and talk to you about damages, but I could not do it as eloquently as Mr. Vice Chair. So I want to just highlight a few points regarding the damages. One about this bill is remembering, as Mr. Vice Chair was talking about, it is those damages in your civil case that a jury has determined are appropriate to compensate you for the injury that you're living with. That is what's capped under this statute. These are the injury, the part of your injury that you live with. These are, some of the things he mentioned, burn scars, disfigurements, all of the things that Mr. Vice Chair mentioned. These are injuries that have happened to people through no fault of their own. These caps affect people that have been involved in a catastrophic event through no fault of their own. And as Mr. Tolley mentioned, there was a task force convened in 1985, and their report came out in the end of 1985. And some of the things that you'll hear, if you'll see in that report, and you'll hear probably mentioned later tonight, this task force led to this arbitrary cap. And some of the things that were mentioned in there, for example, there was no guarantee that it was going to even lead to more availability and affordability. The task force said that. Also, the task force talked about in their findings section that there's a common belief that these non-economic awards are overly generous and can be fabricated. These were the findings of a task force. This was a 23-member panel where only one person represented claimants. You will get to hear from victims today and hear about them, and that is the focus of the public policy and this bill, and we urge a favorable report. Thank you.
Good afternoon.
Mr. Chairman, members of the committee, I know it's been a really short day today, so I thank you so much for your attention. My name is Gwen Marie Davis, and I am here on behalf of my law firm, on behalf of my family, and of course, on behalf of the Maryland Association for Justice, as I'm the president-elect. I ask that you would have a favorable vote on behalf of Senate Bill 538. You see, I've heard a lot about caps, but a cap on non-economic damages is unfair and unjust because it's arbitrary. Verdicts should be based upon facts and circumstances in each individual case, not based on an arbitrary number chosen by the legislator. Juries and trial judges hear evidence at trial in each case. Well, on relatively rare occasions, a jury verdict may be too high. Well, if that happens, then the trial judge has the authority under Maryland law to reduce the verdict. The judge has heard the same evidence and makes his or her decision based on that evidence, not based upon the arbitrary number chosen by the legislators. So the plaintiff can, if that occurs in a remitter, agree to the judge's number, or else the case can be tried again in front of a new jury. Well, that final verdict is always based upon facts and evidence. So you see there are multiple safeguards. So the idea is that juries do not have to have a verdict or unanimous verdict. Remitters have been developed centuries ago by the courts to limit the impact of runaway juries. Thank you.
My name is Kurt Schmoke, and I'm happy to be here. We all know each other. But for the record, Billy Murphy, I represent plaintiffs. I've also represented defendants. I know how both sides think. I know from brutal experience the devastating impact that caps can have. I'm currently handling a brain injury case, and in brain injury cases, it is common for people to have completely different personalities for the rest of their life after traumatic brain injury. It is common for people to have extensive memory loss. It is common for people to have different emotional triggers that makes their life miserable. It is common for them to have a life of pain. And it is also common for them to have a life of suffering. There are cases out here, and we call them catastrophic injury cases, where the cap is in no way related to the extensive amount of suffering that people face for the rest of their lives in these kinds of cases. And putting aside the costs of care, these people are going to require, because the injury is permanent, a lifetime of suffering and relief from suffering. They're going to have a lifetime of changes in every relationship they've had with close friends and other human beings on the planet, who now see them in a totally different light. And that's vice versa, because when you've got brain damage, you don't see them in the same light that you have to, that you formerly saw them. Last but not least, there's no good reason not to do this. None. It's easy to change. All we have to do is repeal the bill, and then people will become fairly compensated for their pain and suffering in the state of Maryland for the first time in 40-some years. And so please write this wrong. It wasn't supposed to happen in the first place. It's supposed to be a medical malpractice cap, but then you heard the absolute nonsense that supported extending the cap. Please don't do it. Please don't let it last a moment longer. And thank you so much for listening to me.
Excellent. Thank you very much. Question from Senator McKay.
Forget, I think it was you, sir, who may have said, can you explain to me more a little bit under the direction of a judge what that means?
Yes, I can. So what Ms. Davis was explaining is the process called remittitor. So under Maryland law, if a jury comes back with a verdict that the judge believes under the same facts and evidence and circumstances that the jury heard is excessively large, the judge has had authority. Judges in Maryland and all over the country have had authority for over centuries really, to reduce unilaterally the size of the verdict to something that the judge feels is more appropriate and in line with the evidence. And at that point, then the plaintiff in the case has a choice: either take that number or try the case again in front of a new jury and see what happens. And it goes both ways. Sometimes the plaintiff will think they can do just as well in front of the second jury, and sometimes they're not right, and sometimes they are. And then the second verdict can be remitted and so on. But the system itself has developed this safeguard, this sort of exhaust valve that deals with the fact that sometimes a jury can get carried away and include too much money, whatever that might be under the facts and circumstances of an individual case. And so the trial judge is sometimes referred to in the case law as the 13th juror. And that's their role. And it is a role that in Maryland is very much honored and respected. It doesn't happen very often because in Maryland, as you may hear from other witnesses, juries don't tend to run away very frequently.
That's, I guess I'm going to channel my inner Senator James and ask, is there data?
Not good data that I'm aware of.
Can I get my hands on any kind of a data? If you find some.
The challenges there are twofold. First of all, there's no good repository for all the verdict information in the state and how much money is awarded by every jury. But then the second thing is that a lot of times, because there is a cap, cases will end up settling for far less than the fair value because the fair value is impossible. And those cases that settle, we don't have any data about that. Very frequently, those settlements are confidential. What we heard in the House last week from both sides, from our side and the other side, is that without a cap, even more cases would probably settle because of the unknown about what would the jury do unrestrained by the arbitrary limitations of a cap. And that, when both sides are talking and you come to a reasonable amount that both sides can agree to, even if they're not happy about it, that's usually better and serves the purposes of the civil justice system.
Thank you.
Thank you.
I'm not sure if it was you. Obviously, I was wrong thinking it was you that said that. But it was made by someone in this panel that said that while capped, these damages, while capped, isn't still justice. Could somebody expand upon whether it be capped or not be capped, why that isn't justice? To me, justice is being found in the jury determining if there was a fault, not necessarily with the cap. Maybe I heard it completely wrong.
Yeah. So we're.
It's a good thing I haven't started since like.
Can I make sure I understand your question? Because I think I do, but part of me thinks that I don't.
Hence why I'm doing the question. I don't know either. So let me phrase it a different way. Regardless of being capped or not, when there are damages due, if it's being capped, is that still justice?
No, it's not.
Okay.
Because the cap is arbitrary. The cap isn't based on the case that's in front of the court. The cap is something that applies to every case, whether it's fair or not. And so if a jury has found pain and suffering of up here and the cap is here, all of this legitimate pain and suffering compensation is going to be lost.
Okay.
And that's not fair at all.
Okay.
And it's arbitrary because a statute can't look at the case and say, wow, cap of this size, that's not fair, and automatically inform the parties. No, it's going to be there fair or unfair. And we want to stop that from happening. Juries are in the best position after hearing both sides of the evidence to make that judgment instead of some arbitrary number being in their way. And this is especially true in catastrophic injury cases.
Okay. All right. Thank you. Appreciate it.
Thank you, Mr. Chair. It's been a long day and it's great to see some good friends sitting on the panel. Since my fellow senator just picked on Billy Murphy, why don't I pick on another member of the panel? You. Yes.
All right. Senator West, good to see you again.
Nice to see you. So we've talked a lot about non-economic damages, but that's not the only element of the damages that a jury awards. So first of all, there are economic damages and there's no cap on the economic damages, correct?
That's absolutely true.
And they would include all of the losses experienced by the litigant, including medical expenses, most importantly, lost income and lost earning capacity, as well as other expenses.
I would gently push back on that
Okay.
because I don't believe it's true. While it is true that economic damages include the medical expenses and include the lost wages and earnings that an individual might have suffered and can prove in court, it doesn't compensate or it doesn't include all of the losses, because I think, as the vice chair explained, the non-economic damages side of the jury's verdict is to compensate a plaintiff for all of the things they've lost that make life worth living in the first place.
Yeah, I understand. But I was referring to lost income and lost future earning capacity.
Yeah,
So if
those
the-
monetary things that we can calculate.
If the plaintiff can prove that because of the injury, the plaintiff can no longer do what the plaintiff has been doing and earning a nice income, then the plaintiff can also recover the income that he would have earned or she would have earned for the rest of his or her earning life.
Assuming the evidence proves all of that.
Yes.
I agree with you.
Okay. And also, there's no limit in Maryland, is there, on punitive damages?
Well, that's a difficult question to answer. I think there are constitutional due process limits on punitive
sure.
damages when they are available.
But when they're available,
In
there's no
personal injury
limit.
cases, overwhelmingly, they're not available because of the standard that we have in Maryland. And this is a completely different issue, but the standard we have in Maryland on punitive damages in personal injury cases is among, or if not the most limiting in the country. And that's not me talking, that's a work group panel that the House put together back in 2017.
About half of the other states do limit punitive damages, don't they?
I don't know the answer to that question. That's a different issue and a different bill. This is a non-economic damages bill.
I understand, but
I don't
unlike
know what
many
other
other
states do.
states, Maryland does not place any limits on the amount of the punitive damages unless they're, what's the word?
Well, unless there's a constitutional limit,
Yes.
right? I mean, there's a case, as I'm sure you're aware of, where somebody had bought a BMW that was supposed to be new and it had been refurbished or repainted or something. And for $3 in actual damages, they got $3 million in punitive damages. And the United States Supreme Court said that was too much, that that there has to be a relationship. So there are limits on punitive damages. I don't think that whether there's a cap or not is a different issue.
Gotcha. All right, it didn't escape me that the four people on this panel are all plaintiffs' lawyers. So let's talk about how this bill would affect plaintiffs' lawyers. It is true, is it not, that if the case goes to trial, the plaintiff, it's not unusual for a plaintiff's lawyer to get 40% of the recovery?
I think that is unusual. I think in most premises liability, automobile accident cases, the going rate, as I understand it, I don't do that kind of work, but the going rate is more like a third, even when the cases go to trial.
Okay.
The market sets those rates. Obviously, there are some lawyers who charge less and there's some lawyers who charge more, and I won't quibble with that about that with you. In more complicated matters like medical malpractice, I think the going rate is closer to the 40% you cited, but this
Right.
isn't a malpractice
Well,
issue.
let's take the third as an example. So let's assume that a case goes to trial these days and it's not a nuclear verdict, which is over $10 million. Let's assume it's a $10 million verdict at the end of the day. Under our current system in Maryland, I think it's $935,000 is the current limit on compensatory damages.
That sounds about right. Yes.
Okay, and it goes up by 15,000 a year, but currently it's $935,000.
Uh,
So if it's a third, the amount that the trial lawyer is going to receive will be in the range of $315,000, something like that. A third
of the non-economic, assuming the jury found that that much it was appropriate in the case, and I'm assuming all of that is part of your question.
Okay, yeah, so the premise is a $10 million verdict, but because of the cap in Maryland, the trial lawyer is going to receive $313,000, right?
If the cap applies as you've described, I'm not gonna-
33%.
I assume the math is correct.
Right. So if this bill's passed and the cap is removed with that $10 million verdict, the actual amount the attorney will receive in that case is $3,333,000. Correct?
Assuming that the attorney actually doesn't cut the fee, or, I mean, there are other things that can happen, but yes, I agree with you that that's the math.
Okay, and then my last question is, I am informed that using state-specific data, the National Association of Insurance Commissioners found that premium rates are lower in states that regulate the amount of non-economic damages. Are you familiar with that study? Do you agree?
I'm not familiar with the study. That's not consistent with the studies I am familiar with. I don't know to what extent that study was limited to the 10 states that have caps like 11,108 as opposed to medical malpractice caps. I'm also familiar with the rhetoric from the Tort Reform Association that caps don't have an effect on liability insurance costs, and they've never been claimed to have an effect on liability insurance costs, nor has there ever been to my knowledge, a demonstrated cause and effect relationship between the two things.
Interesting. So in my earlier hypothetical, where we have a $10 million verdict, and today the amount of money that goes to the plaintiff's lawyers is $313,000. But if this bill were passed, the lawyers would receive $3,300,000. You don't think that might have an effect on insurance premiums here in Maryland?
I don't, and I can explain why if you let me. So first of all, for automobile insurance, property insurance, homeowners insurance, the insurance company sets its own sort of contractual cap by the amount of insurance they're willing to write, and the limits of liability, say in a automobile insurance policy of 100,000, 300,000, those are the limits. The insurance company isn't exposed. That I think is why you don't see State Farm, Allstate, or any of those folks lined up to testify against this bill, because this bill doesn't affect them or their day-to-day business. Even if they're writing an umbrella policy, they get to set the umbrella policy and charge what the market will bear. And so I disagree strongly that auto liability costs or homeowners liability costs or even commercial liability costs would increase on policies of less than $1 million, because as you pointed out, the cap already is $935,000.
Well, if I were running a business and I was concerned that there might be a $10 million verdict, which would stand up because there's no cap, would I not be likely to want more insurance than I currently get, and therefore would have to pay much higher premiums than I'm currently paying?
That's one thing that you could do. So the purpose of this tort law that we've been talking about, and that you've been talking about since maybe the second bill that you heard, the tort law is not just to compensate the victims of wrongful conduct, negligent, or unreasonably unsafe conduct. It's also to deter such conduct. So you can, if you're a business and you fear exposure to liability, you can buy more insurance, or you can revisit your internal controls and your training and the way you keep your business, the way you maintain your equipment and so forth to reduce the risk of an injury in the first place. And the way insurance is priced, as I understand it, there are benefits to that, that if you're a customer and you buy insurance and you go a long time without a claim, your rates are lower. So letting the tort system do what the tort system's designed to do, I think is, yes, you could buy more insurance and that would increase your cost because you're buying more insurance, not because the rates internally have gone up. But if you're buying more insurance because you're not running a safe shop, then there's another way to deal with that.
Thank you, Mr. Tully. I
Thank you.
always enjoy our conversations.
Thank you, Senator.
Can I add something? What you also get when you get insurance is risk reduction, because that's what insurance companies do. They want to make sure that you are running your business in a way that you don't have to make claims. And that's in their self-interest. And that's one of the great benefits of insurance. And insurance also spreads the risk. And so insurance is cheaper than having to pay this money out of the pocket of the business person. And so even if the insurance rates go up, they're a bargain because that risk has been spread enormously. And so you're paying a fraction of what it actually costs to insure the risk. So you got to take that into account too. And one last thing. Children, what are you going to do about that? When they have brain damage, when they're permanently injured, when they suffer for the rest of their lives, shouldn't they be compensated for that? Shouldn't that be a part of what our heart tells us to do? Our sense of fairness tells us what to do. And so it's not as simple, Chris, as you're making it. And you got to look out for the injured parties, especially when you're dealing with poor people, because they're not going to get lost wages. They're not going to get the other kinds of damages because they're not making enough money to get it under our existing laws. And so they're getting a fraction of their pain and suffering. That's not fair.
Thank you. Briefly, thank you for touching on the idea of deterrence and future behavior, because that was actually my initial question. I was going to ask whether or not you could point to instances in your own practice where that had that effect outside of justice for the victim. And you can certainly respond, but you've already touched on it. I think that what I'd like to know is how the current caps on non-economic damages negatively impact vulnerable people, poor people, and those that may not have the greatest economic damages, how it affects that population. If we got rid of the caps, do you think that it will result in a more fair system, not just for the individual plaintiff, but for society as a whole?
So we have folks coming up to answer that second question. I don't want to take their thunder or extend the length of this hearing any longer than it needs to be. So I'm going to defer the answer to that second question to the next group of folks. As to the first question, I think we did touch on it with the deterrence issue, giving you specific examples. I mean, it does happen. In fact, there's a rule of evidence that says that when a business takes remedial measures to prevent an accident from happening again, that's actually not evidence that you can use in court to prove that they were negligent in the first place, because the whole tort system is set up to encourage that kind of behavior. And I think the deterrence side of it is the other side of that coin. I'm happy to give you examples if you want offline, but at this point, I'm mindful of your time. It's been
Consideration of the committee. I'll ask for offline, but I also finally, you all touched on a lot with Senator West, the idea of the insurance premiums. The Chamber of Commerce and others are, this is going to put people out of business. But what they specifically focus on is the small business. And so my understanding is that in other states where this is, can you speak to whether or not it's had this devastating effect?
Yeah, and I believe that the evidence is quite to the contrary. So Maryland was one of a small number of states in the 1980s that adopted a law like this. Our court said it was constitutional, but not every state court has done so. And in states like Florida, where the cap, like 11108, was declared unconstitutional way back, the bill before you says we're going to eliminate the cap, but we're not going to do it till October 1st. In a case where a court declares it unconstitutional, the next day the cap is gone. And you would think that would have a catastrophic effect on the stability of insurance markets, but it never really happened. In Florida or elsewhere, there's no evidence at all that you will hear from the other side or anywhere else that says when these caps were declared unconstitutional, insurance became somehow unaffordable or the markets became unstable or any of those consequences actually happened. What the whole argument about, insurance crisis and insurance being so expensive, the arguments in the 80s and the arguments that I'm sure members of this committee who've been here for a long time have heard about, crises and we need to do this and that and the other thing because insurance is so expensive and reinsurance is so expensive. That doesn't hold in 40 states where 85% of the United States population actually live. They don't have an 11108 and they have stable markets. So repealing the cap, there's as Mr. Murphy put it better than I could, there's no reason not to do this.
Thank you, Mr. Chairman. I apologize for being out of the room for the beginning of it. So if I do ask a question that's been asked and you all are going to address it later, or one of my colleagues can chime in and say that they've asked that and we'll get that information. It's a small world because when I was in law school, this was my senior thesis, was to actually put a cap on non-economic damages. Because at the time in the mid-80s, the other option Maryland was seriously considering, for example, was no fault insurance for automobile accidents. And the plaintiffs bar at the time didn't want that to happen. So this was sort of the result of it. So I'm rusty on my research. I'm going to go home and try to find my 35-page paper. I know I was before a committee. I know they shot it down immediately and then they turned around and passed a different bill, which was the same one. But I do have a question. I believe in Maryland, medical malpractice cases are dealt with differently. I'm sure you touched on this, right? Yes. And did you speak to why that's the case?
Yes.
And
the
okay.
complaint of the insurance industry that doctors' premiums were going to go up, complaints about from the doctors that their premiums were going to go up, and the fear, all of which turned out to be unrealized because it's unrealizable, was that we would lose doctors, et cetera, et cetera. So
and I think in particular, pediatricians were quite alarmed because of their exposure, and we need pediatricians, especially in the rural communities. So I take it this bill does not address medical malpractice, which, just to be honest with you, the fact that we put that separately because we don't want to lose doctors or hospitals or we're worried about it, it does kind of indicate that we have some worry about how this impacts insurance and business and the like. But I think you indicated that there are very few states that still have the cap. Right. I think
because that was the map that
right.
Senator Wallstrecker put up.
I think what not now, but get back to me. But remember that Maryland is a state that does not have comparative negligence. So in some of the states where you have comparative negligence and the fault can be sort of assessed, you could have a larger damage award, but in the sense that you would look at one particular plaintiff as having contributed some to his demise or makes a difference. So you have to understand you're not always comparing apples to oranges. I mean, apples to apples in states. So you might want to address that. The last thing I have, and if you dealt with it, I'll try to catch up from one of my colleagues, but what I think one of the concerns about non-economic damages is no standard by which to judge what a person's pain and suffering is. So, with economic damages, you can look to, the value of lost wages or other aspects that you can at least have a range on. So I'm curious about what you think should be looked at in pain and suffering cases, because I think it's so incredibly subjective. And in a way, I don't know if you can even put a dollar value on pain and suffering. It is it's what the law allows, right? The world, this is the best we can do as our judicial system is to go in and try to help somebody who's been harmed, but it is so wildly subjective, and it could depend on the sympathy of the jury, the sympathetic nature of the plaintiff or not, the quality of the lawyering or not, then the jury pool, what they're familiar with and what they're not. So, I mean, it has a lot of very difficult subjective aspects to it. That I think that is part of a reason to have some certainty in the system. So if you want to make a few comments back,
Just very
that's
briefly,
fine.
because
Mhm.
there's a lot in that, but
Yeah.
I would very briefly say that all across the country, juries hear personal injury cases in all the states that were painted red and all the states that were still white, the ones with the cap and without the cap. Jurors from all walks of life are brought in together. They hear the evidence in an individual case and they decide unanimously how much the non-economic damages, how much the pain and suffering is worth in terms of balancing the scales, which is what jurors are instructed to do. And they do it all the time under as I said before, under the watchful supervision of a trial judge who hears the same evidence. They do it all the time because there's nothing really magical or mystical or mysterious about it. It's common sense. And jurors are also instructed to use their common sense. Jurors are very frequently drawn from the same community. So if the injured person is from Harford County, the jurors are typically going to be in a circuit court for Harford County, drawn from the same community. They're going to know what it's like around here and what it's like to live in this community and to live in this community with the injuries that this person is going to have in a catastrophic case for the rest of their life. And together, bringing all of their experience and their personal beliefs together, they unanimously do it. And it's one of the beautiful things about the justice
Let me give you an
system.
example. So let's say I'm injured in Baltimore City, and just for whatever reason, that jury, would give me $10 million. But for some reason, my same facts, but in Harford County, and we could look at it over time, data, they get a fraction of that. Is that justice? I mean, at least between those two jurisdictions in economic damages, we'll get the same thing. But when you have non-economic damages and you're culturally or societally, however you want to say it, there's wide discrepancy. I don't know how you turn to a plaintiff in Harford County and say, hey, too bad you weren't injured in Baltimore City. Could have gotten 10 times the amount, because that's what the juries do in Baltimore City. Well, what do you say to that?
So Mr. Murphy wants to respond to that now.
First of all, we've got to accept as fact that the amount of pain and suffering is going to vary from case to case.
The cases are identical is my hypothetical, sir.
That's kind of hard for me to work with, because look, I've been doing this for 50 some years and I haven't seen two cases that are anywhere close to being identical.
Well, I've practiced for 35 and I've seen ones that are very, very, very similar.
Okay, so our experiences are different. Now, going back to the basic premise, you can't force the system arbitrarily to come up with a limit on something that you can't possibly limit until you hear about it. And so that happens to be the variable caused by us being human. And there's no way to make that a certainty. And look, some of us wish that it were, but it would have to be a fair certainty, but it would take into account almost an infinity of factors. And so you got to leave it up to the people who hear the actual evidence, because they're in the best position to do it. And the jury system is what separates us from every country in the world. And we don't want to lose the ability of the people from the very county from which this person resides to look at the entire case and come up with an informed judgment. And yes, there's going to be variation. It's impossible to eliminate because of human nature. And so going back to the real question then is, what is a fair way to cap something that you don't even know about until you hear all of the evidence? So case A may perfectly well justify lifelong pain and suffering worth millions of dollars. case B may not justify that at all.
I understand difference in cases. I'm talking about cases that
And
are
so-
very, very similar, which I've dealt with
And how
numerous times.
how do you make that uniform except by coming up with an arbitrary cap that's going to create a tremendous amount of unfairness?
I appreciate your opinion on
No,
that.
no,
I
and I'll
appreciate
just finish up with, you
Sure.
know, when we rely on jurors to make these choices, as Mr. Murphy points out, and the jurors hear the evidence in the individual case, and we do that because it's better than having the governor or the county executive decide every case or decide how much the damages are worth. You know, we could have a dictatorship, but we don't. We have a democracy. And while there may be things you could point to, say, well, in that jurisdiction, it's maybe not as fair as that jurisdiction, or I would rather live in that jurisdiction. You know, there's some written testimony from a woman who was in an apartment building in the chairman's district that exploded a couple of years ago. And she suffered horrible burn injuries all over her body. And if she lived a quarter of a mile south of Silver Spring, she'd been in the District of Columbia where there's no cap, right? In that difference, there's a huge difference between what the law allows her to recover. It's a completely unfair difference, I submit to you, because in one jurisdiction it's capped and a quarter of a mile down the road, there's no cap at all. The fact that there's those differences isn't a reason to choose arbitrariness. I submit it's better to use the system that allows the jurors to decide on their own under the supervision of a judge.
Well, I don't want to debate this, but I think there's an arbitrariness even in trying to put a dollar figure on pain and suffering, to be honest with you, because it's, so I'll just leave it right there. The last thing I would say, and again, if you covered this or you're going to give us information following up the hearing, that's fine too. I'd like to get any kind of data that shows that there have been, you know, egregious cases that you know, a significant number or whatever the data is about how people were not through our whole system between, you know, the economic damages and all the elements there, whether there's punitive damages, any other thing. And then on top of it, non-economic, where there, what's the issue that you're trying to address here? What cases do you feel are just not getting enough money?
And I think some of that you're going to hear from the panels that are coming up.
Very good. Thank you all very much.
You might want to start with quadriplegia, a lifetime of suffering. And it would be hard for anybody in this room to say that that was worth under $1 million.
You know what? I don't know what it's worth, honestly. That's what we're struggling with. It's hard to say what that would be worth.
But here's what you do know, that if we're going to fairly compensate people from their pain and suffering, it's going to have to be a tremendous amount of money to compensate somebody.
If I were a quadriplegic, I don't think you could give me $100 million and you're never going to put me in a position where I feel like I've been satisfied or that I got justice.
Oh, we agree.
Okay?
We agree.
So, I mean, in that sense, this is a flawed system and money is not going to solve it.
Then I think there's a meeting of the minds there. I hope.
Different solutions, but.
All right. Seeing no further questions for the panel, thank you all very much.
Thank you.
Thank you.
We're scrambling a little bit. Sorry about that. I'm going to go off script a little bit too. Well, first, let me introduce myself. Good afternoon, everyone. My name is Laura Zoyce, and I'm a partner at the law firm of Miller and Zoyce located in Baltimore City. I live and work in Baltimore City. I've been a civil trial lawyer for 29 years. One thing I think we can all agree on is that there's no possible more horrible human suffering than the death of a child. And to Senator West's point earlier about economic damages, typically the things that grieving parents are left with is simply the non-economic damages cap. That's it. That's all they have. There are no economic damages typically for their grief. That's it. As civil lawyers, our hands are tied on what we can do for compensation for people. We can't put people in jail. We can't force people to do criminal background checks on their drivers. We can't force them to have safety standards for the people that are driving their corporate vehicles. The only thing we can do is hold the bad actors accountable financially. That's all civil trial lawyers can do. And to Senator James's point, it is difficult to come up with what that number is. It's not easy, but that's what we task civil juries with every single day with every single civil trial that we have. The juries are given instructions. They're pretty lengthy. They give them guidance on how they come up with the number. One of the things that the jury is told is that they cannot rely on sympathy. They shall not consider sympathy in the number, and they have to fully but fairly compensate the grieving parents or whoever the injured victim is for the harms that were caused. One thing I find incredibly offensive about the cap is that many things, but the jury's misled. The jury isn't told about the cap. They take the time in individual cases to hear from the mom, hear from the dad, hear from the experts, hear from the defendants. They come up with a number based on this case. And the arbitrary cap is, it's what it is, it's arbitrary. For those reasons, I would ask for a favorable report.
Good afternoon, Mr. Chairman and members of the committee. My name is Patrice Meredith Clark, and while I am a trial lawyer and a member of the Maryland Association for Justice, I'm here to talk today about myself and my family. I want to tell you a personal story that really illustrates, I think, the way that Maryland's non-economic damages cap harms Maryland citizens while helping foreign corporations. On May 4th, 2019, a two-person helicopter crashed into the Chesapeake Bay, killing two 36-year-old men, both of whom had young children. The passenger, Matthew Clark, was my brother-in-law. Matt died, leaving my sister-in-law to care for my niece, who had just turned 5, and my two nephews, who were 8 and 11 at the time. My family hired an attorney to investigate the crash, and eventually we learned that the engine that was installed on the helicopter had a defect. The engine was manufactured in Pennsylvania by a Pennsylvania company called Avco, which is the parent company of Lycoming. And even though the crash occurred in Maryland, the engine was designed and manufactured by a Pennsylvania company in Pennsylvania. Suit was filed in Pennsylvania federal court, and it is still pending. But I tell you this story because Lycoming is arguing in that case that Maryland's non-economic damages cap should limit the recovery of Matt's widow and his 3 children for the pain and the suffering and trauma caused by his death. Why is Avco or Lycoming arguing that? Because Pennsylvania doesn't have a cap. So a Pennsylvania corporation that manufactured a defective engine in Pennsylvania, in a Pennsylvania case, wants to limit the damages of Maryland citizens. We should not have a law that harms Maryland citizens and helps foreign corporations. And there's no cap in Pennsylvania. And I just want to address Senator McKay's question about fairness really quickly, if I may, Mr. Chairman. Very briefly, I want to point out the pilot had 1 child and 1 child on the way, but he had 2 wrongful death beneficiaries. My brother-in-law had 3 children. Maryland's non-economic damages cap is that you get, it doesn't apply to each beneficiary. There is 1 cap for the entirety. So in a wrongful death case, you get 1.5 times the $935,000, whether you have 4 wrongful death beneficiaries or 5 wrongful death beneficiaries or 10 wrongful death beneficiaries. And that's not fairness. Thank you. Thank you, Mr. Chairman.
Thanks. Good evening. My name is Ron Richardson. I'm a resident of Harford County and a civil lawyer for over 36 years. And I'm here obviously in support of Senate Bill 538. But I only want to focus on a case that I'm handling. It involves a young lady. She's now 16, but when she was 6 months old, she was scalded badly to the point that her skin looks like an alligator. She does not want to go outside. She's very paranoid. She wants to commit suicide. Her life has been destroyed and she's young. I mean, she's going to go through this for the rest of her life. Ergo, the injustice of the cap, because it's the same across the board. It does not take into consideration the facts of each unique case. And I would submit that in this particular case, it would be inappropriate to apply the cap.
And I think the safeguards that Ms. Davis talked about, where a jury's verdict, if considered to be excessive, can be moved to be remitted, and the court, who have also heard the same facts and evidence, can decide on that. We have in place what can address the concerns that are arguably were supposed to be addressed by the cap. And so I submit that the cap is not necessary, and it works in injustice in cases such as the one that I've just told you about. With that having been said, I thank you for your time.
Thank you. Good afternoon. My name is Debbie Potter. I've been a trial attorney for 35 years. A lottery ticket is when you get paid for being lucky. A verdict is when you get paid for what's been taken from you. And there's a reason why the expression exists. When you have your health, you have everything. So let me tell you a story. A lifelong Maryland resident is on his way home with his buddy. A distracted driver crosses the double yellow line, hits him head on. Bad crash, turns to his buddy, "You okay?" "Yeah, I think I'm okay. I'm going to get out." His seatbelt stuck. Trying to get out. His seatbelt's just stuck. There's a fire coming through the floorboard where the gas pedal is. And the fire starts and it starts and it starts until brave citizens cut the seatbelt and pull him out. And as a result, he's burned over 80% of his body. He loses his leg. He loses his right arm. His half of his face is melted off by the fire because he kept his left side out of the window to avoid the flames coming through the truck. A jury of this state awarded him $15 million in pain and suffering for being burned alive. The jury spent their time coming up with that money off the factors the judge instructed them. The jury walks out of the room and the judge slashes it down to the cap. My client's like, "Wait, who said my pain and suffering is only worth the cap?" I'm like, the Maryland General Assembly did. They decided your case was only worth that much. The jury is not told there's a cap. Why are we wasting our citizens' time back there, not even telling them that the cap exists? The cap is not one size fits all. It has to go away. Trust your fellow Maryland citizens to come up with the right number in every case for the cap. I'd like to address the drunk driver kills a stay-at-home mom. Senator, you asked this question. The drunk driver kills a stay-at-home mom. There's no medical bill. She's dead on the scene. There's no lost wages. She was a stay-at-home mom. The only thing she has is non-economic, the family has is non-economic damages. And I know you've addressed, well, insurance rates to go up. Every time I stand before the jury and say it's a car crash case, they think, oh, I'm the bad person. Insurance rates are going to go up. State Farm's revenue last year was $89 billion, but yet I'm the bad person.
Thank you very much.
The cap does not fit all.
Thank you.
Mr. Chairman, members of the committee, my name is Mike Winkleman. I live and practice law in Prince George's County. I urge favorable vote on this bill. The cap disproportionately harms those most grievously injured. The cap applies to very, very few cases in the state of Maryland. And that's one of the unfairnesses of the cap, is that the worse you are hurt, the more the cap hurts you. So for almost every case that all of us will ever deal with, the cap has nothing to do with it. But the persons that are hurt the most are the only ones that are injured by the cap. Senator McKay, to expand upon what was said before, why the cap is not justice. I'll give you an example of a client I had, a 23-year-old woman, just graduated from college, single mom, lived in Prince George's County, horrible accident, almost lost her arm. The doctors at Shock Trauma amazingly saved her arm. 12 subsequent surgeries were able to save her arm, but she'll never use it again for her life. Why is that not justice that she only gets the cap, which at the time was $800,000? She lost no income. It doesn't affect her ability to work. She had to pay back every medical expense from the verdict. Every medical expense has to be repaid. So the only compensation that comes to her is a portion of whatever recovery there is for pain and suffering. And as a 23-year-old woman, she has a 60-year or 50 to 60-year life expectancy of having no use of her arm. That's the example of why it is not compensation or fair compensation. You asked about statistics. DC keeps statistics. of all jury verdicts, they have no caps. There's been one verdict reported on DC website since 2019 where a case was in excess of the cap. Prince George's County has had 2 a year for the last 3 years and only 1 instance of punitive damages. Thank you, Mr. Chairman.
Excellent. Thank you very much. Questions from the committee? Senator James.
Can you, would you share that information because I'm very interested in how many cases, that you can come up with that exceed if there had been a cap? Because I take it in DC, the case that didn't have a cap. Is that what you just said? That
DC does not have a cap.
Right.
But they keep track of their verdicts.
Right. Right.
Probably not perfectly,
I
but
know.
in a way.
Right.
That's easy for us to supply. It's literally on the DC court website. And there's also a Maryland judge who not perfectly keeps track of jury verdicts in Anne Arundel and Prince George's County for the last number of years. Also available.
And I love doing
online.
research as a lawyer, but we just don't have a lot of time. So anything you can do to give us information is a big help, right?
Senator, we will do that.
Thank you.
Yeah, absolutely. Before I sit down, David Herrick texted me. He's in the waiting room. So if somebody could let him in, that would make my life much easier. Thank you, Mr. Chairman.
Thank you for that. We'll do that. All right. Do you want to do let's do the in-person, finish up the in-person panel first, and then we'll invite our guests who are attending virtually.
These are amazing.
Senator West, did you have a question for this panel, or do you want to wait till the next? Okay.
May I proceed? Okay, all right. Thank you so much. Mr. Chairman, Mr. Vice Chairman, ladies and gentlemen of the committee, thank you for your time today. My name is Kelly Donahue. I'm a Queen Anne's County resident. I'm a lawyer, and I'm here on behalf of myself, my family, and frankly, on behalf of all women, and children, grandparents, and persons of color, and even you white guys too. But you're going to know why I led in with that in just a second. So I want to talk about peer-reviewed data. I want to talk about facts, and I want to talk about data. And here's what the data says. The data from Buffalo University, the data from Washington University School of Law, the data from the University of Baltimore, the facts stated on the United States Senate floor, the facts stated by the United States House Judiciary Committee. Caps on non-economic damages discriminate against women, children, elderly, and persons of color. Period. End of story. That's what the data says. So at the end of the day, the only question that we need to ask ourselves is, what is the principle of the Maryland General Assembly? Is the principle of the Maryland General Assembly to remain laws in place that discriminate against constituents of this state? Or is the principle of the Maryland General Assembly to make the laws equal for all people? And when I drove into Annapolis today, I saw this amazing mural of Ruth Bader Ginsburg and Thurgood Marshall. And above that beautiful mural, it says equal justice under the law. And that's what those Supreme Court's giants, that's what they stood for. That's what this state stands for. That's what this General Assembly stands for. It's equal justice for all people under the law. And the facts show that caps discriminate against very specific populations of people. So at the end of the day, when we put aside all of the other boogeyman stories that you're going to hear in the opposition, that the sky's going to fall and insurance rates are going to go up. And by the way, none of that is true. And I'm happy to explain why if I have enough time. But at the end of the day, the only question you need to ask yourself is, do you believe in equal justice for all people? And if you do, then please give a favorable vote on this bill. Thank you.
Good evening, Mr. Chair, members of the committee. My name is Bruce Plaxon. I'm Vice President of the American Association for Justice. I was a practice here in Maryland for over 40 years, but I see cases from all around the country, and I have colleagues in every state. And I woke up this morning to an email from a friend who just finished a 2-week trial of a gas and oil explosion in Colorado, where a young man in his 20s had a leg blown off and lost his penis. And he just finished the trial, and there was gross negligence. And my immediate thought was, how horrific. With a prosthetic leg and a return to work, that case is worth $935,000 in Maryland. $935,000 for the loss of his leg and his penis. And what you'll hear from the other side is no one will say that's fair. They wouldn't have the nerve to tell you that's fair. What they'll tell you is, with no facts or data to support it, apocalyptic predictions of the sky falling. And that's untrue because from the map that the Senator Wallstreicher showed you, 40 other states manage just fine. We have the worst tort system in America. We have no dram shop. We have contributory negligence. We have all types of safeguards to keep away from runaway verdicts. And as you point out, we have contributory negligence. So that case that you gave with the example where other cases, those people in Maryland get nothing. All right. Instead, they'll waive a flimsy 1985 report that was written during the Cold War on a typewriter when you had to go in the kitchen to answer your phone because it was on a wall. Okay? That's the data they're going to bring to you today. All right? There is nothing in that report that is accurate, including their allegations that the secondary market will fall because Lloyd's of London in the report now 40 years later says they are the leading insurer in North America, including a robust secondary market. There will be no effect in Maryland if you abolish this cap.
I've got a question about the legislative history, but which I'll delve into, but I want to make sure that the members have an opportunity to ask questions. Well, let's just finish with the in-person panel, but Senator West, then Senator Fulton, and then I've got a question as well.
Thank you, Mr. Chair. And I know it's late, so I'm going to be quick. I noticed that.
Is this for me or
Bruce, how about with you? So I noticed that in the 7 additional witnesses that we've seen since the first panel, once again, all are plaintiffs' lawyers. None of you disagree with the hypothetical I went through originally that currently, if it's a $10 million verdict, you, if you were the lawyer in the case, would receive $313,000. But if we repeal this cap, you as the lawyer in the $10 million case would receive $3,333,000.
Yeah, I totally disagree.
You disagree? Okay.
Yeah, and let me explain why. So yes, we work on a contingency. The reason we work on a contingency is because Maryland residents would not be able to access the court system if we don't work on a contingency. They can't afford it. And so what that means is that every time I try a case, I have money out the door to get my client to trial. And if I lose, I don't get that money back and I don't get paid. And it doesn't matter if I've worked on the case for 5 years. So yes, I get paid on a contingency, and the higher the case comes in at verdict or settlement, the more money I make. That is on paper. But I disagree with what you have asked because that's not what happens in practice. In practice, what happens, and I do this on a daily and a regular basis, and my business partner hated me for it, I cut my fee all the time. There are times that I take a 10% fee. There are times that I take no fee. I ask for my expenses back. I had a client who he died in the middle of our auto tort litigation. It wasn't a big case, but his parents needed to bury him and pay for a funeral. Funerals and burials are expensive, man. I had no idea. I took no fee so that his parents could make sure that he was buried in the ground and he had a beautiful passage of life. So I drive a minivan. There are chicken nuggets under the seat. I have friends that practice law in Pennsylvania and in DC. They're also moms. There are no caps in those states. They're driving the same minivan with the chicken nuggets under the seat.
Right.
So the reality is we can talk about big numbers, just like we can talk about the boogeyman story that's in the 1985 report, but that is not really what happens in the real world.
Okay, thank you for your answer. Bruce, how about you for my second and last question? So I'm looking at the testimony of the Maryland Department of Transportation, and here's what they say. They say, unlike other state agencies, the Maryland Transit Administration's tort liability is governed by the Transportation Article, not the Maryland Tort Claims Act. The Transportation Article does not include a limit on liability. Current law provides a cap on non-economic damages, which provides plaintiffs with significant levels of recovery and protects MTA from unlimited exposure to non-economic damages. Removal of the non-economic damages cap will likely lead to significantly greater awards and settlements against MTA and could result in a lack of predictability in litigating and settling MTA cases. Senate Bill 538 may also affect MTA's access to excess insurance or deductible amounts. Do you disagree with what they say?
Yeah, I mean, the 40 states, I mean, Maryland's the only state between Maine and Florida with a cap on non-economic damages, and they have transit systems, they have buses, they have subways, they have airports. They manage to have an economy that doesn't fail. That was a lot of could-haves and should-haves and maybes. As Mr. Tolley pointed out earlier, states that did away with the cap where overnight the court said this cap is unconstitutional. The next day, there was no reports of massive runaway verdicts or difficulty providing normal state functions. I don't see that happening.
Okay, thank you very much.
Ms. Donna. So I think you kind of answered, I had one question about the fees, so I think you kind of answered that one. I wanted to ask you about, you made a specific comment about that the caps are discriminatory. So can you explain that to me, why you felt that?
Sure. So, and let me be clear, it's just not my feeling. It's the published data that's been published across the country, and in multiple peer-reviewed publications. But, and what the published data has repeatedly and consistently said is that non-economic damage caps discriminate against women, children, and persons of color. And let me give you one example as to why. So I'm a mom of 3 kids, right? And I was really lucky when my first daughter was born. I stayed home for a while and I got to take care of my daughter, but I'm not paid for that. But I would venture to say that my work staying at home and any other stay-at-home mom's work is probably a little bit harder than maybe when dad leaves and goes to the office. You know, three small children running around your living room is tough. And there's a lot of work that goes into that. And I don't think any one of us would say that the work of a homemaker isn't of extreme value, but they don't get an economic payment for that. So let's say that a stay-at-home mom is in a car accident and her leg is amputated, just like Debbie's client. A man is a white CEO and he's driving to work and he's in a car accident and his same leg is amputated. Well, he goes to trial and a jury says, I'm going to give you $2 million for lost wages and I'm going to give you $2 million for pain and suffering damages to the white CEO. Well, the stay-at-home mom who works just as hard and is bringing just as much value to the table, it's just she's in an uncompensated job. She goes to trial and a jury can't award her wages, but a jury says, we're going to give you $4 million because you're never going to be able to play Legos on the floor with your daughter again. You're never going to be able to stand and push the swing on the playground. You're never going to be able to get in, on the diving board and make sure that your daughter can jump off safely to do her first cannonball. So we're giving you $4 million. Well, guess what? The white CEO, he gets to collect his $2 million in his wages and he gets to collect whatever the cap will allow him to collect for his pain and suffering. But the mom who has the same exact injury and the same exact total award, she only gets to collect under today's law in Maryland, $900,000. That's why the cap's discriminatory. Okay. The cap is also discriminatory because the truth of the matter is if you take a wages paid to white men and you take wages paid to white women doing the same exact job, we women, unfortunately, we're still being paid less. So, baked in discrimination over decades and decades and decades still exists in a wage calculation. So even when we want to talk about, wages, women's awards are always going to come in less, and that's why.
No, I appreciate the
Thank you.
follow-up. Thank you.
Thank you, Mr. Chairman. Following up a little bit on Senator West's questions about legal fees. I don't know where I read this, but I think I saw somewhere there was it's either used or has been suggested so that when you get into non-cap situations that legal fees, contingency fees are also capped. I really appreciate the witness who indicated that often you do not, pursue, I guess, the industry standards around 1/3, but I've seen it up as high as 40%, as Senator West has indicated. I think the proposal I'd seen in one case was really depending on it, I'm going to use arbitrary numbers. So the first $1 million, you would get the normal contingency. Then from $1 million to 10 million, it begins to go down a little bit and so on and so forth. Have you heard of those proposals? Have you read about that? And the reason I'm even asking is I think that what we want to do is try to protect our citizens, but not incentivize lawsuits, which just the mere threat of, I'm going to sue you and I'm going to ask for $100 million in non-economic damages would scare anybody, including myself, to bits. So, we're trying to come up with getting money for victims, but not incentivizing abusive litigation, because you now have no, cap, and you can claim, and you see it all the time. I'm going to, claims that they're going to sue you for $1 million, a ridiculous amount of money. Any thoughts on that?
Yeah, I have lots of thoughts on that, and you and I should
All
probably.
right, well, I mean,
I know.
you know
So
what I mean.
I'd
I'm
love
giving you an
to,
opening, but don't take them.
because you had so many wonderful questions, and I really appreciate all of your thoughtfulness. I think it's.
I am thinking it
At
through. I
6
really
o'clock
am.
in the
I
evening, I
know.
am really impressed with your thoughtfulness, and I'm grateful for it.
Thank you.
So maybe we can connect later, but to try to answer the 10 questions that were posed there in about 10 seconds or less. Number one, there really isn't in the real world of civil litigation, I will threaten you with a lawsuit and therefore get paid. And the reason for that is because I could threaten a lawsuit, and let's say even there was no cap and I threatened some fictitious lawsuit of $100 million. I still have all of the same evidentiary requirements to be able to get to a jury that exist even today with a cap. And those are pretty big hurdles. I need to be able to prove my case by preponderance of the evidence. I still have to have experts to be able to prove each element of my case. There's a reason we have all those gatekeepers in place. So if you truly have a frivolous case, you're never getting to a jury for a jury to do anything to
I've been
you.
litigating a long time too, so I just trust me when I tell you that I want to hear what you have to say, but maybe I already know that part. But what I'm saying is I've been in the real world too. And I can tell you that when litigation is threatened or even brought, I do a lot of defense work. I know what we talk about in the back room. Okay. What we talk about is if it's a very high demand, right? Even if the evidence is weak, that potential exposure, we have to advise our clients to seriously consider settling. Okay, so it is just a reality, but I'm trying to just get to the idea of whether or not it makes any sense to put some brakes on the potential abuse of excessive attorney's fees, in contrast to trying to get fair money for victims. That's all. Just that
I think as a
philosophical question.
fundamental matter, I don't think there's such a thing as excessive attorney's fees for us plaintiffs.
Fair.
So, for the reasons I've explained, I may work on a case for 5 years and I've done it all for free and I funded the litigation. My defense attorneys who sit opposite me, they're being paid by the hour. And even if I go to trial and I win, they still get all of the money that they've been paid as they've gone along. So I don't think there's factual foundation to the idea that plaintiffs' lawyers are
That's
overpaid.
fair. Okay.
In addition to that, I disagree with the idea of a sliding scale of any kind, because we don't do sliding scales on defense lawyers. We're not going to say to the attorneys that are representing drivers at State Farm or that are representing big business, well, sorry, you can't have two partners on this case, or we'll pay you $350 an hour, but once you hit 100 hours, we're only going to pay you $275. I don't think the General Assembly is going to say that to them. We don't tell a plastic surgeon, how much he can charge to do, breast implants. I don't think it's the General Assembly's place to tell one industry what they are allowed to collect as a fee. I think that's a contract between the business professional and their client.
You don't like the idea. Just throwing it out there. Thank you very much for your answer.
Yep.
I'll pass.
But then the actual implementation of the statute in '86, just give us some more of that history, because I think it's good context for the discussion.
Yeah, so I was surprised when this hearing was held in on the other side in the judiciary, when the opponents came up and said and pointed to the committee and said, this has already been decided. Your committee passed this bill in 1986. It was actually 1986 based on a 1985 report. This bill, this cap was never discussed in any committee in Maryland. And I'll explain what that means. In 1986, in reaction to what we later learned was bogus or overstated medical malpractice crisis, a bill was introduced to cap medical damages only. Medical malpractice cases only, not medical damages. It was a medical malpractice bill to cap medical malpractice verdicts only. And it passed out of the House and the Senate in slightly different forms. It was never debated or amended on the floor. In conference committee, it was amended to include the cap that we're talking about today, other torts. And on Sinai Die, this portion of the code was passed. So this body never debated the debate we're having today on whether the person that I'm talking about, or Debbie Potter's client, or Dave Harrick's going to come up behind me and tell you one of the saddest stories I've ever heard in my life, or Laura Zoy's talking about the death of a child. If any of those people were ever supposed to be capped, it was a Sinai Die conference committee that decided that. So the legislative history is that there was an alleged crisis in the medical malpractice community, and then the bill was expanded to include these torts, and that was a sin, that was a wrong created in 1986 that really ought to be fixed, because the people that we're talking about and the way it's been expanded was never meant by this body. It was never debated in this committee or judiciary. That's the real legislative history. And Senator West, there's no way to get punitive damages in any of these cases. I mean, you need an intentional act in Maryland. Gross negligence is not enough to get punitive damages. So none of the cases we talked about would punitives ever come into play. Thank you.
Yes.
Did you have another?
No, I didn't. I mean, I thank you for that. I didn't know. I mean, we were just talking to the vice chair. We didn't know that history. So thank you. All right, we have one more witness joining us virtually for this same panel. So David, you're up. Can you hear us, Mr. Rock? You're up. If you can, we can take you off mute and you're ready to go. Hold on one second. You're still on mute. There you go.
Can you hear me?
We can.
So let me address the punitive damage issue pretty quickly. This committee has heard from Monica and Doug Murphy about the tragic loss of their son when Monica saw her son be run over by a commercial van being driven by a crackhead who had just watched a friend of his overdose. And in those circumstances, no actual malice could be proven. So this concept that you can get punitive damages is completely not the case in Maryland. It's a throwaway talking point. I'm here on behalf of the Murphys to tell you the rest of the story now that you've heard how the criminal system failed them, the civil system failed them. When I put together a massive demand in this case and explained all the facts of what happened to their son that Monica watched die and whose brother watched die, and sent them to the insurance company called me back and said, because the adjuster I talked to was in New Jersey who doesn't have caps. And she said, I can't believe that Maryland has caps on damage. I thought you were a progressive blue state, because we have a $5 million policy here and your clients deserve every single penny of that policy. But I'm really sorry, I can't give it to you, because our shareholders would never allow us to give money to somebody that is more than the law would allow them to get. So here we have a horrible case. We have a company that was actually responsible enough to purchase $5 million in coverage, who themselves felt horrible about what the Murphys lost, who themselves wanted the Murphys to be compensated with their insurance. And their insurance, of course, isn't going to pay something the law doesn't allow. So you have the loss of a child. And it ended up being that the Murphys ended up with about $50 a day. Now, would anyone doubt in a million years that they wouldn't write a check for $50 a day to have their son back? That's the injustice we're talking about here. These are real people's lives, not a spreadsheet.
All right. Thank you very much. Questions from the committee? All right. Seeing none, thank you all very much. Thanks.
Thank you so much.
All right. Is anyone else here to testify on behalf as a proponent of this bill that I have not called yet? Okay, so that will conclude the testimony for the proponents of the bill. We'll now go on to the opposition panel. Mr. Enton, Mr. Collins, Carrie Silverman, and then I saw, is Bryson, there, Mr. Popham, there you go. Come on up. Mr. Campion, there you are.
Good evening, Mr. Chairman, members of the committee. Thank you for the opportunity to testify today and for your patience on this long night. My name is Carrie Silverman. I'm a Maryland resident and attorney, and I'm here on behalf of the American Tort Reform Association to express our concerns with SB 538. Now, as part of my practice for ATRA, I follow trends in civil litigation, and what we've seen in recent years around the country, not here, is a rise in the size and the frequency of what some call nuclear verdicts. These are verdicts at the levels of 10 million, 20 million, 50, $80 million or more. And while you might think that those verdicts at that crazy level are punitive damages, what we found is they are wholly compensatory damages, usually mostly non-economic damages at that. And those cases, they involve awful, horrible, tragic injuries and deaths. There's no doubt about it. But no amount of money can compensate for the loss of a loved one or living for the rest of your life with a horrific injury. But when you see the word compensatory before that verdict, a compensatory verdict at levels that are more money than most people would earn in several lifetimes, there is a problem with that system. And why does that happen? We've heard a lot about how caps are arbitrary, and they inherently, setting a maximum amount has an inherently arbitrary aspect to it. But you know what else is also arbitrary? When one plaintiff, one case gets a $20 million verdict, another gets a 5, another gets a 50. And that's what we're seeing in states without caps. How do the juries get to those numbers? Well, they rely on another arbitrary number. They usually rely on the amount that the plaintiff's lawyer asks them to award in the case. And there have been studies upon studies that say that so-called anchor influences the jury and has them return often the amount of money that's requested. Well, I would be happy to answer more questions about what other states are doing or how this impacts Maryland residents, and I'll wait for your questions on that. Thank you for your time.
Thank you, Mr. Chairman, Mr. Vice Chairman, members of the committee. I'm Carville Collins. I'm an attorney representing Maryland Employers for Civil Justice Reform. We're comprised of many of the largest employers, businesses, and healthcare providers in Maryland. We're here in opposition to this bill for the reason that caps on non-economic damages have been a vitally important public policy in Maryland for more than 37 years. In 1985, a severe crisis in availability and affordability of liability insurance occurred in Maryland. The response, as this General Assembly has done for decades, is to convene a study, a task force. That task force has been mocked here today, and we respectfully disagree. That task force was chaired by a former chairman of this committee, Joe Curran. That task force was comprised of the leading experts in this state, and their findings, which correct the unfounded assertions made today by the plaintiffs, include the following. First, the current availability and affordability crisis in certain lines of liability insurance is not a manufactured crisis, as some have charged. The civil justice system can no longer afford unlimited awards for pain and suffering. A second finding, a cap on allowable pain and suffering awards will help reduce the incidence of unrealistically high liability awards, yet at the same time protect the right of the injured party to recover the full amount of economic loss, including all lost wages and medical expenses. So contrary to the proponent's testimony here today, it wasn't arbitrary. The task force made a very specific recommendation. And contrary to the story you were told about the legislative history, that recommendation turned into a piece of legislation that was considered by this committee and your counterpart across the street, and it turned into the enactment that became the cure. It became the solution to a crisis. And so, Mr. Chairman, if I may, just to conclude with this, in light of this well-studied foundation for the current caps on non-economic damages, I ask this committee to consider why ever would the General Assembly want to risk inviting back an insurance crisis by removing these caps? That is not the best public policy choice we submit. Thank you. Thank you.
Long day. Thank you, Mr. Chairman, members of the committee. Robert Etton on behalf of the American Property Casualty Insurance Association. Our members write 60% of the insurance in the state of Maryland. That means basically that 60% of your constituents are insured by our members, and we are strongly opposed to this legislation. You know, what I find to be very, very interesting is that the not one other group other than the Maryland Association for Justice has come forward to support this bill. Not one. No consumer group. No one. No one. And by lifting the cap, the example that Senator West gave is a tremendous factor in what we're hearing today. You have $1 million cap. And the reason you have a cap is because it's so difficult, if not impossible, through any type of objective means whatsoever, to quantify what is the appropriate measure of damages. There is no cap on economic damages. Why? Because you can quantify that. But you're going to leave it up to the emotion. You're going to leave it up to my capable friends, the plaintiffs' bar, and wonderful lawyers that they are. You're going to leave it up to 12 citizens who are going to sit there for, I don't know, a week, 2 weeks, whatever it is. And they're the ones that are going to decide. So ask yourself, what will removal of the cap do to insurance rates? Do you think for 1 second that insurance rates in the state of Maryland will not go up if this cap is extinguished? It's obvious that rates will go up. You don't have to take my word for it. Take the word of your own state agency, the Maryland Department of Transportation. They know what's going to happen. So for those reasons, we are very, very strongly opposed to this legislation. Thank you.
Good evening, Mr. Chairman, members of the committee. Bryson Popham on behalf of the Maryland Association of Mutual Insurance Companies, appearing in respectful opposition to this legislation. Let me begin by offering my commendation to the Vice Chair for his articulate and passionate presentation of the bill. And I was impressed by that. It was a long time ago, but I remember your passion, Mr. Vice Chair, as well as those of the panels that preceded us. But I'm here to talk about something much more prosaic on behalf of my insurer clients, my small Maryland mutual insurer clients. In a word, it's reinsurance. And I can satisfy, I think, Senator James's desire for information by recommending that each of you look at my written testimony. There is attached to it an article from the New York Times from last year that describes the situation, the very difficult situation, insurance and liability situation in Florida. And a part of that at the end, there is a nice little précis on the subject of reinsurance. Why do we care about that? Because reinsurance is insurance that insurance companies must buy. And my clients are small insurance companies. It is extremely important to them. So when they saw the introduction of this bill, they were quite concerned, and they in turn began talking to their sources for reinsurance, and those conversations continue today. They've spoken to me, obviously, and that's why I'm here before you expressing their concern. I don't understand, honestly, why the proponents didn't come back and do what they've done many times in the past and seek to increase the cap. That would seem to me a more logical approach to take. But to completely eliminate it is hazardous, and that's as mildly as I can put it. It's extremely hazardous. Our clients write insurance throughout this state. They depend on reinsurance. and you depend on them. And for those reasons, we'd respectfully request an unfavorable report on Senate Bill 538. Thank you.
Thank you, Mr. Chairman, members of the committee. For the record, Lewis Campion with Maryland Motor Truck Association, representing roughly 1,000 motor carriers from around the state, 90% of which run 6 trucks or fewer. The American Transportation Research Institute studied in 2020 the impact of rising nuclear verdicts on the trucking industry. And over about a 15-year period, they looked at 600 cases. In the first 5 years, there were 26 cases over $1 million. In the last 5 years, there were 300 cases over $1 million. Verdicts over $10 million doubled that time. The average verdict against a trucking company in 2012 was $2.6 million. In 2019, it was over $17 million. The impacts on our industry are bankruptcy filings, businesses closing, unsustainable high insurance premiums. We've seen Nationwide and Zurich exit the truck insurance market entirely. Another outcome is staged fraudulent accidents. What are these? These are where cars intentionally collide with trucks or buses in the hopes of a large jury award or insurance settlement. In Louisiana, we've had 47 individuals federally indicted, causing 77 truck crashes. In 2022, we've had 23 defendants in a variety of states federally indicted with staged accidents. Removing the cap entirely will make Maryland a laboratory for similar incidents and expose us to unlimited liability. You've already heard from Senator West and earlier in comments from Mr. Enton about the conversations relative to the Mass Transit Administration, and that similar impact will occur with our industry as well. We urge an unfavorable report. Thank you, Mr. Chairman.
All right, questions from the committee. We got Senator James.
Thank you, Mr. Chairman. Earlier, I had talked to the other side, and I didn't want to inject myself personally, but I'm glad some of you have addressed the history in 1985-86 because I literally was there. I mean, I'm a law student, granted, and I'm working for a senator, and I'm given this report, and I have a file on it, and I remember that one thing I want to correct as an eyewitness was this was deeply discussed and debated. This was not some 11th hour throw in some language. There was a real problem. Thoughtful, scholarly people in the state of Maryland looked at this, deeply concerned for everybody's interest, the Marylanders' business and all of it. It was not some, I think it was very disparaging to put that on the record. Former Attorney General Kerr and many others were involved in this. So I just wanted to say, I'm glad there was someone else here. I wasn't going to put myself in it, but I witnessed it. So small world there. To be fair, though, to just make sure that I'd ask the other panel this, I've heard a lot that said, look, other states don't have caps. They don't have insurance rate issues or premium issues. So I'd like you all to get me some information because, here I'm hearing, conflicting information. Clearly, there must be data on this that you could, help us to eliminate this issue and tell us, what's really going on. And then I appreciate some, at least one of you testified that there's some studies out there about what I hadn't heard this phrase, nuclear verdicts, and that they are increasing. So, and you're from Ultra, I think you all look at that to some extent. So we'd like to get that kind of information. And then finally, I was very intrigued and I kind of agree with you. I don't know why we didn't first look at whether or not the escalator clause, which what is it in this? What is the current statute? Is 15,000? Can you all want to address whether that was always in the legislation when it got in that amount and whether you all, if we were to do anything, maybe we could look at that escalator, whether or not that is keeping up with just inflation and other things. Do you have any thoughts on that escalator and just a little bit of history about it? Thank you.
Yes, Senator. Thank you so much, Senator James. To your question and your comment about the legislative history, we respectfully agree with what you have suggested. This was not a sine die deal.
Yeah, that was
absolutely not. This was a study that went on for all of 1985, and the recommendation came forward to the 1986 General Assembly. And they specifically enacted a cap on non-economic damages. This was not an inadvertent last-minute addition on another bill having to do with medical malpractice. That is simply incorrect. And the actual text of the entire study is right here, and we'll demonstrate
It's
that.
in my red well at home somewhere, but it's probably buried in the third story attic. I remember reading.
Thank you, Mr. Chairman. We're happy to provide that. And then Senator James, in response to your question about the escalator on the cap. The caps were originally set at 350,000 at the time of 1986. And I respectfully disagree with the proponents of the bill who say, oh, it's just an arbitrary number. The number was set in exact accordance with that finding that I mentioned in my testimony, which was that we needed a cap on allowable pain and suffering awards to help reduce the incidence of unrealistically high liability awards. Yet at the same time, we needed to protect the right of the injured party to recover the full amount of loss. So that cap at that time was set at 350,000 back in 1986 as the best idea, the best decision that this General Assembly could make. And then in 1994, the cap was revisited and there was a thought to increase it. And that proposal came forward, and the 1994 General Assembly increased it to 500,000 from 350. And at that same time, they elected to add the escalator. And the escalator was 15,000 per year, which has now brought us up to 935,000 for the injured party. But I would also point out that there are multiples of that cap in wrongful death cases, and that cap for the maximum cap under those scenarios, including with two or more beneficiaries, is $2.337 million today. That's the full current cap in wrongful death cases on non-economic damages in those instances of multiple beneficiaries. So it may not have been the perfect number, but it was not an arbitrary number. It was the product of a long and careful study, which I believe this is how the General Assembly solves the most difficult problems that face the state. And a look at the roster of experts that were chaired by the former chairman of this committee will confirm that.
My point is very briefly.
And don't forget either anybody, remember just to address later, if it's really late, insurance rates, other states, this argument that other states don't have caps. Now, again, other states don't have contrib versus comparative, and comparative is very, very different. But, so we're not necessarily comparing apples to apples, but get back to us on a little bit on that, the rate of insurance too. Thank you.
We will, Senator. And I just want to say that, the bill you have before you today says no cap. No cap. Doesn't say, the $15,000 is inadequate. This is what inflation has done. This is what happened to costs. There's no cap. You're going to go from $1 million cap to no cap whatsoever. 5 million, 10 million, 100 million.
And as far as I can know, we didn't base it on any kind of study.
Right. So.
Sorry.
Thank you, Mr. Chair. So I can remember, I've been here this is my 10th session. And 8 of those sessions were during the Hogan administration. And during the Hogan administration, I can remember letters of information from state agencies with respect to legislation, which were the most namby-pamby things I've ever read. They seem to be incapable of expressing a strong opinion one way or the other. So when I saw the letter that was submitted on this bill from this Department of Transportation stating removal of the non-economic damages cap will likely lead to significantly greater awards and settlements against MTA, it was like a bucket of cold water thrown in my face. My reaction was, wow, I have never seen from a state agency in my time here a letter this vigorous in terms of expressing an opinion. But that leads to another question. So if we're going to have significantly greater awards and settlements against MTA, Mr. Carville, why don't you answer this? Is it not fair to also expect significantly greater awards and settlements against other small businesses across the state of Maryland?
The definitive answer to that question, Senator, is yes.
And if that happens, is it not an inevitable corollary that insurance rates paid by small businesses across this state are necessarily going to go up? Mr. Popham, do you want to answer that?
With your permission, Senator, I'll take that. And this also addresses Senator James's point. I want to be clear about one thing. That is one possible consequence. Rates go up, but also I talked about reinsurance.
Would you further explain that? I know what reinsurance is, but it's not an everyday concept.
Please read the New York Times article. I don't want to take the committee's time at this late hour. You have a nice summary there at the end of that to tell you what it is, but it's insurance for insurance companies. And there are a couple of phenomena at play here. One is an increase in rates. That's certainly possible. Another is a restriction in coverage. That's more possible. And kind of the worst case scenario, some reinsurers will look at Maryland and say, well, you used to have a stable, predictable liability environment. Now you have none because you've taken the cap off non-economic damages. We're not going to play in your sandbox anymore, and they don't have to. The one issue the one item I take issue with in that New York Times article is there's a comment from a person who said we ought to have states regulate reinsurance. States cannot regulate reinsurance. There is no authority in the Maryland Insurance Administration to regulate reinsurance. So please don't be deceived by that.
And the last point I want to make, which I hope you will, I suspect you'll agree with, but I'll find out in a second, is not only will insurance rates go up, but if I owned a small business and I found that there's no longer a cap, I wouldn't want to buy $1 million or $2 million of insurance on my business. I would want to vastly increase the insurance so as to be protected, so I wouldn't be put into bankruptcy in the case of a judgment. And that's going to cost me a lot more money too, is it not?
I think that's a reasonable assumption, Senator.
Thank you.
Thank you, Mr. Chair. So, Mr. Carville, maybe you can answer this question. And it's going to be, where have I gone wrong with my statement here? So with the other panel, I had asked a question because I had paraphrased of what I had heard them say, that caps don't equal justice. And so I looked up in the Cornell Education Law Legal Information Institute. It says, justice is a legal structure or system that is designed to judge in a general sense who should be accorded a benefit or burden when the law is applied to a person's factual circumstance. So according to a benefit, regardless of a cap or not, a benefit has been assessed. Now that assessed to some may not be fair, it may be wrong, but a benefit has been assessed. And so my question is, just in my mind, am I wrong that justice, a cap doesn't they said caps don't equal a justice? And I say that as two separate things. There's justice and then the amount of money that may or may not be able to be awarded. To say that, I think, is a mischaracterization. I could be wrong.
Senator, you're touching on essentially the heart of this matter. Is this the just result? And is this the right policy? The General Assembly decided they didn't need a map like what we've seen on the board here today with certain states in certain colors. The General Assembly decided, the Maryland General Assembly decided what's best for Maryland. And what they decided that was best for Maryland was, we're going to deal with this insurance crisis. It was an availability and affordability crisis. And we're going to set a policy. And over time, they realized, and that policy, that cap, should adjust over time. And it is the right decision for Maryland to first solve a crisis, hopefully prevent it forevermore, and to balance the interests. And is that justice? In every case, it's going to be different. And my friend Billy Murphy told this committee, every case is different, and he's absolutely right. But in general, a public policy that balances the interests of insurance costs as well as the right to recover and to fully recover for injuries, all of those considerations are expressly mentioned by the task force. They looked at this very carefully and they made the best decision that they could. And the decision has stayed current because of the increase in the cap and then the escalator in the cap. And so what they ended up doing is fashioned a solution to a crisis. And what we're suggesting is it's working, it's doing exactly what was intended, and there is no reason to change it. It'll continue to increase in those annual escalators. And yes, we have caps in other areas like for medical malpractice, and those cases are all different. Each case is different there too, but it does create justice because there is an allowance for pain and suffering. It's quite generous. If you compare us to other states with caps, their caps are much lower than ours. Not on all cases, but in most of those states, those caps are lower. I'm sorry, those caps are lower than in Maryland. So we have a generous cap as compared to other states. All of that information is set forth in the written testimony that the American Tort Reform Association and Mr. Silverman have provided to the committee.
Thank you, sir.
Further questions from the committee? All right, the night is late. Thank you all very
Thank
much.
you,
It's been a
Mr.
long
Chairman.
time. Thank you all very much. Thank you for hanging in there with us. With that, that'll end the hearing for Senate Bill 538 and the hearings for the day. Have a good weekend, everyone.